Just testing the audio. Can you hear me, Betsy?
Yes, I can. Good afternoon.
Good afternoon. I have a new device that I'm using to zoom in from, so I just didn't know if the audio was working. You're very kind to test it out with me before the meeting.
Oh, no, no problem. I'm using a different device as well.
Cool. Thank you.
So,
I'll leave you alone. I'm sure you're very busy getting ready.
oh, thank you. See
See
you
you
soon.
later.
What's up, guys?
Hey, Dave.
Morning.
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 Anybody know why you have bare pavement on one side of your car and literally 5 feet of snow on the other side and the
Yeah.
back?
I know across the street I could see grass through the snow, and then next door there's like 3 feet of snow blown up against the side of their house.
Actually, what's going on?
I am done. My back is killing me. I'm exhausted.
I haven't started yet.
Yeah, me neither. I was waiting till after this to go out and do it.
Me too. I actually thought, hey, let's let the wind just be done, you know?
That's
wind
my
is
plan with the leaves.
Wind is not going to take care of my snow. It is not.
Well, you,
It's going to take hours for me to dig out, hours and hours.
And
Kathy, for the first time ever, I think you've got the worst
yeah, they got the
version
worst,
of the
right?
storm.
No, we've got it almost every time. We always get snow out here. They did say we were getting the worst of the worst, and I was wondering what it meant by that because I got more snow last time than I did this time so far.
Chairman Lamar, I suggest you get an AI powered snowblower to just take care of it for you.
No, that's a really good suggestion.
Well, it'll all keep us underweight. That's it.
Speak for yourself.
So Senator Maroney and I went to an event this year where they're demoing a series of like AI based enhancements, like personal enhancements. One of them was like a lift assist. Another was like for folks who struggle with disability, like you attach them to your body and they help you go up the stairs. They make going up like large hills a lot easier for folks. And I'm thinking that is the next reasonable application is to help me shovel because I am done. I'm 50 years old. I should not be out there completely gassed by a snowstorm, but I was
How old are you?
almost 50.
Well, I'm 70 and I'll be out there shoveling. So you got 20 more years of shoveling. So you don't know what you're talking about.
Somebody told me that this is the whole reason you have children, but I've yet to reap the benefits of procreation.
Yeah, no, I'm not seeing that. We'll see this afternoon how I mean, I paved the whole pathway for them. All they have to do is keep it clean. Let's see if they do that. All right, it's noon. Betsy, you able to get us started?
Yep, we're here. We're recording. We are streaming to YouTube Live right now.
Wait, all of that was just on YouTube?
Makes us human.
Makes us human. Great. All right, so I'll kick this off. Good morning, everyone. Welcome to the public hearing for today, February 23rd. We have a number of bills on today's agenda that reflect proposals from the Department of Consumer Protection, from individual legislators, and from advocates who came before the committee with some thoughts and ideas about issues that we should consider for the upcoming year. Everyone's online today. The Capitol complex is closed. Through the joint rules established at the beginning of this session and the last few sessions, we are allowed to have a public hearing fully remotely. There are many advantages of that. There are some disadvantages too. So please, if you feel like you weren't heard fully or you didn't get full attention, reach out to each individual member if you would like to schedule additional time. We'll try to accommodate that as the session goes on. But in reality, your written testimony provides the most valuable tool for engagement as we move forward. That's the stuff we referred back to quite frequently. That's where we're able to get communications out to our members. It's what legislators review on the floor of the House and Senate when bills are under consideration. They don't have the ability to go back and timestamp their public testimony, whether it's in the Capitol or on the Zoom. That written testimony is the most valuable tool that people have. So with that, I'm going to turn it over to my Senate co-chair, Senator Maroney.
Thank you very much, Representative Lamar. And just to echo those sentiments, the written testimony is extremely valuable to us. So please make sure that you are submitting that, and that we will have other public hearings coming up covering some similar topics that may be covered today. So if you did not get in today, there is still the opportunity to address the committee, and always reach out via email. And then just thank you to our staff who switched this to completely remote, and for all the work they do supporting us throughout the session.
Excellent. Yes, thank you, Betsy, in particular, but also the team of assistant clerks who are helping her pull this together. Next up, my ranking member, Representative Rutigliano.
I appreciate it, Mr. Chairman. I thought you did an excellent job summarizing everybody's feelings about today. Other than the COVID flashbacks, I think we're ready to go.
There you go. That's right. Senator Cigarella isn't on yet, but we'll make sure to highlight him when he comes on. Senator Cigarella is the Senate ranking member. He's on multiple committees that are meeting at this time, so he'll be joining us throughout the day. With that, Madam Clerk, I think we're going to kick this thing off. First on our agenda, but not in the room, is Senator Duff. Second on our agenda is Senator Harding, neither of which are currently here. So we're going to move quickly right to Commissioner Caffarelli, I believe.
Just a minute, Mr. Chair, because I thought I saw Senator Harding for just a
Senator
second.
Harding just raised his hand. I apologize, Senator Harding. Senator Harding, we're going to go to you, and Commissioner Caffarelli will follow up right after. Senator Harding. Senator Harding, you able to jump on?
Senator Harding, if you would accept that invitation to be a panelist,
There he is.
then we can hear you. There we go. Thank you.
Perfect.
I apologize for the accommodations. It's in my basement making do with what we're dealing with weather. But thank you, Mr. Chair, and other chairs, Chairman Maroney, Chairman Lamar, Ranking Member Cigarella, Ranking Member Rutigliano, and the entire honorable membership of the General Law Committee. Thank you this afternoon for allowing me to speak. I'm looking to speak on what is one of the Senate Republicans' primary caucus proposals, which is Senate Bill 105. And Connecticut is one of the highest tax burden states in the country, third highest taxes, third highest electric rates, rather low in states that do business in, despite the fact that we're improving in some of those areas and doing great in many other ways. The regulatory environment, the tax environment, the affordability environment, particularly we have on small businesses, is becoming crippling here in the state. And we can and should do something about this on a bipartisan basis. Senate Bill 105 is one of those things that I think bipartisanship can work in working to remove some of the occupational license fees that hit the middle class small business owners across this state. These are occupational fees are everywhere from realtor fees, other registration fees, to teaching certificates, and other professions regulated by the Department of Consumer Protections. This will not impact their ability to regulate, but ultimately will remove those fees. And it isn't in consideration the amount of money that it would cost in our budget to find other efficiencies. Certainly, I think are an amount of money that we can take on as a state and provide a significant level of relief, though, individually to these small business owners. The bill is self-explanatory, so I'm happy to take any questions. But as I mentioned again, it's crippling for small businesses in this state. This is a huge first step towards helping those small business owners, those middle-class individuals that are paying these licensing fees.
Thank you, Senator Harding. I really appreciate your testimony. We chose to have this bill heard today, largely because we feel like there may be bipartisan support this year, certainly part of the governor's proposal. I do believe that you're right, and that we should do everything we can to make the burdens of running a business in Connecticut as easy as possible. There are some challenges, of course. Department of Consumer Protection needs to run programs and oversight and ensure that there's compliance with the rules and regulations, and they need, of course, resources to do that. But I do think it's time for us to be a little bit more creative. Sadly, we can't pass the budget out of the General Law Committee. but the leadership of this committee felt very strongly that this proposal should receive a public hearing, and that you in your caucus deserve credit for helping to push this issue for the last couple of years. So I want to say thank you, Senator Harding, for your leadership, and I feel like this is a bipartisan supported bill that hopefully we can get greater support for just outside of this committee. So I appreciate that.
Amen.
Are there any questions for Senator Harding? Representative Rutigliano, looks like you unmuted.
Yeah, I think Representative Ackert had a question.
Okay, Representative Ackert.
Thank you, Mr. Chair, and hope everybody can hear me. I've already done the snow plow, so I'm exhausted. But to the good senator, one of the areas that I looked at with this bill, many of us that have licenses and understand that the effort is to make it more affordable for businesses. An area that we may want to start thinking about is those that have to pay an apprenticeship registration. So these are the young folks, typically young folks, those may be transferring to another job that are paying a licensure fee, and they're essentially a apprenticeship registration, and they're not actually licensed making the larger dollars. Maybe to add on to this good legislation that you're proposing and others have proposed, that we look at that also. What are your thoughts on that?
I would fully support that, and Representative Ackert, I appreciate your work. I know all you've done for the trades, and how critical it is to your business, and how you've led. What is a citizen legislature, right? And occupations that also allow us to be legislators at the same time. And your work in electric work is a perfect example of areas in the trades where we're missing out. I'm sure I've heard stories from you, and I've heard from many others, whether it be plumbers, electricians, and other trade areas that they cannot find the workforce, and they're not getting that pipeline. And sometimes the apprenticeship programs are not operating in the manner that they should be, because there's individuals that want to work, they want to do these jobs, but they're just not given the opportunity for whatever reason. And so if there's an avenue here that we can remove some of these apprentice fees to help incentivize and help small business owners in the trades hire individuals on apprentice basis and get them started in these careers, I'd 100% be behind it.
Thank you, Senator, and I thank the good chair and this committee for raising this topic. It's good to have discussion on it. So again, thank you, Mr. Chair, and Senator, thank you for your time.
Thank you.
And your efforts.
Thank you. For folks who've signed in to speak, you're going to notice a number next to your name. That's the number that you are on the speaker order today. Please do not remove the number that you are assigned by the clerk. It makes things really complicated on the back end here. So if folks could not remove that number that is put in front of your name, that would be greatly appreciated. Next up, we have Representative Turco.
Thank you, Mr. Chairman, and thank you, Senator Harding, for this proposal. I think this is really great. Just curious, I see that included in here is eliminating the fees for speech and language pathologists, which sounds great, but I'm wondering why they were specifically identified, when I'm guessing there may be other type of therapy professions that aren't included, and wondering if we should consider including them as well.
Yeah, I would be open to that as well. I think this was written as a bill to try to find what most individuals would review as occupations that are either small businesses or middle class individuals that are paying burdensome fees, such as teaching as well. Obviously, providing a benefit to multi-billion or million-dollar businesses it's not going to have the hit that it would if we're driving this towards middle class individuals and working class individuals that find these fees to be unduly burdensome. So if we can extend that out to additional therapists, depending on what those fees are, I mean, we'd have to ask the commissioner, I think, what the fee structure is there, and how we could potentially reduce that. But I'd certainly be open to adding more professions to this. Absolutely.
Thank you so much, Senator Harding, and thank you, Mr. Chairman, for allowing me the question.
Thank you, Representative.
Any other questions for the Senate Minority Leader? Representative Rutigliano.
Yeah, it's just a quick, I guess more of a statement than a question. I really wanted to thank the committee. This has become a bipartisan issue. Fundamentally, I don't believe anybody should have to pay for their job, other than the cost to DCP to actually maintain the license and regulate in any way. Other than that, people should be able to work freely without a burdensome fee. So thank you very much for raising the bill.
Thank you. And with that, Senator Harding, thank you for joining us today. Hope you're
Thank you.
making it out okay, and that look, my back is killing me already. Senator Acker's complaining about his, so you got to get out. I know up there you guys deal with like 3 feet of snow like it's
no,
nothing.
I've been told it's like cement, so this is my next task is getting out there and shoveling out. So, but no, I do want to thank you, Mr. Chair, and the rest of the leadership team for working on a bipartisan basis on this bill. I think, as you said, this should be bipartisan, and I look forward to working on a bipartisan basis with your committee to make this possible.
Thank you. Hold in just a second. Senator Ciccarella popped in. He couldn't let you go shovel. He needed to jump in. Senator Ciccarella.
Thank you. Thank you. Sorry, having a little bit of issues connecting, so I apologize. Again, I just wanted to wish you good luck going to shovel. But prior to doing that, I just want to thank you. I know that we've been really trying to find ways to reduce the cost of living here in Connecticut and making it more affordable, and reducing these fees is a great idea. And I know that we have talked about this before. Senator Ryan Fazio brought this up. I just think it's a great idea, and I look forward to seeing how far we could stretch this, and what other professions we could make more affordable to get into these lines of work, especially the educators and speech therapists and other professions that are struggling here in Connecticut. So I wanted to thank you for that. And I don't want to get in trouble for not making some comments when the leader is on, so I want to make sure I got something in there.
Emergent
now you
times
can go
call for
shovel.
emergent circumstances, Senator Ciccarello. Do not worry about it. But thank you for your comments, and I also want to thank you for your leadership on this committee in making this possible. So thank you, Senator Ciccarello.
Thank you.
All right, Senator Harding, that concludes our questions. Thank you for your public
Thank you, Mr.
testimony
Chair.
today. Enjoy yourself and don't injure
Stay safe.
yourself.
Thank you.
All right, is Senator Duff available? It doesn't look like he's.
Senator Duff would like to go after the Department of Consumer Protection.
Okay, that sounds perfect because it is already what I promised the good commissioner. Commissioner Caffarelli, you're up.
Thank you, Mr. Chairman. Representative Lamar, Senator Maroney, Representative Ritigliano, Senator Ciccarella, and all the distinguished members of the General Law Committee. I do want to thank you for the opportunity to offer testimony today regarding several of our agency bills on the agenda related to consumer protection, liquor control, cannabis regulation, and licensing in Connecticut. Briefly, the liquor control changes include removing annual sales reporting requirements for out-of-state wineries, clarifying permit requirements for minors, prohibiting minors from having liquor permits, ensuring entertainment declarations on certain permits, and tightening age verification procedures. With regard to cannabis, the bill sets timeframes for the destruction of cannabis failings tests. It allows for the denial of registrations based on felony convictions for the ENDS, or vape permits as they're sometimes known. And it permits medical cannabis delivery by hybrids and dispensaries for qualifying patients. Under consumer protection and licensing reforms, it does a variety of things, including clarifying investigative authority between DCP and the Board of Accountancy, eliminating continuing education for interior designers, extending license renewal periods for engineers and surveyors, and requiring that real estate licensure exams be taken within 2 years of an application. It clarifies the definition of plumbing to include work on underground storage tanks on petroleum, addressing industry confusion, and codifying the regulatory practices over such installations. It also clarifies the contractor of record, background checks for homemaker agencies, and some technical corrections to the guarantee fund. I know we have worked hard to keep this to a limited proposal in a short session, and I think that these are concise bills, and I'm happy to take any questions that you may have on them.
Thank you, Commissioner. I do think it's always worth noting the remarkable breadth of your agency and what they're involved in that it's a concise proposal before this committee. It still encompasses a series of proposals that each of their own probably warrant in-depth conversation. I want to say thank you for coming and having your agency come to us early on in session, having our early leadership briefings, making sure we have a full breadth of understanding about the proposals that you've submitted. And you're right, it is far more limited than past proposals have been. Very concise. Really appreciate that. And the nature of a short session gives our members ample opportunity to review each of the proposals and gain relevant feedback. You will notice that there is opposition to some of these proposals if you have a chance to check out the public hearing testimony, either later today or the ones that have been submitted in a written basis. Our committee will be working through some of the concerns that folks highlight over the next few weeks. And as always, we've been able to rely on access to your agency attorneys and legislative staffers to help work through some of those concerns. So I don't have any questions for you right now. I know members of the committee do, but in your commitment to keeping your staff available to us as we proceed, being able to work through a lot of those concerns would be really grateful. All right. I think I saw Senator Maroney jump on. Senator Maroney first, then Representative Ritigliano.
Great. Thank you very much, Representative Lamar, and Commissioner, thank you very much for testifying. And just to echo Rep. Lamar's statement, it is amazing the variety of topics we cover within DCP and within this committee. Speaking, I guess, to one of the topics that we are hearing a lot of opposition to, I was wondering if you could just explain a little bit the thought around expanding the delivery, for the cannabis, as we did set up the delivery market as part, a delivery license as part of that. And so, what was the thought behind expanding or allowing for an expansion of that to other license categories?
Sure. Thanks, Mr. Chairman. That's Section 5 of Senate Bill 231. And first of all, the intent here is to benefit medical patients. We believe that it would be helpful to medical patients, but obviously this committee has to balance that against the interest of the delivery licensees. And so as always, as we are willing to work with, all interested parties and the committee, and in terms of your preferences to how to proceed. But the intention here was really to benefit and make it easier for access to medical patients.
Okay, great. Thank you very much, Commissioner. We look forward to working with you on that and other topics going forward.
Thank you.
Thank you, Senator Maroney. Representative Ritigliano, to be followed by Representative Luxembourg and then Representative Eckert.
Thank you, Mr. Chairman. Thank you, Commissioner. I just had a couple of questions about the out-of-state shipper registration, sales registration. Do you remember, if we could go over the history of why we have people register their sales that are coming into the state, not part of the three-tier system?
Are you talking about the reports that are collected regarding the out-of-state shippers?
Yes.
Okay. So this proposal doesn't have anything to do with them registering or not. It is really it's a requirement that licensees submit a report, an annual report, which we are proposing to eliminate that requirement. And so we do, as an agency, have the power to audit and request records if needed, but the reports currently are not collected or enforced. So really it was a burden that we didn't think necessary on the licensees. And, it's not anything the agency uses.
How are the reports forwarded to the agency? Is it simply just an Excel spreadsheet that each one of these people forward to your office and you put into a file on a computer, or is it something a little more formal and burdensome?
It is an Excel spreadsheet, I'm told.
So it just comes over and you guys store it away?
They could either email it, or I'm told it can be uploaded.
So, I mean, you don't have like a dedicated person that collects this information, it just sort of sits there.
Correct. There is no dedicated person.
All right, and that would become FOIable if somebody thought maybe there was something going on, or it would be available to the public if they request it, you know, as a, you know, sort of as evidence of something they might.
Yes. It's
So-
a public document. Yes, it is
We do
available.
away with you collecting a simple email, though, then how would those folks who may or may not have a problem have access to that information?
I don't think I'm sorry, Representative, following who has the problem.
No, I'm just saying, what if there was an industry member who thought there was something going on that shouldn't be going on? How would they know, A, who's in the business, and B, where the wine or booze is going? If you didn't collect the reports?
So, well, transporters also have to keep their own records, so it's available through that. But you know, I think that if there are concerns about illegal shipments into Connecticut, a requirement that a licensed shipper keep their records won't accomplish it. So, you know, I'm not sure if that's what you're speaking to, but happy to work
how much
with
of a
you.
burden it was to actually gather the information. Like, it was a big hurdle or a big bother. I was like, I would agree with you. But if it's simply just collating some Excel sheets into a file, I don't know. I didn't think it was that big of a deal. But
Oh, no, it's not a burden to us whatsoever. The proposal was to alleviate a burden on the shippers.
oh, so they don't have to report anymore.
Yeah.
Oh,
Because we don't use it. So, you know, that's why we just said, why make them do it if we don't use it?
no, I understand. I didn't know. I just didn't know if we had an issue or if anybody's ever hadn't filed a complaint, or I was just checking in.
No one's filed a complaint. I think it was in the spirit of trying to make things a little easier for licensees and businesses in Connecticut. It's one of the things where we came across and said, these reports aren't used. We have independent methods to get that information through audit and records requests, and the transporters have to keep their own records. So why make them compile these reports and send them to us if we don't use them? But if if the committee wants us to keep collecting them, it's not a burden on the agency.
Okay, so I wanted to just quickly go over the age statement form part of the bill that you guys proposed.
Sure.
If I read it correctly, you're saying you can't have somebody at the front door of for lack of a better word, a club or whatever, have everybody fill out an age statement form, regardless of whether or not their ID is questionable. Is that what that language said? Am I reading it properly?
Well, that's current law, Representative.
Right, that's current law. So what exactly were you guys getting to? Because I have a couple of issues with the age statement form. It's current practice that I wanted to ask you about, but what exactly were you doing with the age statement form in this bill?
So it was a requirement to identify the city and state of birth on age statement forms.
Okay, so it came to my attention over the past year or so that even though you may have somebody at the front door IDing everybody, which would be a great place to use the age statement form if you had a question. The age statement form is only valid if handed to the person from the person giving them the drink. So even though it's 21 or older to get in a building, and even though you were ID'd at the front door, and if they had a question, they could fill out the age statement form, that age statement form is not valid. It would have to be done by the bartender, one next step removed. The next step in the ladder, the bartender would have to give that person, even though there was somebody at the door, they would have to be given by the bartender. That just didn't seem reasonable or sort of like the normal course of business. I didn't know if you had an opinion about that.
Well, I think that, current law, as you point out, Representative, that it must be the server. So whether it be the bartender or someone coming to your table, that requires the individual to fill out the age statement form. One of the purposes, to be frank, for the addition of the city and state is to keep the minor engaged and adopt a reasonable standardness so that, you could better inquire as to whether or not they truly are of age to, be served alcohol. We intend or would like to see the committee support that these forms are used in good faith, not make it so that everyone fills it out.
So I guess I won't belabor it too much. My point is that I agree with you. When you're getting your drink served to you, if there's a question, that person IDs you and you fill out the form, great. But at those particular times or businesses where that ID process happens at the front door, the whole place is age gated. That's where I thought it would be reasonable to have them fill out the form there instead of waiting to the next step for a server or a bartender. And the lack of a door person, for a better word, then it would go back to the law as written now. I didn't know if you'd be open to that minor change.
Yeah, certainly we could discuss that. Yeah, but that would require a change, to your point.
And the last thing is, we could probably talk about this on the side, but I get somebody under 21 not being I guess have a liquor permit, but they are 18, they are of consent, they can enter into a contract to get married, they can join the military. So does that mean somebody 20 years and older, 20 years old can't open a business? Say they want to open a restaurant at 20. They can't be on the liquor permit?
No.
I mean,
they can't be on the backer.
What if what if there was a young person that wanted to open their own business at 20? Now listen, I'm not saying they could drink. I'm saying they could own. You're saying they can't own their own business at 20 years old, or be on the form that gets the liquor permit.
So we are saying that, I mean, not to do with owning their own business, but owning a business that supplies alcohol, correct? Yes. So to have a permit to sell liquor, it's clarifying Section 4 that minors are not allowed to have an ownership interest or be a permittee for any liquor permit.
So I could see a permittee, but so are they when using the word minor, right? Is that, in your eyes, is that just for liquor 21 and under, or is that somebody under 18? What do you technically call somebody who's between 18 and 21 that can't go drink at a bar? Are they technically?
I'm sorry. I didn't mean to interrupt. I thought you were finished.
Okay.
I'm sorry.
It's Zoom and we're Italian, so just talk. It's fine.
Well, minor is defined in Title 30 as 21 and up.
21 and under.
I mean, yes, 21 and under, excuse me.
All right. Okay. I guess we could talk about this later. Thank you very much for your time, Mr. Commissioner.
Okay, thank you.
Representative Luxembourg, followed by Representative Acker.
Thank you, Mr. Chair, and thank you, Commissioner. I had a question about the remote pharmacist part of the bill. It seems like maybe we're making a policy shift there that might create an additional operational burden on the hybrids. And I was wondering if you could talk about whether a lot of complaints in that area have come into DCP, or what's sort of motivating that shift in language.
So certainly, and thank you, Representative. So a couple things. This is amending a recent law that was passed last session with the intent to make it a little more less burdensome on hybrid retailers in terms of the necessity to have pharmacists present all the time at their locations. And so that was through these remote pharmacy, if you will. What this proposal, this limited, removes an inaccurate reference and will allow for remote dispensing. So it removes, so it's a little technical, but the current statutory language does not permit remote dispensing, which is part of a whole host of things that dispensing includes, when a pharmacist dispenses a medication. So it will allow for that kind of remote pharmacist that was intended in the law that was passed, so that this work can be done without the pharmacist present. It was really something that was, I don't want to say an oversight, but should have been included in the bill to make it functional. That being said, there have been a lot of discussions with market participants in terms of what remote pharmacy should look like, and whether or not, for instance, pharmacy technicians, which is part of the remote dispensing. So there's a pharmacist remote somewhere in another location, and there's a tech necessary to be on premise who will affect a lot of those procedures that are in place to dispense a medication. So there have been discussions as to whether or not employees could do some of those things the techs can do. There's a lot of nuanced things that different hybrid retailers have suggested would make it easier for them to operate. And those are discussions we're happy to engage in with both the committee and the participants in the market. However, this specific proposal just removes the dispensing requirement so that techs can actually affect what was trying to happen in that bill that passed last year.
So just so I understand, you're not requiring a pharmacist on site at every hybrid facility.
It's the opposite, right? So
Okay.
we're allowing for this remote dispensing to actually happen. There was a little bit of a hiccup in terms of the actual language in how the practice of pharmacy works, so that it would not, we couldn't quite get there.
Thank you, Mr. Chair, and thank you, Commissioner. I appreciate
Thank you.
it.
Thank you, Representative. Representative Ackert.
Thank you, Mr. Chair and Commissioner. Thank you for your work that you're doing. I have a couple of questions on some bills.
Sure.
One starting the raised bill 232. That's the one with the volume for commercials. Am I understanding that right now, for somebody that wears hearing aids, I could tell you what, when I'm on a streaming platform, I don't need the hearing aids because it changes. That's the one. Is it aligning with regular TV stations? Is that what we're doing? Because I thought it was already a law that you can't increase the volume of a commercial over the volume of the broadcast.
So, Representative, so this is not an agency bill,
Oh,
but
okay.
my understanding is that is correct.
Okay. All right.
Yeah.
And for some reason, I thought it was maybe you mentioned 231, but all right. So I'll ask whenever that comes up. But okay, so I'll skip to an agency bill.
Okay.
I have a couple sections on I think it's the 5222.
Okay.
Starting with section 8. Dealing with it looks like you're adding or maybe adjusting to what we're actually doing, but alternative fuels, petroleum-based products, is that an expansion of license, or is that just including it under normal practice?
This is existing scope that aligns with current statutes and regulations, so it's not an expansion.
All right, thank you. And then to skip to 9. I probably have a couple questions in there dealing with a licensure. And I understand by how I read license, I don't have to have a license at all. And I could buy a contracting business that is required to be licensed, but I have to have a license that's associated in my employment to actually do the operation. Is that correct?
Correct. In your employment, that's what we're seeking to clarify here.
Right. So, good example, local plumber in my area bought another company. So they obviously have a license with it's a heating contractor, actually. They actually have a license associated with the original company, but they're buying another company. That license could still be used for both of those. Is that correct?
That is correct. Yes.
Okay.
Just had to-
All right, so let me just see if that was it, because I was reading. So lines 252 to 254 confused me. I thought that is what it was, because if I bought, I have a company, I have a contracting company now, and if I bought another electrical contracting company, I don't need to get a separate license. I am a license holder. My license can be used for, Joe's Electric that I'm buying, right? So I can do that and still use that. Okay, what are
Correct.
we clarifying in section 9?
So,
Anything? Go ahead,
yeah,
sir.
I mean, so I'm sorry, Representative. So the clarification, really what it seeks to do is prevent contractors for getting paid for, quite frankly, selling their licenses for pulling permits on a job they don't have control over.
And thank you, Commissioner. To the committee, I want to let you know, unfortunately, this happens too often. And it's a disservice to the contractors that are out there that are, should be the ones being called, but they're not associated with the job in any way. They're not being hired to do the job. They're just selling their license off that somebody else non-licensed is then doing the work. And if there's a way that we can, good luck on enforcing this, sir. As you know, I continue to put in license inspectors for your department. And like, we need more of them. But it's unfortunate. It's a policy that's been happening for a long time. I'll get a call once a month. Hey, I'm doing a job. Any chance I could use your license? I'm like, no. So thank you for this. Thank you. And to the committee, thank you for raising this. I mean, it is an issue that we need to address. But thank you for your
Thank
work.
you. Thank you for your support, Representative.
Can I ask Representative Acker a quick question?
Sure.
If you give somebody your license to use on a job that you're not a part of, aren't you ultimately liable for that job?
Yeah, I mean, you could, if something goes wrong with a job, to your point, Representative, that's correct. I mean, if DCP if there's a complaint on the job, right, by the work, you're like, given your, license to do somebody else. But when DCP goes to, good point, the building department goes to inspect the job and there's something wrong, and your name and license is on there, and they pursue it and nobody fixes the job, then that could be turned over to DCP for regulations. Sure, you could. I mean, it's a chance you're doing, but the issue is that you are the one supposedly liable. But where you find it more, to be honest, is in the solar world right now.
Okay, all right. Let's I recognize that this could be a deeply problematic issue, and we clearly need to rectify it. Maybe we need to give the commissioner more tools to go after those folks. That's deeply problematic, and I thank you for raising the issue. But I don't want to go into too
Thank you,
much
Mr. Chair.
speculation.
Thank you, Mr. Chair.
Thank you, Commissioner, for your time this morning. As you can see, we will be in touch regarding a number of questions and concerns and comments that people have with some of the proposals that you brought before the committee.
Thank you. Thank you for your time always and your support.
Thanks again. Before we proceed to Senator Duff, there's someone who's entered via phone number. So we don't know who that person is by name, so we don't know how to assign you a number for public testimony. So if you could just change the name of your phone to be your name so that we can appropriately place you in order for public testimony, that would be greatly beneficial to our committee staff. All right, next up, is Senator Duff available at this point?
I'm here.
Excellent. Good to see you.
You too. Thank you.
I think we've already talked about this ad nauseum, but if you haven't gone out there to shovel, bring some back support, perhaps like hire some youthful folks walking around, because it is grueling.
It's bad out there.
So hopefully you get that done after your testimony today.
You all are keeping me, you're in between me and shoveling right now, but so keep me on as long as you like, I guess. To Representative Ackert, I've got a bill for you. Because I'm the one who proposed the 232, the streaming video services and volume of commercial advertisements. So I'm just going to read real quickly the testimony that I'm sure you've all experienced this before. You're watching a show or a movie. when an advertisement comes on with a significantly higher volume than when a show or movie was playing. Additionally, the volume does not stay consistent across advertisements, with some commercials having significantly louder advertisements than others. It can be deafening as you quickly rush to the remote to turn the volume down, which we've all had to do. Not only is this highly annoying, but has created a new consumer issue. Specifically, a recent study shows that 92% of viewers say ads have become more intrusive, with 91% of viewers saying that they will not purchase from brands with these more intrusive ads. In 2010, Congress passed the Commercial Advertisement Loudness Mitigation (COM) Act. This goes to the representative's question, which mandates that broadcasters and cable operators use industry standards to keep advertisements volume consistent with programming. Although this was an excellent step to address this annoying problem, considering it was 2010, it did not go far enough, and it did not apply to streaming services. With so many Connecticut residents now cutting the cord and using streaming services, it is only right that streaming service should have to abide by the intent of the COM Act, the same as cable television providers. The bill will fill the gap and ensures an even playing field, as well as an even viewing experience for all consumers. So thanks to the committee for your time, and hope that you would give this a favorable report, and happy to answer any questions.
Thank you, Senator. Are there any questions for Senator Duff? I'm going to turn it over to Senator Maroney and then Representative Ackert first and foremost. But if anyone else has any questions, please let us know. Senator Maroney.
Thank you, Representative Lamar. Senator Duff, thanks for bringing this issue to us and for your leadership on so many tech issues. I don't really have a question, just a thank you.
Thanks, Senator.
Representative Ackert, anything for Senator Duff?
I don't have my hand raised, Chairman.
Excellent. Sounds good.
I think
Representative Iaccarino.
I do. Hey, good morning, Mr. Chair. Good morning, Senator Duff. Good to see you.
Hey, morning, David.
Tomorrow morning. I did get a couple texts this morning. I read your testimony in the bill. There are people that actually think, and tell me if I'm wrong, and I could be wrong, or I could be right, that the streamers lower the volume so the commercials seem appear to be louder. Have you heard any of that?
No, I've experienced this myself, and then looking into it, we understood that the streamers are exempted from the rest of the law. So just felt this was kind of a natural extension to what's already out there.
Yeah, I didn't know if you heard it. I had never heard it, but I had a couple texts shockingly this morning during the snowstorm.
Yeah.
And all right, well, thank you. I'll see you tomorrow. Thank you, Mr.
All right, see you tomorrow. See you tomorrow, Representative. Thank you.
Representative Turco.
Thank you, Mr. Chairman, and thank you, Senator Duff, for this proposal. I've certainly experienced it myself, and I thought we were, done with this based on the federal laws, but as you pointed out, they don't apply to streaming. My question is this just when you have streaming devices over TVs, or will this apply when you are watching content on your phone, your computer, your iPad, all types of devices that, let's say, one of the Apple TV, Netflix, something like that you're watching that might have commercials?
I don't think that it says one way or the other, so I'm going to make the grand assumption that it's no matter what device you're on.
And I think that's important that we ensure, if this legislation goes forward, that it is broad enough to contain any device that someone, streams content that could include commercials, because nowadays people are using all different types of devices to get their media content. So I want to make sure they're covered. But thank you so much, Senator.
Yeah, absolutely. And just confirm it is all devices.
Senator Ciccarello.
Thank you. And thank you, Senator, for testifying and taking the time away from the snow outside. Just a quick question, and I've experienced it. I actually get yelled at for listening to the TV too loud, and then we fall asleep, and all of a sudden it comes on, and I get yelled at again because it is a little bit louder than before. But my question is, how would we be able to do this just here in the state of Connecticut? I know the streaming services provide probably worldwide. How would we be able to regulate that, and what kind of impact would it have on streaming here, or providing that service here in Connecticut?
Yeah, thank you. So the bill is effective, if it passes, would be effective this October, but would go into effect on July 1st of 2027. People can then make complaints if they like to, if it's still an issue to the FCC. Also, it could be considered a cut violation as well. And then DCP, DCP could take in the complaints. People can also complain to the FCC. Could be a cut violation, and also DCP could put forward regulations if they wanted to as well. I think it would be. I think this is probably one of those things that will be something that we'd see copied across the country. I don't know how many other states may be looking at this right now, but if there's a law, I would imagine streaming services would comply, because they're not being held in any other different standard than anybody else's right now.
Got it. Yeah, I'd like to see them just do it across the board. I'm just wondering, and I'm sure with the technology and coding that it might not be too challenging to set that provision on the back end. Just if it was something that was challenging and they decided not to do that, just would it reduce the amount of options we had for streaming services here in Connecticut, or if they would just kind of just do it across the board and we would be the leaders there, and then they would, again, just do it across the board. That's just a question that I had, and possibly a little concern. Hopefully they just do it nationally and they solve that problem. But all right, well, thank you so much for answering the questions.
Thank you. And again, that's why we thought it was important to make sure they were held at the same standard, not a higher standard than anybody else. That we're not holding them out as something different than cable or TV or anything else. So thank you for that question, Senator.
All right. I think that exhausts questions for you, Senator Duff.
All right, out to shovel.
Out to shovel, sorry.
Thank you all. See you later. Thanks for
soon.
everything. Bye.
Next up, we have Senator Perillo, followed by Representative Linehan.
I do not see Senator Perillo on, unless that 203 number is his in the phone list. And Representative Linehan was going to submit written testimony.
Excellent. I have then Senator Gordon and Senator Fazio, who I also don't see.
I don't see them either, Mr. Chair.
Perhaps they all came in under Senator Harding's testimony. So perhaps Senator Harding testifying on behalf of all. All right. Well, that would end the folks who've signed up under our public officials section for the morning, evening, whatever we are at this point. And we'll move on to the general public. First on that list is Alice Hamblett.
Alice, I just sent you a request to be a panelist. If you'd accept that. Oh, looks like you're propping up in that list. Perfect. Thank you.
So we'll have Alice, and then Antonia Jeffrey, and then Reno Ferrasi. So Alice, you're up first.
Thank you. And I'll just share that Antonia Jeffrey will not be testifying today, and I will be giving testimony on behalf of Worth Rises.
Outstanding. Thank you, Alice.
Wonderful. Good afternoon, everyone. Good afternoon, Chair Maroney, Chair Lamar, and members of the General Law Committee. My name is Alice Hamblett, and I am the Policy Campaigns Manager at Worth Rises, a national nonprofit committed to ending profiteering in the criminal legal system. Thank you so much for the opportunity to speak in strong support of House Bill 5225, which prohibits a person doing business in the state from knowingly manufacturing, testing, or selling drugs or medical devices for the purposes of capital punishment. This extends Connecticut's commitment following the abolition of the death penalty in 2012, and we are grateful to the committee for introducing this as a raised bill this session and for your leadership in advancing it out of this committee last year. During the previous session, the committee heard extensive testimony from stakeholders, experts, and from the community, and that record remains relevant today, and the evidence and the rationale presented at that time continue to strongly support the passage of this legislation. In the interest of the committee's time, the snow. We will not repeat those points in full, but will instead underscore that the need for this legislation has not diminished and refer you to Worthrise's written testimony today that was submitted. We stand ready to support this legislation as it advances through the session and look forward to working with you to see it enacted. Thank you.
Thank you. I really do appreciate the written testimony. That's likely going to be utilized in full as we try to figure out a way to draft it. There were some struggles with kind of getting the language in a good place for the public hearing. We decided to go with where we were at, but we recognize that these necessary changes are probably advantageous to the bill's final passage this year. So I do greatly appreciate your written testimony, as well as you being here in person. Representative Turco.
Thank you, Mr. Chairman. Thanks, Alice, for your testimony. I just wanted to ask something for my own clarification, because I believe that some of the drugs and devices that are manufactured could have other purposes besides being used to cause someone's death. And you can correct me if I'm wrong, and the sole purpose of these drugs and devices are only to be used for the death penalty, but I believe they could have other uses. So my question, Alice, if I'm correct on that, is this legislation you're supporting doesn't prohibit the manufacturing of those drugs, of that equipment. It's basically prohibiting that company from having a contract and selling it to a company that they know is going to use it for those purposes. Is that correct?
Thank you for the clarifying question. So basically, this bill says if you're a company licensed in Connecticut, you can't make or supply drugs or devices knowing that the person you're providing them to intends to use them in executions. That's it. So they just may not be used for those purposes.
Yeah, I think that's a really important distinction, because I think there's a concern that, we're stifling business, manufacturing, from a company here in Connecticut. And we're not, as long as they're not willingly using the products that are going to be used for the death penalty in another state, which Connecticut has decided it's not supportive of. So I think I appreciate you clarifying that for me, because that helps, and maybe some of my colleagues, and I think this is a good bill. Thank you, Alice.
Thank you.
Senator Kissel.
Thank you very much. And I apologize to everyone for taking a long time to get into this. It was like my computer was putting me in the public testifying section over and over and over. In any event, I take an opposite view, I believe, of Representative Turco. I don't like this bill, and I'm wondering, could you explain how you feel that this proposal is not a violation on the constitutional prohibition against laws that violate interstate commerce clause?
Absolutely. So this bill does not violate the interstate commerce clause. Federal courts have essentially held that the commerce clause, as you all probably know, only prohibits a state taking action that, one, clearly discriminates against interstate commerce in favor of intrastate commerce, or two, imposes significant burdens on interstate commerce but provides relatively minor in-state benefits. The Commerce Clause does not prohibit all state action that has an effect on interstate commerce, and neither concern exists here. This bill does not discriminate in favor of in-state commercial interests. It treats all companies seeking a license in Connecticut the same, whether they're based in-state or out of state. And federal courts have held that where, as here, a law imposes the same requirements on all parties, there's no discrimination and thus no per se violation of the Commerce Clause. This bill also does not impose anything close to a significant burden on interstate commerce. The trade for execution drugs and devices is minuscule, hidden, it's largely illicit. It's not part of the business model of pharmaceutical companies, ultimately, the wider healthcare industry or gas companies. And there is also a significant benefit to Connecticut and its residents to ensure that it is not in this business, even beyond being consistent with our state's abolition of the death penalty.
And if I could follow up, Mr. Chair?
Yes, please proceed.
Yes, and I appreciate your answer. I will ask my counsel to do their investigation. I don't believe your analysis is accurate, but I'm not here to pick on you. I appreciate your heartfelt passion regarding this. Other than taking a perceived moral high road, what is the benefit to the state of Connecticut?
That's an important question. Ultimately, this bill actually helps Connecticut also enforce drug safety laws and keep dangerous practices out of the state. So it not only protects state values, but it also protects the integrity of the medicine that folks rely on. When states secretly get drugs for executions, it puts patients and it puts the public at risk because they're frequently taken from the medical supply chain in ways that bypass rules designed to ensure drug safety. And that means that those drugs aren't properly labeled or tracked or tested, and it weakens the whole system that's meant to protect patients, which is why we've seen over 60 pharmaceutical companies publicly state that their drugs should not be used in executions.
I appreciate your answers. Thank you, Mr. Chair.
Thank you. And Ms. Hamblett, I think you've seen what the nature of this conversation is going to be for the next few weeks. So I do appreciate your testimony, both written, that will allow us to engage in this more fully and kind of get a product that I think people can understand in full detail. And we can have this conversation on the committee room floor again for the second year. And with that, I see no further questions. Thank you again, Alice, for your time.
Thank you for the opportunity.
Of course. Next up, we have Reno, to be followed by Timothy Egan.
I am not seeing Reno unless, again, we don't know who that 203 number is that's listening via phone. If that person could email me via the link that you got to sign in the first place, that would be really helpful.
Yes, it's going to be near impossible for us to allow an anonymized phone number in for the public hearing. Just folks, we're not trying to dissuade anyone from testifying or limit anyone's ability to testify. We just sort of need to know who that is.
Oh, Reno just popped in at the bottom of the list, but while the last person was testifying, Senator Gordon popped on, as did just now, I believe I saw Senator Fazio.
Okay, we'll go Senator Gordon to be followed.
Mr. Chair, I
Yes,
just wanted to interject rudely. I apologize.
That's okay.
But I wanted on the record to thank Betsy for not giving up on me as I was trying to get into this hearing. So thank you, Madam Clerk, for your hard work and effort.
Thanks for your persistence.
All right, Senator Gordon, we're going to go to you.
Thank you, Mr. Chairman. My apologies for being late. I just finished testifying in another public hearing on another committee. So we're all bouncing around the different committees. So thank you. Chairman Lamar, Chairman Maroney, ranking members Ciccarella and Rutigliano, and distinguished members of the committee, I'm State Senator Jeff Gordon, 35th District, 13 towns up in Northeast Connecticut. We're the ones in our part of the state usually getting whacked with snow, but it looks like other parts of the state south of us have gotten a lot of snow. So I wish everybody is staying safe and doing safe. I'm testifying today in strong support of proposed SB 105, an act eliminating various occupational and professional license permit certification and registration fees. I'm proud to have co-introduce a proposal like this with my Senate Republican colleagues as part of ongoing efforts to make Connecticut more affordable for more people. And this includes making Connecticut more affordable to hardworking people and job-creating small businesses who do spend money, sometimes every year at big expense, to obtain, sometimes even renew, various professional and occupational licenses, permits, certifications, and registrations. There's a long list of the various ones. We do want more people to come to Connecticut to work here. We also want more people to stay in Connecticut, especially when they're training through various types of training programs or apprenticeships, and not leave to go to some other state. It's all part of an effort to make certain that we can have a good economy all around our state, but a growing and sustainable economy. And that ultimately helps state government with revenue it does bring in. We don't want more taxes, we want more taxpayers, and that's something the governor has said, and I agree with him. In addition to economic development, it's also part of a workforce development. The more that we can strengthen all the different trades and professions here in Connecticut, the better that will be all around. We know various occupations and professions have various degrees of shortages, including in various parts of the state. And that's important as well when we look at geography in Connecticut, even being a small state. And one way to do that is to remove a barrier to licensing in these registrations, and that is the fees that are charged with it. So I ask that the General Law Committee support this bill. It's a very good bill, certainly something we can get behind in a bipartisan way as we move Connecticut forward and make Connecticut more affordable for more people. One caveat I do want to bring up is that if in any way eliminating any of these fees would impact money that does go to the Haven program, that's the Health Assistance Intervention Education Network that's been around for many, many years. Many healthcare professionals, for example, with their types of licenses, do have a certain amount, I think it's $5, that is designated to help fund the Haven program. It's a very good health assistance program authorized by state law that does serve a very, very good purpose. I think there's at least 30 disciplines through their licensing that help support this program. So I just want to make certain that in the work that's being done to try to support SB 105, that we're mindful if there might be an unintended consequence that affects the funding of Haven. And I'm sure there's something that can be worked out to make certain that the work of Haven continues, while at the same time we are doing more to try to get rid of these professional fees for licenses and registrations and working to make Connecticut more affordable, which is a good step forward. So thank you for the opportunity, Mr. Chairman, to testify today, and I did submit written testimony for the committee members to read.
Thank you, Senator Gordon. I really do appreciate your testimony this morning. Again, hopefully you're able to get out and get some shoveling done, though you're not dressed appropriately for shoveling right now. I do hope you get a chance to get out there because it is miserable and very taxing. I just want to say we had a pretty robust conversation with your Senate leader earlier today. Broad support for removing some of the cost barriers that make it hard and difficult to both become a professional, to get your license, to maintain that license. Driving down the cost barriers necessary to work are, I think, a shared priority for folks on this committee, irrespective of House, Senate, Republican, Democrat. And I appreciate your caucus's leadership bringing a bill forward this year. I think we have broad approval to get this out of committee this year, but as you know, it ends up somewhere else after that. And the conversation and the thoughtfulness that you put into some of the programs that are funded by some of these license fees are part of what will happen next once we leave this committee. And so I hope you'll stay a part of those conversations, because what we agree to as an important policy matter in general law becomes an appropriations issue somewhere down the line. With that, Senator Kissel.
Thank you very much, Chairman Lamar. And I want to thank you, Senator Gordon, for testifying this afternoon. First of all, regarding Haven, I know people that have benefited through the substance abuse and counseling and interventions efforts by Haven. It's a critically useful program. And in fact, this committee should give itself credit because not that long ago, we opened that program or got the program to open up to pharmacists, especially younger pharmacists that like so many young people, they think they're indestructible and get themselves into trouble if they try some of the wares that they feel that they know more about than anybody else. And so it is a program that must maintain its funding and its valuable purpose. My recollection is that when Governor Lamont came out and gave his address at the beginning of this short session, he did mention getting rid of some of these fees. I think my recollection is, in particular, he pointed out plumbers. I'm just wondering, I know that Senate Republicans have been championing this for at least a couple of years. Yourself, Senator Fazio, obviously Senator Harding, the leader of your caucus, our caucus. But I'm wondering if this bill substantially mirrors what the governor is supportive of, because at the ultimately he will either sign or not sign the bill. And I think to the extent that everyone's on the same page, as Chairman Lamar pointed out, the best chance for success, this will be the great year that it gets cross finish line. So how close are these proposals to mirroring one another?
Thank you, Senator, and I appreciate your leadership on this as well as part of the Senate Republican caucus. This is a very good effort, and I do appreciate Chairman Lamar's remarks as well in that regard, and certainly the caveat we all know, when things get out of committee, the work's not done, and I plan to continue to be involved as best as I can. I've not done a word-for-word comparison of what the governor has proposed in this bill. Nevertheless, my understanding, having heard the governor in his address and read through various things coming from the governor's office, that it seems to mirror, and I think there's an alignment of various different efforts to do what we can for various occupational and professional license and registration fees. So in ways that there might be differences, I think the differences may not be big, and they may well be things that we can come to consensus on, understanding that it looks like the stars are aligning for a big push to try to move on this issue. You did mention prior years' work on this, and there has been, but I hope that this can be done now. It's not a minor thing. I can tell you for a lot of healthcare professionals, it can be very big licensing fees, but we're also looking at young people coming out of, let's say, apprenticeships for the trades, plumbers, electricians, carpenters. The more we can get rid of barriers, the better. And I think what this proposed bill and what the governor has been saying and documents coming out of the governor's office, I do believe things do align. But again, as you know, we'll have to see where the devil is in the details and exactly how the wording aligns. But my sense is it does in the bigger sense. And I'm encouraged by that, and hopefully that will be the impetus, even in a short session, for us to get this through. And I appreciate the work the committee is doing, especially moving this to a public hearing, which is a very important big step. And I'm glad that there's that opportunity for the public and others, myself included, to weigh in. So thank you, Senator.
You're quite welcome. And again, through you, Mr. Chair, actually the leadership of this committee, both the ranking members and the chairs, deserve an awful lot of credit. They've been very interested in this proposal. I think it's very heartening that Governor Lamont mentioned it centrally in his opening remarks to our short sessions joint convention. And I'm of the opinion that half a loaf is better than none. We can always come back and add other licensures and costs. But whatever we can get through appropriations, I would say go for it. And I'm hoping this is the magic year. As they say, success has 100 parents, but failure is an orphan. So thank you very much, Senator Gordon. Thank you, Chairman Lamar.
Thank you, Senator.
It looks like there's no more questions. So thank you again, Senator Gordon, for your time today.
Thank you, Mr. Chairman, and appreciate very much the work of the committee.
We'll see you soon. I know Senator Fazio is still scheduled to join us. If he comes in, we will certainly make time for him.
I am here.
Oh, there we are. Sorry.
I see him floating around.
There we are, Senator Fazio. The floor is yours.
Thank you, sir. Chairman Lamar, Chairman Maroney, ranking members, and distinguished colleagues, I'm excited to testify again for my fourth straight year in support of Senate Bill 105, an act eliminating occupational licensure fees. Senate Bill 105 will end those annual fees from licensed workers in our state. It will improve economic opportunity for workers. It will make our state more affordable, and it will help our state economy writ large. It will benefit all residents, but especially working class and middle class skilled workers who are in need of economic support. Currently, state policy imposes unnecessary and at times exorbitant fees on workers who are already licensed and qualified, and those burdens can amount to hundreds of dollars per year. That not only reduces opportunities for those workers, but it also slows economic growth and inflates costs for our consumers. Those costs are obviously passed on in the price of goods and services. These barriers have grown substantially over generations. One study finds that the number of jobs that require a license has increased from roughly 5% of all jobs in our economy in the 1950s to around 25% today. And Connecticut's licensing fees and requirements are higher than most states, according to the Institute for Justice, and they place our state at a competitive disadvantage. Those costs of licenses can surpass $500 for some occupations. A study from the National Bureau of Economic Research found that licensing reduces labor supply by anywhere from 17 to 27%. We can't grow our economy with so much red tape and taxation if it shrinks the number of workers and jobs by that much. Connecticut used to be a place of opportunity and upward mobility. It can be again if we reduce unfair burdens and costs on our workers. Passing Senate Bill 105 would be a major step in the right direction. And I just want to end by thanking the members and the leadership of this committee for each of the last 4 years passing this bill or a similar bill through the committee with bipartisan support. As Senator Kissel said earlier, successes have many parents, and I think this is no exception. And I hope that this is a year where we can continue to take steps in the right direction. As Chairman Lamar said, there will be a budget question in all of this. And to answer maybe Senator Kissel's previous question preemptively, I think the administration had originally taken a look at nurses and educators, and maybe in the future has an eye towards the trades and so on. I think that having broad-based relief is very positive. I would also like to see relief for those in industries where we have the greatest need, like the trades. So those are a couple of my preferences on how we might narrow the policy if we need to because of budget room. But with that, I'd like to end my comments, but just thank the General Law Committee once again for their support over the last 4 years for this important policy innovation.
Thank you, Senator Fazio, for your consistency. We know every year it's coming, and we know every year that we're going to want to encourage this conversation to continue. We talk about it in our leadership briefings before session even starts about having this conversation, the importance General Law Committee standing firmly in support of this proposal, whether it comes from you or Governor Lamont. We want to make sure that we're sending the message that our licensed professionals deserve a little bit of relief. It shouldn't be that difficult or that expensive for folks to maintain their current occupation. And I appreciate your willingness to continue to come here and testify. I'm going to move over to Senator Ciccarella and then Senator Kissel.
Thank you. And thank you, Senator, for coming to testify. I know this is something that you and I have talked about numerous times for many years. And we see it firsthand in professions across the board that Connecticut's license fees are higher than other states. We talk about professional organizations that meet at a national level to talk about the challenges of professions, and it's eye-opening to hear. It's not just maybe one profession or one area, whether it's trades, whether it's health, but across the board, our fees are substantially higher. And you made a very valid point. This is not only to help these professionals that are just trying to work, but also the consumers that utilize these services that these license holders provide. At the end of the day, if it's more expensive to do business, it will trickle down to the consumer. And it's just one way of addressing the burden of the high cost here in Connecticut to consumers. And, this committee is great because we have these conversations and we're all in agreement that this has to happen. We're finding the way to do it and avoiding any unintended consequences that may arise. Senator Jeff Gordon, Dr. Gordon, brought to my attention that there are other programs that are ran out of some of these fees that are collected for the licenses. So I look forward to working with this committee, getting it out of this committee and pushing across the finish line. And as I know that you have been a champion for this. So I just wanted to thank you for your persistence and continue to bring this forward and advocating not only for the license holders, but the consumers. So I just wanted to thank you.
Thank you, Senator.
Senator Kissel.
Thank you very much, Mr. Chairman, and as well as like congratulating and thanking Chairman Lamar and Chairman Maroney. Clearly, I want to point out the dogged efforts year in and year out by our wonderful ranking members, Senator Ciccarella and Representative Rutigliano, and their efforts should not be lost on us. And again, I just want to pass along after many, many years on this committee. It's fabulous because it is so bipartisan and nonpartisan. This is something we all can get behind. And again, I'm hoping we can get what we can get, and then we can always add to the list down the road. And this is something you said 4 years, but even prior to that, I believe that then ranking member, and I think he may have been when it was 2018 during that tri-chair era, one of the tri-chairs, Senator Witkos, was really working hard on this initiative as well. So I think the time is right. I think the sun, the moon, and the stars are aligned. And I just want to thank you, Senator Fazio, for all your efforts as well. Thank you, Mr. Chair.
Thank you, Senator.
Representative Acker.
Thank you, Senator Fazio, for your work on this and continued effort. I got a question for you. I brought this up earlier to another senator. One of the areas that we might not really be looking at is those that haven't even started working and making money, and those are the apprentices.
Yeah.
And we charge them before they work day one in the trade. What are your thoughts about maybe really looking at the apprentices that are registered with the state to be added to this effort?
Yeah, I think that's a wise decision, or that would be a wise, issue to examine, because obviously they're not ones who have been able to save, and they're earning lower wages. They have other limitations placed on them that, has been noted by members of this committee. So I think that it would be a wise angle to look at. We need more people in the trades. There's opportunities to make good middle-class wages and succeed in the trades with the shortages, with the average age of members of the trades increasing, and making it easier on people on the first rung of their career ladder to get by, I think would be very wise.
Thank you, Senator. Again, Mr. Chairman, thank you for the time.
Seeing no one else, Senator Fazio, thank you so much for your testimony today, and we look forward to seeing you soon.
Thank you, Mr. Chairman.
Okay, it looks like next up we have Reno. And is Reno in? I didn't see him.
Reno has been popping in and out. I believe he's here.
Reno, if you're here, the floor is yours. I did see you earlier, but I'm not seeing you now.
He's on our list of panelists just with,
Hi, can you hear me?
there he is.
I'm so sorry.
Oh, there we are.
Working remotely. I don't usually do this.
That's
so
quite
I
all right.
apologize. Hold on, let me make sure. Can you see me?
We can, yes.
Okay, wonderful. Okay, great. Thank you. Yes, definitely working remotely today. So just little technical difficulties getting started. Okay, I'll get to it. So Chairman, ranking members, honorable members of the committee, I appreciate the opportunity to provide technical commentary on SB 231. My name is Reno Ferrisi, and I am an owner and operator of Affinity Grow in Portland, Connecticut. I believe I offer a unique perspective to this committee based on my 30 years in FDA-regulated manufacturing. My career spans sterile vaccine suites at Alexion Pharmaceuticals and Wyeth Vaccines, all the way to directing implantable devices at Medtronics. This technical foundation has enabled me to lead my prior company in a partnership with Yale University that secured the nation's first FDA authorized clinical trial using state-regulated cannabis. And that was a first in class, and that was back in 2020. However, that milestone was achievable only because our medical cannabis program then mirrored 21 CFR 111, the rigorous dietary supplement standards, a level of regulatory maturity and scientific integrity that we should all remember with pride, but which the current program no longer meets, as we also watch dispensary pharmacists get replaced and non-pharmacists in the medical marijuana program. I'm here today to testify that Senate Bill 231 allows a testing framework that moves further from the pharmaceutical nature of the previous program and continues in a direction that is a direct threat to public safety. Connecticut is currently in an 18-month blind spot where laboratories are permitted to test products and pass or fail them without having achieved ISO 17025 accreditation. To put that in perspective, would you let a doctor perform surgery on you today if they told you they weren't scheduled to graduate for another 18 months? That is exactly what we were doing with cannabis safety testing in the state. Because there's no centralized real-time database to verify credentials, it leads to unreliable data reporting. To validate test methods, a laboratory must first undergo ISO 17025 accreditation. The laboratory sampling plan must also be validated. Specifically, we have seen chromium results, for example, which is a type of heavy metal, for the same lot, varying as much as 400% between the same batch, just two different samples. One result would be 2.4 parts per million. Another one might be 9.8 parts per million. 2.4 and 9.8, same batch. Specification is 0.6. Just to put it in perspective, however, New York's specification is 120. So it's not a matter of let me stick with my written testimony, and I can get to it later. The instability likely exists because the current final form sampling mandate is at odds and in direct contradiction with ASTM D8334, which is the standards practice for sampling of cannabis and hemp post-harvest batches for laboratory analysis. And while ASTM D8334 requires composite sampling for multiple increments to ensure a batch is safe, the Connecticut regulations rely on a statistically insignificant grab sample from a limited quantity of retail jar samples. This creates a public health risk. A system that produces false fails also produces false passes, potentially letting contaminated product hit shelves because the sampling failed to detect the localized failure. I urge this committee to drop final form testing and to revert to a CGMP compliant sampling method as soon as possible. Mandate ASTM D8334, implement a public accreditation registry, and adopt formal out-of-specification and retest protocols found in traditional CGMP programs to verify data integrity. The regulator's role in proficiency testing evaluation should involve actively assessing the criteria used by proficiency test providers and determining how closely the regulated labs are to passing or failing these tests. For large, ongoing multiple sample studies, scoring criteria should be statistically derived, ensuring a sample size that is sufficient. And then for smaller corrective action proficiency tests, a manually determined range should be implemented. I'm happy to answer any questions, and I apologize for getting technical in that explanation, but it is laboratory testing, which is technical in nature.
Thank you, Reno. I appreciate it. As you know, the technical aspects of this occasionally outpace my ability to understand while you're speaking. So I do appreciate the written testimony that you provide and your availability, both personally and your representation here, so that we can evaluate some of the ideas and thoughts that you have as we move forward. Not for we didn't make this announcement ahead of time. There's a very thematic timer that will go off at the conclusion of 3 minutes. So if you hear an interesting noise, that is our clerk Betsy's timer. It is really quite heroic in sound. That means you've accomplished great things in 3 minutes. I don't know that there's any questions for you right now. I will make you aware that there will be another public hearing on cannabis-related issues, including some issues that you've brought to this committee in the past. That'll be next week, so I'm hoping you'll join us then as well. And then post-conclusion of our public hearings, it is very likely that once again we'll be relying on your expertise to help us develop good public policy for the state. So thank you, Reno, for your testimony today.
My pleasure. Thank you.
Next up, we have Timothy Egan. Tim, I see. Yep, there we go.
Okay. Good afternoon, everyone, chairs, ranking members, and members of the committee. My name is Timothy Egan. I'm the chair of the Connecticut State Board of Accountancy. I'm a retired KPMG partner, and I reside in Darien. And I'm here in strong opposition to sections 1 and 2 of HB 5222. This bill weakens, not strengthens, public protection. And the core issue is simple. Who should have final authority to discipline CPAs? This bill would remove that authority from the Board of Accountancy, the body specifically created for that purpose, and place it elsewhere. CPAs operate in one of the most technically complex regulatory environments in any licensed profession. Enforcement decisions require deep understanding of auditing standards, independence rules, ethics requirements, quality control systems, and multi-layered state regulations. These are not general regulatory matters. They are highly specialized professional determinations, and final disciplinary authority should remain with those who have the expertise to evaluate these complex standards. Connecticut would be departing from the national framework. Every state in the country has a Board of Accountancy. The Uniform Accountancy Act, used as the national model law, explicitly vests enforcement authority with state boards. There is no national movement to move disciplinary authority from boards. If Connecticut were to move in this direction, we would be stepping outside the nationally recognized regulatory framework. And there are risks to Connecticut CPAs. If sections 1 and 2 are enacted, there could be serious unintended consequences. First is the loss of mobility, which is the legislation you just passed last year, for which I do want to thank you for your efforts. Connecticut CPAs rely on national mobility system to serve clients across state lines. Other states may question whether Connecticut's regulatory framework still meets national standards. This could jeopardize automatic practice privileges for our licensees. Second is increased costs and regulatory burden. CPAs could be forced to obtain multiple licenses. They may face additional fees and redundant CPE requirements. This creates also additional creates an unnecessary burden on our Connecticut professionals and firms. And third, this would undermine professional standards. Removing expert oversight weakens the integrity of the profession's regulatory structure. It risks diminishing public protection, and rather than strengthening it, it risks diminishing public protection rather than strengthening it. So we think there's a better path forward. If there are concerns about investigative authority, the board is ready to address them. We've asked DCP to identify any specific legal or practical obstacles with their current investigative authority. We are committed to collaboration, but transferring final disciplinary authority away from the expert board is not the solution. In closing, this bill would weaken expert oversight, create uncertainty for Connecticut CPAs, and risk real harm to our national standing. For the protection of the public and the integrity of the profession, I respectfully urge you to oppose sections 1 and 2 of HB 5222. I want to thank you for your consideration, and I'm very happy to take any questions if you have any. Thank you.
Thank you. Thank you, Timothy. I appreciate your testimony today. And thank you for both your written testimony as well. Help us to analyze this as we move forward. Representative Rutigliano, you have a question for Mr. Egan?
Thank you, Mr. Chairman. And quickly, thank you, sir, for testifying. I read sections 1 and 2 a couple of times, and I was just wondering, the way I read it, please correct me if I'm wrong, they were just sort of adding the Department of Consumer Protection along with the existing board as a regulatory body. I didn't get the impression they were eliminating the board. They were just sort of having the department or the board. Am I reading that correctly?
I think you're reading it correctly, but the issue was with the word "or," which would say that, you know, in theory, when it's "or," it's the board can do something or the department could do something. So the department on their own could make decisions around, you know, hearings and ultimate final enforcement of matters which are fairly complex. And there have been issues in the past where DCP has misinterpreted some of those complex rules and has caused some harm to our CPAs in terms of their licenses and their ability to practice, which ultimately were rectified. But those issues do exist, and we believe, again, final enforcement decision-making should remain with the board. And DCP absolutely conducting investigations as they have been, supporting the board. We're all for that, but ultimately, we think we are, as the experts in those issues, ones that should really be the final decision makers. And that's the point of it.
So that the license currently is under the Department of Consumer Protection, correct?
Correct. Licensing. Yep.
is the board obligated to listen to or advise and consent or anything from DCP as its current makeup? Or are they sort of independent?
No, we are not required to.
Okay. Thank you, sir, for your time.
Thank you.
Thank you, Mr. Chair.
No problem. All right, seeing no other questions, thank you again for your testimony today.
Thank you all.
Next, we have Bonnie Egan.
It's Bonnie Stewart. I just got listed
Oh.
wrong, but hi.
That makes sense. There you go.
I thank you very much for holding this hearing today. We appreciate the opportunity to comment on bills. The first one I'm going to mention is Senate Bill 105 that Senator Fazio just spoke about. I appreciate this being brought before the committee again this year and the support you gave to that measure last year. If you'll recall, we supported the measure because Connecticut CPAs have the highest fee in the nation, nearly 300% higher than other states. We're head and shoulders, and it really does put us at a competitive disadvantage because you do not need your CPA license to do much of the work that CPAs do. So we find that a lot of people choose not to license in Connecticut. Not a great thing for Connecticut. While it doesn't harm us in terms of the work being done, it definitely harms us with dollars and the number of CPAs. So we would strongly encourage passage of Senate Bill 105. A significant concern to us today is House Bill 5222, what was just spoken about by Chairman Egan. This measure does create a lot of problems, in large part because while it does say that the state board would still have that authority, the practicality is they would not, because we require DCP, the way the system runs currently, to bring all those cases to the board's attention. When they choose not to do so, the board has no knowledge of what's going on, and DCP could act independently the way this bill is drafted. That happened a couple of times last year, even without this law in place, and there were significant consequences. We did have people that were told they had to change their websites. They couldn't advertise for services at a time when we're short CPAs. We had people who didn't have their licenses renewed, all mistaken errors on the part of DCP. And in fairness to DCP, understanding the CPE rules, especially as it gets to the intricacies of a lot of the quality review programs, it's not easy, which is why the expert board is so desperately needed. The other thing is the mobility laws. They really watch very closely to make sure that the states are aligned. You recall it was a big issue for us last year. We kept on playing with language as every state was trying to get the same language adopted. If we made a change where enforcement was concerned and you no longer had people with knowledge of those accountancy laws, rules, regulations, etc., there would be questions as to whether or not Connecticut did enforce our laws properly, which would put our mobility at risk, and that's dangerous. So I would strongly encourage you to reject House Bill 5222, sections 1 and 2. As Chairman Egan said, if there's a specific concern, we're happy to hear it, but none's been raised in any other state in the nation.
I think we lost Bonnie right at the 3-minute mark. Bonnie, if you can hear us, we'll definitely be in contact with you to further clarify some of the concerns that you raised. But yes, we're looking forward to having continued conversations with you and members of the accounting profession to get to a good conclusion for the session. All right. Next up, we have Lamia Ayaz.
Hi, good afternoon. Can you hear me?
We can. And Lamia, if I got your name wrong, please don't be shy and go ahead and correct me.
Yeah, it's Lamia. Thanks so much.
Thank you.
Yeah, so good afternoon, distinguished members of the General Law Committee. My name is Lamia Ayaz, and I'm a sophomore at Yale College in New Haven studying Spanish and public health. I'm also a nationally certified emergency medical technician working in Connecticut. Thank you so much for the opportunity to speak here with you today in strong support of Raised Bill 227. My generation has grown up alongside the internet and social media. More than any generation before, we've had access to the world at our fingertips. And in many ways, this has been one of our biggest blessings. We can learn previously inaccessible skills, connect with family and friends across the world, and order any product to our house in seconds. But with this blessing comes unintended consequences, particularly for our youth. The content our youth consume, unfortunately, often encourages unrealistic body norms and disordered eating. It has come to the point where content promoting disordered eating, which is perpetuated to young and vulnerable users through social media algorithms, has come to be known as skinny talk, a play on words of skinny and TikTok. Discussions about Ozempic, Wegovy, and other GLP-1s have skyrocketed, and our youth are paying attention. But it's not just about wanting to be smaller, although this is a real issue. These dangers also extend to youth who want to get bigger instead. Young men and women who want to quickly develop very muscular frames. I have seen both forms of body dysmorphia extensively around my peers. Whether by getting bigger or smaller, this leads our youth more than ever to turn to quick ways to achieve the body ideal that the content they consume has promoted. And yes, we are worried about what our youth are consuming online. This is not a new discussion, but how careful are we being about what they can access in person? We think about content restrictions and social media bans, but how much do we think about what our youth can access in person, not just on their phones or on social media, but at the CVS down the street from their school in New Haven, or at the Walgreens walking distance from their house in New London? As it turns out, what they can access is over-the-counter diet pills and muscle-building supplements. These substances are often minimally regulated by the FDA, and the American Academy of Pediatrics has stated that youth under 18 should not be consuming them due to their potential negative health impacts: hepatitis, increased cancer risk, even death. So before you today is a piece of common sense legislation. The children of Connecticut should not be able to access diet pills and muscle building supplements. I urge you to vote favorably towards this, and thank you so much for your time.
Thank you so much for your testimony. I want to say thank you for joining us today. I know it's a difficult day to get online, but I appreciate everything that you do to advocate on behalf of so many folks here in New Haven, but across the state. Are there questions for Ms. Ayaz? I don't see any. Thank you again for your testimony. I really do appreciate it.
Thank you so much.
Okay, next up we have Larry Cafaro. Larry, I don't see you in.
He
Larry, if you're
just
trying to
made
get
it
in.
in.
Oh, just made it in. There we go.
Yep.
Good afternoon, everyone. Good afternoon, honorable members of the General Law Committee. For the record, my name is Larry Cafaro. I'm the Executive Director, General Counsel, the Wine and Spirit Wholesalers of Connecticut. And I'm also speaking on behalf of the Wine and Spirit Wholesalers of America as well. We submitted some written testimony. My testimony is not long. It is with regard to one specific section of Senate Bill 230. The commissioner spoke about it earlier. The department is recommending in lines 27 through 31 the elimination of a long-held requirement that had out-of-state shippers who ship wine into our state, had them file records of whom they sent their product to, how much they sent, how often they sent it, etc. And those are kept on file by the Department of Consumer Protection. As you heard today, they might be very rarely used, but I think it is an important requirement. You know, I'm not one for overburdening businesses out there, but when it comes to an intoxicant such as alcohol and the special privilege, I think, that we give to out-of-state shippers to allow them with no other real connection to our state to sell their product directly to consumers. The least we could have them do is record how much they sell and to whom they sell it to. A point was made earlier that, oh, what's the big deal? It's a record that it's no burden to the department, but it's something that's rarely used. I would submit that when it is needed, it is very important. We have had reports through other states, especially with the advancements in technology, of so many out-of-state shippers sending more than they should of their product to consumers within this state. some of sending what they shouldn't be sending, be that spirits, etc. And at least if we put on them some responsibility, some connection, if you will, that requires them to report what they do from out of state to the consumers they sell to in state, I think it is a very good report and good requirement to keep. Being that it is no burden to the department, I would ask respectfully that the committee consider removing the elimination of that requirement and keep it in place. And with that, I'll take any questions if there are any, and I thank you all for your time.
Thank you, Mr. Caffaro, for your testimony here today. It is unusual that an agency comes forward and says, we don't want to regulate folks anymore. We don't want to have this regulatory structure in place because we're not hearing a need for it, and then have the industry itself say, well, wait a minute, like there is some use here. So let's agree to have this conversation moving forward so I can get some clarity about the proposal and understand it from more sides. So you've always been great about being available and having your members available. So I really do appreciate that, and I'll take advantage of that moving forward. There is a question from Senator Kissel, however. Senator Kissel?
Yeah, thank you, Chairman Lamar. And I'm bummed that I missed the commissioner's testimony, but I can circle back and get that. But Larry, it's always great to see you. It was always a pleasure serving with you, either on the Judiciary Committee or in your capacity as the minority leader in the House. Sometimes when we have a concern about an area that needs policing on the regulatory side, we will create a statute that, for example, an Unfair Trade Practices Act that might empower the Attorney General, but also create a private citizen to act like as a private Attorney General, right? And I'm wondering if we agree with your association's position and allow this information to continue to be gathered, while the department may not look at it an awful lot, would your association be able to access it? I don't know if you have in the past. Maybe you can tell us about that as well. So that because you have a dog in the fight, you guys have a dog in this fight. And while the department may be short-staffed or not have the resources to go into this an awful lot, you guys might use freedom of information or just write to the department, look at these records. And then if something raised a red flag with you folks, then you could bring it to the department's attention for further investigation. So I'm sort of wondering, I agree with the chairman that this is a sort of a gray area, but do you see that you folks can at least benefit from the gathering of this information and thereby help our consumers in the state of Connecticut?
Without a doubt, Senator, you make an excellent point. And some of my colleagues throughout the country, Illinois, Indiana, et cetera, have done exactly that. They've taken advantage of the information that has been filed, maybe as your point was made, never used, but has been filed. They've FOI'd that information, and they brought it to the attention of the Attorney General or the appropriate department in that state to say, hey, listen, we have a bad player here. Yes, this particular supplier is registered, et cetera. But in our state, for instance, Senator, as you know, out-of-state retailers and out-of-state shippers of wine are limited to 5 gallons every 2 months to a particular individual. There's been so many instances in various other states where those legally registered, permitted suppliers have sent more than the limit as imposed by that particular state. What does that do? It deprives the state of sales tax, it deprives the state of excise tax, and frankly, it's breaking the statute, which puts those limits on. They were put on for a reason. So sometimes the department might not have the staff and resources to keep on top of that on a daily basis, but certain stakeholders like wine and spirit wholesalers or package store associations that have a real stake in the game that are threatened, or as business is affected, I should say, by out-of-state suppliers of alcohol beverage, do have the right to go to a source, FOI that information, bring it to the attention of the authorities. Without that there, it's going to make it that much more difficult. And once again, if it isn't a burden for the department, as Commissioner Caffarelli testified to, then let's leave well enough alone. We're talking about an intoxicant here. it's a smart and safe way to keep tabs on what's coming into this state by way of alcohol beverage.
Well, Larry, I really, through you, Mr. Chair, Larry, I really appreciate your testimony regarding this. I tend to agree. And again, no one's going to like call us out and being super yay, bureaucracy, yay, filing paperwork. That wasn't what anything you campaigned on, nothing that I campaigned on. But if it's merely these outside forces filing this documentation and you guys being able to FOI it to see if there's any aberrations or things for concern, then I don't really see the downside necessarily, but I'll circle back with the department. But yeah, I guess I approach this from the perspective of, sometimes when I'm driving on the highway, I say to myself, I wish there were more state police on the highway because there's like tons of people speeding, right? And it doesn't mean that I want people to get arrested. I just think sometimes having a cop on the block deters people making bad actions. And I think if there's no mechanism out there, then as soon as that information gets out, yeah, all right, let's say 90% of the players are law abiding, but there's going to be a temptation with the almighty dollar to just push the limits. And if there's nobody watching over their shoulder, these out-of-state companies, why do they care about Connecticut if they can make more dough, right? And so I think that there's a lot of competing interests here, not the least of which is, yeah, it's an intoxicating liquor. It's quite dangerous. I mean, if someone's like going way over the limit and it's going to a house that there's access by minors or something else like that, who knows? But if we don't have the documentation at all, there's no ability to follow up if there's mischief afoot. So I think you raised a really good point, and I think it's worth considering. And it's great to see you. Thank you, Mr. Chair.
Thank you, Senator.
All right. See, no more questions. Thank you so much, Larry. Appreciate it.
Thank you so much. Enjoy your day.
Next up, we have Nora Gosselin, followed by Quinn Meehan.
Can you hear me okay?
We can, Nora.
Hi. Senator Maroney, Representative Lamar, and honorable members of the committee. My name is Nora Gosselin. I'm the Director of Resident Acquisitions at the Cooperative Development Institute, CDI, testifying today in support of HB 5226. CDI is a 30-year-old 501c3 nonprofit that helps residents organize, purchase, and operate the mobile home or manufactured housing communities where they live as affordable resident-owned cooperatives, which we call ROCs. We've supported the purchase of 66 different communities throughout the 5 New England states we serve, totaling over 6,600 households and over $327 million in financing. However, we've only had the opportunity to support one resident group here in Connecticut to successfully purchase their park, which is Ryder Woods in Milford. The reason a state like Massachusetts has 56 resident-owned communities, which is 23% of all parks in the state, and Connecticut has just 1% of all parks in the state, is simple. A strong right of first refusal statute that applies to any park sale, not just a sale that would result in a discontinuance. Resident leaders, legal advocates, and legislators on this call came together in 2023 to get the Connecticut statute, previously only applicable in the instance of a park discontinuance, strengthened into a broader right of first refusal, which was a really important step in a state where approximately 20% of all communities are owned by private equity and real estate investment trusts, including some of the biggest players like Sun and RHP. But there are critical limitations that remain in the law that need to be addressed. And today I'd specifically like to focus on portfolio transactions, which is Section 4 of the proposed bill. In the current statute, if residents receive notice that their park is being sold as part of a portfolio, they may submit a proposed purchase and sale agreement to the park owner, who must consider it, but is not bound to sell to the residents. A park owner is not required to give a price allocation for each property being sold, which can leave resident groups in the dark about how to respond to a sale notice. I ran into this last year working with the residents of Little Valley MHC in Norwich, which was being sold along with 5 other communities in the neighboring towns. Of the 6 total communities, only Little Valley wanted to exercise their right of first refusal. Their competitive purchase offer was rejected as they weren't offering to buy parks that they did not live in. An organized group of resident homeowners trying to exercise their statutory rights, offering good value for the property, was rejected and the community was sold to an out-of-state buyer. both Massachusetts and Maine, two states I work in, have specific practices or provisions in their laws for portfolio sales, which are incredibly common. In these states, when a community is being sold as part of a portfolio, the residents receive the specific price allocation terms and conditions for just their property and can submit an offer that is substantially equivalent to that price allocation. This, in my experience, does not blow up transactions as residents are still responding to the price allocation set by the competitive market. That is quite the buzzer. Thank you for the opportunity to testify in support of this bill. Thank you.
Thank you so much, Nora, for providing some context on what's happening in the mobile home unit place. So I think this is something that a lot of folks have experience with in different ways, and your ability to sort of look across multiple states, see what some of the challenges are in Connecticut vis-a-vis our legislation and what exists in surrounding states is really helpful. Interestingly, I've had a couple conversations this weekend with folks who were a component of the negotiations a few years ago, and sort of like took sort of a bit of an offense to the idea that there's a loophole in our current structure, that this was a very specifically negotiated language that understood the context of the marketplace and the financing terms, and this was the agreed to structure that we should operate under moving forward. And this provided an opportunity for most resident-owned communities to avail themselves of first right to purchase their homes, and that there were just a few select parks that would fall under the portfolio sale model. And I think the frustration I heard from folks on all sides was like, hey, wait a minute, like this, we reached an agreement, and now folks are coming back to renegotiate only one side of it. Could you provide some context to those conversations as you recall them, and what, like, where you think perhaps there's maybe an error or misinterpretation, or is that right? Are we really just living with an agreement, and maybe we should play this out a little bit longer because there isn't enough data yet to suggest that the current framework is failing?
Yeah, I think that raises a lot of good points. I think the law, having also been involved in it in 2023, and its drafting and working it all parties towards an agreement of a really important expansion of the previous statute, was like the law that needed to get passed, and has absolutely strengthened resident protections without a doubt. I think some of these minor things specific to the right of first refusal that are coming up now around protecting a financing period, and really getting a little bit more specific, almost nominally so, but meaningfully in the field, about giving price allocations to resident groups will do that extra step that comes from best practice that we see in other New England states. So Maine has it, and Massachusetts has it. Like I said, New Jersey actually has a version that they just got signed into law last month. And so I think these are minor things that will have impact, because portfolio transactions, in the last 2 years, year and a half since the original OTP was enacted, there have been the majority of communities that have come up for sale have actually been included in a portfolio. And so we see trouble when groups are energized, resident homeowners are energized to use these rights, but they haven't been given the information they need to actually come to the table as a buyer. So I'm of the opinion, and I know other people will speak after me today, that these minor changes to an already strong law will make all the difference for resident groups. And again, pull from practices that we find are really successful and are informed by the fact that the sales that have come up in, since 2023 have mostly been portfolio transactions.
Thank you. I appreciate the context. We have Representative Luxembourg, followed by Senator Kissel.
Thank you, Mr. Chair, and thank you for your testimony. I had recently gotten information, and I think it comes directly from the Department of Consumer Protection, that there have been 5 of these opportunities since we worked together on the 2023 law, and that 4 out of 5, the residents had the opportunity to exercise the right of first refusal to purchase the park and just chose not to do so. And only 1 of the 5 was a situation where there was a portfolio sale, in which case residents of those parks still would have had an opportunity to buy if they grouped together and partnered with your financing. They just didn't have the added benefit of the right of first refusal. And so I'm really, really interested in your testimony where you're saying the majority of these opportunities have been blocked by the portfolio sale exclusion, because I've gotten like basically the opposite information of what you just shared from DCP, that actually 4 out of 5 had the opportunity to exercise the right and were not blocked by the portfolio sale exclusion. So can you, maybe you can enlighten me and the committee on where the information's coming from that you're relying on that's suggesting that since the 2023 law, most of these opportunities have been blocked by portfolio sales?
Yeah, and I apologize, Representative Luxembourg, if I'm not being clear. I don't mean that they've been blocked. I'm just trying to hit on the fact that a lot of the sales that have received notice and come up have been included in a portfolio. And I'm specifically citing the one in the Norwich, those 6 communities that were all getting notice. And if I'm wrong about that, I would obviously defer to you and to DCP. That was my understanding. And I think there are some people coming after me today that can talk as well to this point. And I'd add that, one of the beauties of a right of first refusal is that it is a resident-driven law. So if a resident group is not interested, that's the roll of the day, and the sale proceeds on the same real estate transaction timeline that a park owner and a third-party buyer would want to see. So for some of those communities, they were either too small to really have the sustainability of the co-op model, and then some of them, there was not the resident interest. I personally met with some resident groups throughout the state where they just weren't interested, and that's what the law is for, right? To turn down if there's not the interest. And then other times there was infrastructure. One instance, there was infrastructure concerns that made the purchase and the financing and the appraised value not there. So I apologize if I'll be more specific. There just have happened to be a couple, parks come up in a portfolio sale since the statute was enacted.
Okay, I think we appreciate that clarification, because the data I've seen is only one out of the 5 opportunities has been part of a portfolio. One thing that I think all of us are trying to wrap our heads around is when you do have a portfolio sale, let's say there are several parks, and let's say the law was changed to expand this right and eliminate the portfolio exclusion. And one set of residents wants to exercise the right of first refusal. And in that case, it's blocking a sale of 3 parks or 5 parks or 7 parks because they only want to buy their park. One thing I'm having trouble wrapping my head around in that scenario that you wish to see enabled by a change in our law is how that would affect the existing lending side of that portfolio for the seller. So if you have a scenario where you have multiple different LLCs with multiple different types of owner structures, some people own parts of 2 parks, some people own part of one park, part of another, but there's a loan attached to all the parks, and you have one resident group upending the portfolio. How does that affect the portfolio lending side? Because you're in the lending business, so you might have an interesting perspective to educate us about that.
Yeah, just to clarify, I'm not in the lending business. I work for a nonprofit that does the technical advising, and we have partners that are the lenders. So part of my role is working on financing stacks, but I don't underwrite these transactions. Yeah, just don't want to misrepresent my skill set. I would say that in my experience, in Massachusetts, there's a long track record of this law dating back to the late 80s. And I've personally worked with resident groups through portfolio purchases. Sometimes, we'll see portfolio purchases. I worked on 2 in Massachusetts, 1 in Rhode Island, where all 3 resident groups independently came to the table to purchase just their park. So the seller there gave, price allocation for each park, and it was going to a third party as a portfolio, and each resident group exercised their right of first refusal at the price allocation that was set by, a bona fide third party offer. On the back end, I don't think I'm the best person to speak towards an ownership, controlling interest and the nuances of that. But in practice, what I've seen is that if the price is set by a third party and then, disclosed transparently to a resident group, they can exercise their right of first refusal at same price terms and conditions as the statute, whatever state it may be, states. Sometimes, and this is, I know there are differing opinions about this, if there is a portfolio where a resident group is pulling out or seeks to pull out one park of many. I've worked on one of those that was 8 parks over 5 New England states. And one group in Western Mass last year pulled their park out of a $90 million portfolio. I know that there are differing opinions about that and about the residents' right there. I think I'm of the mindset that with a price set by a third party and a price set by a seller, the residents are still paying fair market value and are able to close. They were the first of that portfolio to close on the purchase. They could do it expeditiously. So I think that's what I've seen in practice, I guess, if that answers the good point you're raising, the question.
Thank you. Appreciate the information. And thank you, Mr. Chair, for allowing the questions.
Senator Kissel, followed by Representative Martinez.
Thank you. And I appreciate the questions and responses that were generated by Representative Luxembourg. And I got to say, I wasn't part of this negotiation in 23, and it's probably best that I stay clear of this issue because it's not simple. But I just wanted to note that I come at this from the perspective of we have concerns as a legislature and as a nation regarding hedge funds buying up single-family homes. I've had problems in various parts of my district regarding apartments and quality of life there, as opposed to when there's home ownership, because home ownership, no matter the size of the home, tends to generate a greater attentiveness to property and upkeep and schools and neighborhoods and all of that. And so I think that my concern was that anything that would allow individuals to remain in their homes, whether it's a mobile home or something else, I think is beneficial. But I'm very cognizant of the fact that Chairman Lamar said, we just recently changed the law and let's see how it plays out. I guess the one question I would have for our speaker is, how difficult is it? When I look at foreclosures in the private sector, pretty much there's always an appraisal. When courts award appraisal fees, they're not huge, they're under $500. And I'm just wondering, when these portfolios are created and there's a set of units, do the appraisals get down as far as what individual mobile home unit is valued at? Because I can't imagine them doing an appraisal on the entire grouping without some sort of breakout, right? So I'm just wondering, like, how hard would it be to require at least that breakout to be given to the homeowner or the unit owners so that they can make an assessment together? Do you know? Through you, Mr. Chair.
So, do you mind if I answer?
Oh, no, of course. Yes, please go ahead.
So in my experience in working in this sector, these appraisals are done on a capitalization approach, looking at them as like a rental income generating business. So we don't actually look at home values of the individual manufactured units. It's looked at, and most commonly the appraiser that I've worked with in this sector is Colliers, who are pros at mobile homes and RV parks. They will look at it as, through a capitalization rate approach, looking at 100 units with this rent and area, rent comps and area sale comps to get to a park value. So looking at it as, 100 rent paying households with rent that is 10% below market or 10% over market, what have you, similar to, akin to apartment buildings. So that's, in my experience, when there is a price allocation given to a group of residents, it's based on a third party or a seller's own, estimate of value and financial modeling for the ability of the property to produce rent. And that's what sets the price, and obviously is informed by, age of park and quality of park and capital improvements and expenditures, what have you. That's what's given to the residents. And then the residents go through their own due diligence process once they're under contract, which involves getting their own appraisal. So that's what I've seen most commonly. We don't look at the values of the individual home units. And while the beginning of a portfolio purchase is a little bit different because they're given a price allocation of an overall lump sum, the rest of the sale process is identical, regardless of, whether the park was going to be included in a portfolio or was not, in terms of the due diligence, the appraisal, what have you.
Thank you for that answer. It's a complex area. One quick last question through you, Mr. Chair.
Please proceed. Yep.
Ms. Goslin, in your experience, when there is a portfolio sale or a sale of a group of mobile homes or similarly situated properties, is it necessarily the net result that these people lose where they're living? In other words, if we're doing it on a cash flow basis as to what kind of income these properties are generating, and that's the basis for the appraisal, as opposed to my sort of old-timey view of making it similar to a single-family house, then if I'm the purchaser, I'd probably want to maintain that cash flow and let everybody, maybe sign new leases or something like that. But I wouldn't want to kick them all out and bulldoze it and turn it into something else. And I'm just wondering what your experience has been with some of these portfolio sales where maybe the owners felt that, gee, if we had known more, we could have put a bid in or something like that. What is the consequence of that not coming to pass and the property being transferred to a new owner? Through you, Mr. Chair.
Nora?
In my experience, and I always like to stress this when I work in the field, park discontinuance and shutting down parks is very, very uncommon, as you're saying, because it's a good business model and it's much more effective for an incoming buyer to keep the park running as a manufactured housing community. So, when I work with groups of residents to consider the option of resident ownership, I tend to say, let's not keep that on the table. Of course, we don't know for certain an incoming buyer's intentions, but most likely the times that we see it were Ryder Woods, for instance, in Milford, or where Gillette Stadium is, that used to have a manufactured housing community. So those are very specific instances. The concern with portfolio transactions, in my personal opinion and experience, is that typically the buyers of large portfolios are not mom and pops. The local park owner is probably not coming in at the $100 million or $150 million, portfolio purchase. So what you see is it's an opportunity for these very large publicly traded REITs and private equity companies to really buy up a lion's share of a state's, stock of manufactured housing all in one go, which we saw with, the Jensen sale to Sun Communities. And so the things that come with that are the rent increases, which again, I'm speaking broadly. I know there are local owners that do great work owning manufactured housing communities. I'm talking about just the trends with the biggest players in the industry, where we'll see that they look at this sector and say, historically manufactured housing rents have been 30% of area 2-bedroom apartments. Let's close that gap to make it more like 50%, not considering that people are on fixed incomes, have mortgages, have other costs that are not always associated with renting. So I guess long story long, the thing that we see most common is the concern around rent increases when you have a big purchaser come in and buy up a whole swath of manufactured housing communities all in one go. Much more likely that that's going to be an out-of-state REIT or private equity buyer and not a local mom and pop.
All right. Thank you through you, Mr. Chair. Thank you very much for those answers. I've learned more about mobile home parks and these issues in the last 15 minutes than I've known in previous years of my life on this planet. So it's an interesting area. Having a district that many of my communities border Massachusetts, while it's amazing how that state line is like, it's just a whole different world, doesn't mean that people don't talk and that we're not a little bit competitive with the good Commonwealth to our north. That being said, though, the fact that this just was so recently changed in 2023, and then it's a short session, As much as I'm intrigued by this and I'm more than willing to dive in and try to see where we can go with it, it may be too heavy a lift for a short session, but I'm just one person on this. I'm just ranking file on this committee, but thank you so much for your answers, and thank you, Mr. Chair.
Thank you, Senator Kissel. I'm going to turn it over to the person who's educated me the most on this issue over the last about year and a half, and who's done an incredible amount of work to get us into a position where we, even though it is a short session, I think there's a pretty good chance that we come up with something this year. Rebecca Martinez, the floor is yours.
Thank you, Mr. Chair. First question I just had is, in your experience, can residents reasonably match an offer when they're not told the price of the park that they live in?
In my experience, no.
Okay, perfect. And then based on your work in Massachusetts and Maine, has requiring a price allocation stopped portfolio sales from occurring?
In my experience, no, it has not.
Is it accurate to say that residents must still match fair market value even under the stronger laws in neighboring states?
Yes, I've found that to be the case.
And just a couple more. You testified that Massachusetts has roughly 23% resident-owned parks, while Connecticut has only 1%. What do you attribute to that?
Massachusetts has had a right of first refusal since 1986. From 86 to 93, it was only applicable to a park discontinuance, and then in 93, it was strengthened into applicable to all park sales. And so because of that law and 30 years of it, there's 56 communities that have been purchased by the residents, and Connecticut's discontinuance right of first refusal was only changed in 2023. So I would say that's nothing else is different between the two states in terms of resident homeowners being interested in becoming resident owned besides that law, in my experience and opinion.
Great. And then when a park is sold as a portfolio of Massachusetts and Maine, do you know what specific information must be provided to the residents?
So in both states, they are given the third-party purchase and sale agreement signed, if such an agreement exists. Typically, if there's a question of disclosure, the third-party buyer's identifiable information is redacted, pretty common, but they are still given something that is the full price terms and conditions. So typically done through the purchase and sale agreement. And then if there is a breakout or a price allocation, they will see that for all properties, or at least for their own property. That's how I've seen it in Massachusetts and Maine.
And then just overall, would you agree that House Bill 5226 doesn't force a sale, but simply gives residents the opportunity to match an existing offer for their own community?
Yes, I would agree with that. I think it's a minor but meaningful change to an already strong law.
Thank you.
Thank you.
Excellent. Thank you, Representative Martinez. Ms. Gosselin, thank you so much for your testimony. There is a very high likelihood that I end up reaching out to you and a few others as we move forward, trying to figure out what we can do. Representative Martinez has put so much time and energy into the bill this year that I think there's a pretty good chance that we get something over the finish line, and I want to make sure I'm working closely with you to understand the full ramifications of what we have under consideration. So thank you again for your testimony today.
Thank you.
Next up, we have Quinn Meehan, to be followed by Diane Costas.
Thank you. Co-chairs, ranking members, and members of the General Law Committee, thank you for the opportunity to submit testimony in support of Senate Bill 227 in solidarity with Reproductive Equity Now. I am Quinn Meehan, a community organizing and policy MSW intern at Universal Healthcare Foundation of Connecticut. Universal envisions a world where justice prevails, health is respected as a human right, and equity is realized. Across the country, transgender people and cisgender women are facing severe barriers to accessing needed and in some cases, life-saving healthcare. In states where reproductive and gender-affirming care are restricted or banned, many patients rely on telehealth and mailed medications to access care from providers in states like Connecticut, where this care remains legal. However, without adequate legal protections, providers offering this care face legal, financial, and professional risks, reducing access for the people who need it most. These risks are not theoretical. This past December, the Texas Attorney General filed a lawsuit against a New York physician, alleging that she violated Texas state abortion laws by sending Texas patients abortion pills via telehealth. A month later, she was indicted on charges of criminal abortion by a Louisiana grand jury as well. Because New York has strong shield laws that explicitly protect telehealth reproductive care, she was able to maintain her medical license and was shielded from enforcement of a $100,000 civil penalty. Connecticut must ensure our providers are similarly protected from out-of-state retaliation for delivering lawful, essential care by strengthening our shield laws to explicitly protect telehealth services and enhance provider safety. The bill also allows prescriptions for legally protected care to list the healthcare practice rather than the individual provider. This simple change enhances safety without weakening oversight and helps ensure providers can continue offering essential services without fear of harassment. When providers face the threat of out-of-state lawsuits, professional discipline, or personal harassment, some may reconsider whether they can safely continue offering this care, particularly via telehealth. Over time, this reduces the number of clinicians willing to provide this care to those without access. And additionally, if providers lose their licenses or face enforcement actions because of care that is lawful in Connecticut, our own residents would lose access to trusted clinicians. Both gender-affirming and reproductive care rely on continuity, and when providers withdraw services due to legal risk, patients experience delays, disruptions, or even forced discontinuation of care, which can have serious physical and mental health consequences. If Connecticut does not strengthen its protections, we risk fewer providers offering this care, longer wait times, and increased barriers for patients who already struggle to access care. Connecticut has long been a leader in protecting access to care, including being the first state to enact shield laws, and this bill builds on that leadership and ensures our protections keep pace with growing interstate legal threats. Universal urges the General Law Committee and the Connecticut General Assembly to pass Senate Bill 227 to protect providers, safeguard patients, and uphold health as a human right. Thank you. I'm open.
Thank you for your testimony, Quinn. I really appreciate it, and specifically trying to give specific examples for folks who've had questions about why we're doing this, the importance of doing this, your ability to highlight very real world scenarios that could and can and have taken place across the country is really useful to that conversation. So I want to say thank you for your testimony today.
Thank you.
Are there any questions? Seeing none, thank you so much for your testimony.
Thanks so much.
We have Diane Kosis, followed by, the floor is yours.
Oh, I'm sorry.
That's
Here,
all
I'll
right.
turn on I guess I turn my video on too. Hello. I'm dressed for outside, so
Well,
my apologies.
Hopefully you got your shoveling done already, because it's
No, I still got to go back out. I had you with me the whole time. I was out there this morning. Okay. All right. Thank you, Chair, for this time and this opportunity. I'm just going to read what I've written into my for my testimony. And my name is Diane Kosis, and I live in Southington, Connecticut. I am here today in support of HB 5226. It's the act about the mobile manufacturing homes. And I want to let you know that I'm trying to speak for a number of my residents who cannot or find it a little difficult to speak today. So my big thing is empathy. And this is what I kept hearing over and over from them. It is essential empathy for building relationships, trust, and providing comfort. The company owning our mobile home parks reaps a heavy profit off of the backs of the elderly individuals. They are also owners of a few luxury businesses, such as yacht clubs and golf courses. And we wonder why they couldn't have a little empathy and get their profits from the luxury items to satisfy their shareholders. On a fixed income, our park elderly must endure town tax increases on the value of our old homes that aren't mobile, and neither are my neighbors. Insurance rate increases, both health and home, rising prescription costs, energy, and food, basic food costs. And then we have unfair rent lot fees. Where is the empathy? There is a type of empathy that I want to bring to your attention. It's called compassionate empathy that helps us identify with our own humanity. It's just a thought to consider. Thank you, everyone.
Thank
you
you
have
for your
any questions.
testimony, Diane. I appreciate it.
Okay.
I'm just trying to read through some submitted testimony today to kind of get a sense for folks.
Mhm.
And you've kind of hit it. Like, there's this feeling of like we don't have control over the outcome. We don't know if people are listening to us. We don't understand what the potential for increase in cost basis might be over the coming years. And so it's a similar refrain throughout the submitted testimony, and I really appreciate you putting voice to that today. We have a
Okay.
question from Representative Luxembourg.
Sure.
Thank you,
Hello.
Mr. Chair, and thank you for your testimony. You mentioned the lot fee increases
Yes.
being unfair. Can you educate us, like, on a dollar per month basis or on a percentage increase basis, how much those lot fees have gone up every year for maybe the last 3 years, the last 5 years, whatever time frame you think is sort of a representation of the lot fee increases that you've experienced, so that we can understand sort of what that pain looks like from a lot fee increase perspective annually.
Okay, so I guess what I'll try to do is do it from my personal experience, which is I've been here for 9 years. My home and my mortgage is paid for, and my taxes on a yearly basis. And I pay to Sun, when I first moved in, like $425 a month. It is now going to be increased to $645 per month. So it has gone up significantly. When you're on a fixed income like that, people can't afford it. And their taxes are going up this year because the value of the homes have gone up now. So they're struggling to get all these other things that are increasing as well, and these lot fees, when I understand they need money. I get it. I know but how much does their shareholders really need? And why is the CEO of Sun Communities being paid $10 million a year? You know,
Okay.
It wouldn't take much here to help us. Cost of living and 1% over increase to give them a profit. I just don't see why they have to get their profit off of our backs. I don't know if that gives you perspective.
Just so I understand, so that's like over a 9-year period you're talking about.
Yes.
It's gone up about 40% in total over a 9-year period. So maybe something like your rent fees have gone up, if I'm doing my math correctly, something like 3 to 4% a year, which is like basically equal to or lower than inflation over that time period. Is that fair to say?
Yes.
Okay, I
would
just
say
want to
that that's fair.
understand, you know,
But you know, when you get a fixed income on Social Security, which most of these people are, you know, having to squeeze that cost in every year is real hardship. And I don't know. I'm sorry, but it's hard to try to describe that, you know, a little bit of money here in these people's pockets, if they can save $10 even a month, and the increases it would be significant for them. And you're welcome to come here to our community, by the way, and meet these people if you want.
Thank you for the invitation, and thank you for your testimony. Thank you, Mr. Chair.
Next up, Representative Martinez.
Hi, Rebecca. Did you have a question, Rebecca? I can't hear you.
Rebecca, you're still on mute.
Oh, can you hear me now?
Yes, I can
right.
hear you now, Rebecca.
Perfect. I know I met Diane when I was walking through campaigning, as this is my first year in the legislature, but I met many of the residents and sons in my other profession as a nurse, where I would go in and see patients, and I would hear very regularly about their concerns of being able to pay their fees and balance their costs of groceries and prescriptions. Now, just to make it clear, this is more like a land lease, correct? If something breaks in your home, who's responsible to fix it?
I am.
Who's responsible? But do they do things like shoveling your driveway, things like that?
No, I do that. That's what I was out doing now. I also have to maintain the lawn. So there's costs related to that as well.
Right. And do you pay property taxes on your home?
Yes. As a matter of fact, my home was assessed at $71,000 and they have now gone up to $135,000 they've assessed my home at. So that's going to be like a double in my taxes if they don't change the mill rate to help us. So I don't know where my neighbors are going to find that kind of money to pay their taxes this year.
Understood. And
I will dip into my savings to do that.
right. And now if the rate went up so high that you couldn't afford to stay there, how easy is it for you to move?
Can't. I mean, this is called a mobile home, and it's got a skirting around it. And if you look under there, you can see, you know, odd things, how they got it here by wheels and stuff, but they're not mobile. That you know, it would cost $20,000 or more, depending on where you were going, just to move this building that I'm on. So that's not mobile. You consider it like an apartment. You can't take it out of the building and put it someplace, you know?
Right. And I know with our
Yeah.
conversations, you'd prefer to see a rent cap because of these hikes and these differences. But I am hoping that this legislation will be able to at least give you guys access to a board that would be able to understand all of these differences and why the lower percentages are so different than apartments and all of the different issues that you all face. So I thank you so much for coming out in your testimony today.
Yeah. And I think that's the point, though, is that I don't think people really understand what these manufacturer homes are. And that's kind of seems to be the problem, that they don't see that and they don't understand what it is that how we live, what we do, and what we have to pay for. And it's just hard when I see the millions and millions of dollars that some community is making, that a little investment over here could really help. So thanks, Rebecca. Thank you for all of your help.
Absolutely.
And caring about the caring about these people. They're trying to do the right things.
Diane, I think we have one more person. Representative Acker, you have questions for Diane?
Yes, thank you, Mr. Chair. And Diane, thank you for being here and discussing this with us. I truly appreciate it. Did you just say that your property tax on your, as you described it, not so mobile home, was in the 130s? Does that include the land also? Is it, or is that by?
No.
That's what I was thinking. So
no.
Alone, it's 130. What town is this again?
Southington.
Southington.
And it went from assessment of about $71,000, and now it's assessed at $135,000. Now these mobile homes, unfortunately, they've gone through the roof. You know, when it comes, people are buying them and they're paying. I mean, I'm flabbergasted that a home near me, but same size as mine, which is only about 1,000 square feet, sold for $245,000.
That's
and I'm like, what?
Thank you for that information. Truly appreciate that. And thank you, Mr. Chairman.
Thank you. Thank you so much for your testimony today. I really do appreciate the insight that you gave us and the voice you gave us to a lot of folks who are submitting testimony. I appreciate that.
That's right. Thank you so much. I really appreciate it, guys.
Good luck with the shovel.
All right. Thanks. Yes, I'm going back out. Thank you.
Next up, we have Lucy Cardenas, followed by Robert Marriott.
Lucy, if you would please accept that invite to be a panelist so we could see and hear you. I'm seeing a message that she declined, but it looks like we have number 19 with us. Robert Marriott?
Yes. And he is definitely comfortable using the Zoom technology, so he should be joining us.
Shall we get started?
There we go. The floor is yours. Good to see you again.
Thank you. Chairman, ranking members, and members of the committee, I'm Robert Marriott, the Vice President for Regulatory and Government Affairs for the American Herbal Products Association, or APA. Regarding bit raised bill 227, APA's comments and opposition on this bill are exclusive to the material in Section 1 as raised. APA has also submitted written testimony that covers a broader range of subjects. We're also aligned with testimony that you've either received in writing or will be hearing today from the Council for Responsible Nutrition, the Consumer Healthcare Products Association, the Natural Products Association, and the Connecticut Food Association. SB 227 Section 1 does not address the harmful marketing or social media material which proponents for the bill identify as the cause, the driver of eating disorders, what Ms. Ayaz earlier referred to as skinny talk. For the avoidance of doubt, we're not a part of that discourse. Our members don't see kids as a target demographic for their products. Our concerns here are because of the costs associated with compliance with the bill and because of the potentially misleading and incorrect impression it could give that a whole range of dietary supplement products are broadly unsafe. Our written testimony covers a lot of this more broadly. What I'm going to focus here is the practical issues created by the scope of the bill as introduced. As defined at Section A1, and especially under the factors analysis at subsection G, the coverage the bill provides is extremely overbroad and also vague about what products would be subject to the proposed restriction. DCP and the courts would in practice have to perform a case-by-case analysis to figure out what sort of communication about either a product or its ingredients, every product, every set of ingredients, would count for the purpose of this factors analysis. This is made more complex because many well-studied and safe dietary supplement ingredients, creatine being a great example, are marketed for multiple purposes, weight loss and muscle building, and completely unrelated things like skin health. As written, inclusion in the same area of a store or the use of an image of an athlete on a product label might be enough and probably would be enough to put a product under the age restriction scope. In practice, regulated industry will also have to guess at what products are subject to this coverage. And in the process, consumers are going to be confused by the inconsistent application of these restrictions by regulated industry. There's going to be a strong incentive for retailers to just remove products from their shelves rather than deal with these uncertainties. Now, bill language like the material found in Section 1 has been introduced, not moved forward in a whole bunch of states. There's one law on the books in New York. To my knowledge, it hasn't been enforced. These practical problems of scope are a major reason why this is an issue. It winds up costing a great deal of money to regulators too. For all these reasons, we must respectfully oppose. There's a serious problem here with eating disorders, but this sort of product level restriction, it's just not a good fit. I'll just also say with the time, our president is in rural New Hampshire, so we are with you in our snow shoveling sympathies. Thank you.
Thank you for your testimony today and for at least meeting us where we are. Like, we're trying to respond to something very serious. We think the proposal certainly has merit. I do appreciate the concerns and the reach that you think would make it difficult to implement here in Connecticut. But we will be working with advocates. My Senator co-chair, who's behind pushing for this issue, I think has a few questions as well. But I would say that, like, I do believe that there needs to be stronger regulatory oversight and or structure into the marketplace. Even if we don't end up in the space that this bill currently proposes with the current language, I have a feeling states like ours are going to look at what we can and should be doing in this space. So your continued correspondence with the committee would be useful and helpful as we go through that process, because it's not going to surprise me if there is something that emerges as a consensus at the state level in the very near future. With that, I'll turn it over to Senator Maroney.
Great. Thank you very much. Thank you for your testimony. And as Representative Lamar mentioned, we look forward to, working together with you to try to, achieve the objective of making sure, which I think we all agree on, is protecting kids, right? And so, but understood on products like creatine that have multiple uses and others. Now, this law is in effect in New York State, I believe. And so, can you just talk to any differences in their law that make it easier to comply with than what we're proposing? And I do understand a few other states have proposed this, but New York is the only one to pass it, to my knowledge.
Yeah, my understanding is also New York is the only place with the law in the books. There's litigation ongoing about the law, though I don't think that there's been a pause in nominal effect. I've been running record searches regularly. There's been no enforcement of the law. So it's very difficult to draw clear conclusions. In practice, members are either removing products from retail if they're going into the state of New York to the degree that their websites can handle that. They're trying to reclassify products so that fewer things get caught up in the scope, but there's just a lot of uncertainty until we see some kind of enforcement pattern.
Great, understood. All right, thank you very much. And, I will be reaching out as we move forward.
Thank you, Mr. Merritt, for your testimony today. Next up, we have Levon Price, followed by Tyler Semro.
Hello.
Levon, how are you? Good to see you.
Good to see you too. How you doing today? Let me just get straight into it. Good afternoon, members of the General Law Committee. My name is Levon Price, and I'm a West Haven resident working as a licensed cannabis delivery driver for Cannabis Connection Delivery. I am writing to respectfully express my concern regarding proposed changes to Connecticut's cannabis laws that could impact third-party delivery services in SB 231. This job allows me to provide for my family. I love the interaction and care we provide each customer, medical or recreational, and I enjoy working for Cannabis Connection, a company that goes the extra mile to make sure elderly or handicapped patients can remain in the comfort of their homes while their medication is delivered. Every day, we operate under Connecticut's regulatory standards to ensure safe, secure, and compliant delivery. I respectfully ask that you consider the impact this change will have on working families like mine. Thank you for your time and consideration. Respectfully, Levon Price.
Thank you, Levon, for your testimony here today. And I think there's some conversations that you and I, members of your industry, are probably going to need to have. I think I understand where the Department of Consumer Protection was originally coming from with this proposal.
Yes.
Kind of evaluating where the impact is going to be felt, I do have some concerns. So I thank you for putting voice to that. And
You're welcome.
I appreciate your testimony today, and we'll probably be in contact moving forward.
Thank you, Representative Lamar. Appreciate it. And everybody else on the committee or assembly. Thank you.
Thanks again.
You're welcome.
Tyler Semro, followed by Chris Erb.
Yeah, good afternoon, Chair, and members of the General Law Committee. My name is Tyler Semro. I'm a resident of East Hampton in the 34th District. Thank you for the opportunity to testify on SB 231. I want to begin by saying I support reasonable, common sense, and science-based regulation of cannabis. Consumer safety matters, product testing matters, market integrity matters. However, my concern is that many aspects of cannabis regulation, including parts of this bill, still appear rooted more in decades-old stigma than in modern scientific understanding of the cannabis plant. Regulations should be proportionate, fact-based, and mindful of the impact on Connecticut small businesses. Cannabis is not a monolithic substance. It contains dozens of cannabinoids with varying effects, and we now understand that the human body has an endocannabinoid system that interacts with these compounds. Peer-reviewed research continues to explore both potential risks and measurable therapeutic applications, including pain management, sleep support, and other conditions. In addition, cannabis and hemp derivatives have expanding applications in agriculture, sustainable materials, and other industries that contribute to economic development. Regulation should reflect current science, not the remnants of outdated mindsets that treat all cannabis as inherently dangerous without distinguishing between dosage, delivery method, or cannabinoid profile. We should also be mindful that over-regulation can unintentionally favor large operators or competing entrenched alternative industries while pushing out small businesses that are acting in good faith, thus limiting innovation and societal progress. Connecticut has the opportunity to become a national leader with thoughtful, science-based cannabis policy that protects consumers without perpetuating outdated narratives or responding to pressure from competing industries. It is also important to recognize that when regulatory barriers become too high or too costly, market activity does not simply disappear. It often shifts outside of the regulated system. That outcome undermines the very goals of legalization, including customer safety, tax revenue, and social equity. If our objective is to bring legacy operators into a transparent, compliant framework, then the pathway into that system must be realistic and sustainable. Reasonable regulation is not no regulation. It is regulation that is informed, balanced, and based on facts. Thank you for your time and consideration.
Thank you for your testimony, Tyler. I appreciate you reaching out on this bill, and I imagine I might see you again next week as well. There's a bill that kind of represents where advocates have had numerous suggestions over the last year and a half that I've been chair of this committee. I'm hoping to reflect a lot of that in the bill that we'll have under conversation next week. Ultimately, the answer may lie somewhere in between, right? We have to, I think you're on to a point that, well, maybe I'm not fully there, that we have to figure out a way to get all legacy providers into the marketplace. I do think that there's got to be some balance between a regulation-based program and a program that is responsive to the needs of Connecticut residents. And I think trying to find that balance has been the work that this committee's tried to undertake for a long time now. And maybe the weight is too heavy in one area versus another. And so I think a proposal we have next week may elicit some more conversation about how we rebalance the structure of our program. And I hope you'll be a part of that as well. So with that, Tyler, thank you again for your testimony today.
Thank you.
Next up, we have Chris Herb, followed by Robbie McCluskey. Chris, I apologize. I always want to not pronounce the H in your name. I don't know why, but
Big H.
I always correct it the second time I say it.
Thank you. My name is Chris Herb. I'm the president of the Connecticut Energy Marketers Association. We represent 600 family-owned heating oil and propane dealers in Connecticut. And those companies are full-service companies. We employ the vast majority of the 11,000 licensed professionals in the heating and cooling space. And so we did not submit testimony, but we are in support of SB 105. But my comments today will be catered to sections 8 and 9 of House Bill 5222. In section 8, and I know there was a very productive question and answer with the commissioner in the beginning, and I thank Representative Acker and others who ferreted out some confusion in what the language could mean versus what it actually does. But in section 8 specifically, it appears, and I think it was confirmed, that the Department of Consumer Protection is going to adopt the current practice of allowing P license holders to install tanks. We just want to make sure, and if you look at that line 204, we just want to make sure that the addition of the words petroleum, I believe it says petroleum products and alternative fuels, does not expand the scope of the license to include the installation of heat pumps or boilers or furnaces. I don't believe that the plumbers want to do that work, but we can see where the interpretation of that language could go. So we do accept and support the department's codifying current practice with the installation of tanks. In section 9, this language limits contractors to use their license number to the company that issues them a W-2. This is long overdue. The department is enforced against people renting or selling their licenses. You literally have a person living in Boca and he's the license holder of record for 6 or 8 companies in Connecticut. It's just ridiculous. We've made complaints over the years, but unfortunately it happens a lot. So we think that that's good. The problem is that I have many of my members own multiple companies, and they are separate corporations where they use their license number as the contractor of record. The commissioner, I thought on that question when asked, but did give the right answer. We just want to make sure that when this language passes, that there is no confusion that if you own multiple entities, that license, even though you're not receiving W-2s from all those entities, that license holder, being the owner of multiple companies, will be able to use that license across all of those companies. And that concludes my testimony.
That seems like a very important clarification and assurance to make here, so I appreciate your testimony. Are there any questions for Chris? Seeing none, thank you again for providing that clarification. We'll get to work on it.
Have a good day.
You too. Robbie McCluskey?
Chairman Lamar.
There you are.
Thank you, Chairman Lamar, Chairman Maroney, distinguished members of the committee. Thank you for the opportunity to testify today. My name is Robbie McCluskey. I'm testifying on behalf of the Consumer Healthcare Products Association, representing the manufacturers of dietary supplements, over-the-counter medications, and over-the-counter medical devices. I'm testifying in opposition to Section 1 of Senate Bill 227, which would restrict the sale of certain over-the-counter drugs and dietary supplements intended for weight loss and muscle building to individuals under the age of 18. Our primary concern is the bill's expansive definition of dietary supplements for weight loss or muscle building. That language could sweep in products that are not marketed for those purposes at all. For example, products formulated for bone health, cardiovascular support, or antioxidant protection may contain ingredients such as creatine or green tea extract, and these ingredients have a wide range of uses and are not exclusively tied to weight loss or muscle enhancement. By focusing on certain ingredients, rather than product intent or marketing, the bill risks capturing a broad array of mainstream products. This creates confusion for retailers, compliance challenges for businesses, and unnecessary access barriers for adults. We are also concerned about the redundant age verification requirements for home delivery. Age verification at the point of sale is already a well-established and effective practice. Requiring additional ID checks upon delivery would create logistical burdens, particularly for working adults who are not home during standard delivery hours. Common carriers are not structured to perform age verification for products in this category. Imposing that requirement could disrupt home delivery systems and potentially lead some carriers to opt out of shipping these products altogether, limiting access even further. It's important to note that similar legislation has been proposed in other states, but is facing significant challenges. New York, as mentioned earlier, is the only state to have adopted such age restrictions, and it is currently involved in litigation on their law. California also vetoed similar restrictions in the past, citing the challenges of enforcing such measures. So in closing, we respectfully urge the committee to reject Senate Bill 227 as currently drafted, to work with stakeholders to develop a more precise solution that protects minors without unintentionally limiting access to important healthcare products. I will be submitting written comments as well, but I thank you for your time and consideration today.
Thank you for your testimony, Robbie. Please do. I was looking for your written testimony just to kind of have a chance to review that as well you're speaking. If you can get that to us, that'd be great. The link will remain open for a short time after the hearing. So if you could send your written testimony, that provides an opportunity for members of this committee to reach out to you if they have any further questions. With that, we have Senator Maroney.
Thank you very much, Representative Lamar. Robbie, thank you very much for testifying. And agreed, it is, I think there are products or ingredients that have multiple uses, right? Are there that you're aware of? The other thing is, we know that products come on the market, things change quickly. So once you put things in legislation, how do you remain flexible or go with the most current understanding, right? I think with creatine, they're discovering new uses for it, right? Are you aware of any government list of, I guess, products of concern or of things that, again, other than, I guess, FDA approved or FDA testing, other ways that we can look to try to identify harmful products?
Yeah, that has been the big challenge, I think, for states coming into this, is there's no, federal product listing, for example. There's no FDA list of products. There's in Maryland, actually, there was a bill for a couple of sessions where the Department of Health actually came out and opposed the bill because they would be the ones tasked with putting together a list of problematic products, and they are like, we don't have the bandwidth, we don't have the expertise, and such an undertaking would be really, really challenging. So yeah, I think that you're correct in identifying that as a major hurdle, and I think that's been the case in a few states because there isn't just a list that can be pulled from.
Okay, great. Thank you.
You got it.
All right. Thank you again, Robbie.
Thank you, sir.
Alyssa Romero, followed by Dr. Margot Main.
Hi, can everyone hear me?
Yes, we can.
Okay, thank you. Good afternoon, Mr. Chairman, Vice Chairs, Ranking Members, and members of the General Law Committee. My name is Alyssa Romero, and I'm here on behalf of the Connecticut Statewide Fair Rent Commissions Network. which encompasses commissioners, municipal staff, and community partners working every day to uphold Connecticut's fair rent protections. I'm here to speak today on House Bill 5226. We appreciate the committee's ongoing commitment to strengthening tenant protections, especially for residents of mobile manufactured homes. The network does not oppose House Bill 5226. Our goal is simply to raise several areas where clarification would ensure the bill functions smoothly and avoids unintended disruption to existing fair rent commissions. First, the bill authorizes the creation of regional fair rent commissions, but it's unclear whether these regional bodies must be formed through just the Council of Governments or whether towns may form regional commissions through other interlocal agreements. Because the COGs vary widely in size and capacity, clarity on this point is essential for planning, staffing, and budgeting. Second, we ask for clarification on what happens to existing municipal fair rent commissions if a town joins a regional one. Many municipalities have invested significant time and resources into building their commissions, and current statute already allows them to hear mobile home matters. We encourage the committee to make clear that the towns may retain their municipal fair rent commissions unless they choose otherwise, so residents may continue to have accessible local options. Third, we want to avoid confusion about jurisdiction. As written, it's unclear whether a complainant who receives a ruling from a municipal fair rent commission could then bring the same matter to a regional fair rent commission or vice versa. Clear guidance on how these bodies interact will help prevent duplicative hearings, inconsistent outcomes, and forum shopping. Finally, because fair rent commissions sit at the intersection of municipal capacity and state statute and community need, the network respectfully requests the opportunity to partner with the committee as this legislation moves forward. We would welcome the chance to share practical insight from commissioners and staff and to help refine statutory language so the bill strengthens, rather than complicates, the fair rent system in Connecticut. Thank you for your time and your leadership on housing justice issues. I'm happy to answer any questions.
Thank you for your testimony. I do appreciate the thoughtfulness that you put into the concerns and how this would ultimately play out over the next few months before it gets put into legislation. There are some questions that I think we'll have to provide greater clarity to you so that you don't see the risks that you're worried about come to fruition. Representative Martinez has handled much of the negotiations and development of the bill to this point. I'm going to turn it over to her for a few questions, but I will say, being in contact with her as this develops over the next month or two is probably your most useful way, because she's going to be dealing with a lot of the day-to-day of this bill development. So, Representative Martinez.
You're muted, Representative.
Rebecca, you're muted again.
Sorry about that. Thank you so much for coming on and sharing your concerns. I definitely look forward to speaking with you more in depth about them. I did just have a couple of questions. Do you think it would be beneficial for a board to be given education or a little bit more knowledgeable on issues that pertained only to mobile home residents?
I think that makes absolute sense. I think it would be great, especially if you have members or commissioners who are not entirely well-versed on mobile home matters.
Great. And I have been talking to Prague, and I'm looking forward to further conversations. And I think that's a big point of the public hearing. But I think a lot of this bill is getting to the point to ensure that people living in these manufactured mobile home parks are really seen and heard with their legitimate concerns and things that really come to park residents as opposed to, say, apartment renters. So thank you so much for your testimony today.
Thank you, Representative.
Thank you very much, Representative Martinez. Okay, I don't see any further questions, so we'll thank you again for your testimony. We'll definitely be in touch with you as we move forward. Next, Dr. Margot Main.
Am I on?
Yes, you are. Please proceed.
Hi, I'm Dr. Margot Main, a psychologist who lives and practices in the greater Hartford area. I'm here today to urge the members of the General Law Committee to support Raise Bill 227, an act concerning prescription drugs and over-the-counter diet pills and supplements. I have dedicated the past 4.5 decades of my profession to the pursuit, to the prevention and treatment of eating disorders, developing clinical programs, treating patients, and educating the professionals and public across the country. Over these years, eating disorders have increased dramatically, now affecting as many as 10% of young people. During this time, media and cultural pressures have contributed to eating disorders, but the recent growth of eating disorders and the recent growth of social media have made it a much worse problem. The pressure to have the perfect body creates vulnerable victims for the weight loss and body change industries. School-age kids spend upwards of 7 hours a day online, constantly exposed to the marketing of these supplements. They don't know the risks that come with this promised perfection, like hepatitis or organ failure, liver failure, and other medical issues. Some of the things that they take have chemicals that have never been tested on humans. In reality, over-the-counter diet pills and body-altering supplements have become gateway drugs for eating disorders. Girls who use diet pills are 6 times more likely to develop an eating disorder. And today, 35% of teenage boys use supplements to alter their physique, increasing their risk for an eating disorder or anabolic steroid abuse. Eating disorders are potentially deadly. Medical issues and suicide are often the outcome. In fact, in the United States, an eating disorder kills someone every 52 minutes. I am here because I have lost patients to these disorders. Bright young people who were loved by their family and friends and teachers, but who believed the messages that the products promised, that they would feel better about themselves, that people will like them more, and they'll be successful if only they change their bodies. These over-the-counter meds are particularly dangerous because people believe they must be safe. After all, they're over-the-counter. It is true that we need to stop the stalking of otherwise healthy, vibrant young people by these money-making industries. Eating disorders should not be a growth industry. We need to make it harder to die from an eating disorder. Please support Bill 227, an act concerning prescription drugs and over-the-counter diet pills and supplements. You might save a life.
Well, very well timed. You made it right just as the 3-minute alarm came up. Yeah, Dr. Main, thank you very much for your testimony. Representative Ritigliano has a question, and then I may have a question or two after you go.
If you'd like to go first, Senator, you could.
No, you go first.
I was going to ask the good doctor, I really appreciate your testimony. Can you tell me, should be more concerned about a pharmacy or like a CVS type of situation or a vitamin store when it comes to products like this?
You can buy them either place. It really, they're available everywhere. I'm not sure it's one or the other.
You're not sure it's one, but both of the types of products we're looking at possibly access to could be found in either store?
Yeah, I mean, and the bodybuilding things are available, in health food stores, supplement stores, everywhere on the internet.
And have you found, this might be slightly off topic, but since I have you here, I'd love to ask you if you found any recent increase in certain conditions associated with higher levels of THC consumption?
I personally have not found that. I'm not sure. I would have to ask my colleagues.
All right. Thank you.
Yeah.
Thank you, Senator.
Thank you. Dr. Main, I guess I have a few questions based on more on previous testimony than on your testimony. Is there a source that we could look to when we're trying to decide what products should be age gated, or and then the follow-up question to that is going to be, are advertising restrictions just as important as the product restrictions, or do we need them both?
The research on advertising restrictions has been a disappointment to me because it hasn't found that if you restrict the ads and you restrict visibility of those ads, that it makes a difference. But I don't think we've done it long enough to really have a good assessment of that. I think one of the things that we have to remember is that the kids swallow this stuff hook, line, and sinker. They are desperately trying to define themselves, trying to be better than everybody else, trying to find a place in the world. And a product that makes it look good will be very, very attractive to them. So we have a lot of work to do, that's for sure.
Great.
I wish we could legislate away eating disorders. We can't, but we can make it a little bit harder to get the things that contribute.
Thank you. I don't see any further questions. And you've submitted your written testimony?
I didn't, because this came up very late in the week last week. I'm going to submit it tomorrow.
Okay, good. Please
Is
do
tomorrow
so.
okay?
Oh, yeah,
Okay,
that's
good.
fine. Anytime
Yes.
up until we vote on the bill is fine. But
Okay,
I think
thank
we'll
you.
be referring to it in the next week or two when we look to modifications we may have to make to the
Yeah.
bill to vote it out of committee. So
And I certainly am available if you have more questions.
great. Thank you very much.
Thanks.
Okay, next is Theodore Conrad.
Can you hear me?
Yes, we can.
Great. Thank you, Chairman, members of the committee. My name is Ted Conrad. On behalf of the Natural Products Association, the nation's oldest and largest trade association representing the dietary supplement industry. We represent more than 500 companies committed to producing safe, high-quality products for American consumers. We respectfully oppose Senate Bill 227. Dietary supplements are not unregulated products. They are governed by a comprehensive federal framework established by Congress under the Dietary Supplement Health and Education Act and enforced by the Food and Drug Administration. Under federal law, manufacturers must comply with strict good manufacturing practices. Labels must disclose ingredients and quantities. New dietary ingredients require a pre-market safety notification, and the FDA has full authority to remove unsafe products from the market. This is a robust regulatory system that has functioned nationally for more than 30 years. Supporters of Senate Bill 227 suggest that certain weight management or muscle building supplements are contributing to eating disorders among minors. That is a serious claim, and serious claims require serious evidence. The FDA maintains national adverse event reporting systems specifically to detect safety signals. If these products are causing eating disorders, those signals would appear in federal data. They have not. NPA submitted Freedom of Information Act requests to the FDA seeking evidence of such a connection. The agency's records did not establish a causation between lawful supplements and eating disorders. Public policy should be driven by evidence and not by assumptions. Senate Bill 227 would restrict access to ingredients that are naturally present in everyday foods, including creatine and amino acids. These are among the most extensively studied nutritional compounds in the world. Restricting these ingredients in supplement form while they remain available in conventional foods creates regulatory inconsistency and consumer confusion. It also fragments the national marketplace that Congress intentionally structured to be uniform. When states create their own definitions and retail restrictions for federally regulated products, they undermine regulatory coherence and burden small businesses, particularly independent health food stores and pharmacies. If there is a safety issue, the FDA already has authority to act. That authority is clear and well established. NPA strongly supports enforcement against illegal and adulterated products. But this bill does not target bad actors. It restricts lawful products that millions of Americans use responsibly. This bill is a solution in search of an unsubstantiated problem. For these reasons, we respectfully urge the committee to reject the bill. I thank you for your time and consideration.
Great. Thank you very much.
Thank you.
Are there any questions from the committee? I see Senator Ciccarella has a question, and then I may have a question or two.
Sure.
Thank you. And thank you for testifying. I just have a couple of quick questions. So there are certain products that have been, I guess you could say, banned. And this is going back years when I was in high school. So it was quite a while ago. In wrestling, a big concern is keeping your weight down. And I know there was hydroxycut and Excedrin, and there was a supplement in there that would probably speed up your heart rate or allow you to burn fat and lose weight faster. And I do believe that those were taken off the market. I'm not sure if you're familiar of any other supplement or products that were taken off the market because of proven health concerns to the users. Are you familiar? You said there's an established guidelines that the FDA
Sure.
is paying attention and looking and then addressing any concerns.
Yeah. I don't have a list in front of me, but I'm aware of the supplements you referenced at the beginning of your question. But I'm happy to get that information and submit it to the committee for review.
Got it. Okay. Yeah, that may be helpful just to realize that when there are certain products that have that very serious
Absolutely.
health implication, that it is being addressed. And I guess I have another question that when there is maybe someone 16, 17, maybe a wrestler trying to lose weight, they go to the pharmacy and they may try to buy something over the counter. Do you believe by regulating this in this way that it may attract a younger generation to go maybe to the black market or try other things to lose weight that may create maybe an unattended risk?
Absolutely. And you see that with the number of things that, when access is restricted, a black market is created. And, when things are on the black market, they're inherently less safe than what is currently being regulated by the FDA. So, yes, that would be a concern.
Excellent. And then just last question. I heard a couple of people that were providing testimony say hepatitis was a concern. Have you heard of that, and what supplements would?
I have not. That was something that struck out to me as well. We'll definitely do some more research on it, and we'll be happy to provide some information to the committee.
Okay. All right. Well, thank you very much for taking time to testify and answering my questions.
Thank you very much.
Great. All right. I guess I have, my question is your opposition more to the reporting requirements or to just not to the age gating of this sale?
It would be both. It would be both. But certainly, restricting age, when it appears to be that, when we talk about, skinny talk and things like that, addressing the root of the problem as opposed to products that have proven to be safe, that are already very much regulated by the FDA, which has authority to ban them or pause the sale of them under review. According to FDA records, there isn't a causation between these supplements and eating disorders. So, but no, I would say the opposition is both, but certainly the age restriction side.
The age restriction. Okay. I think, all right. And have you submitted your written testimony?
Yes, I believe my colleague Kyle Turk submitted written testimony on behalf of the Natural Products Association. But happy to, keep open lines of communication as, things advance, and willing to work with you and the rest of the committee to hopefully come to a reasonable solution.
Great. Okay. Thank you very much.
Thank you.
All right. Next is Tim Schneider.
Good afternoon, distinguished chairs and members of the General Law Committee. My name is Tim Schneider, and I am the former CEO and one of the founders of Earthlight Technologies. We are a solar and energy efficiency company in Ellington. And I come in support today of two bills, first starting with Senate Bill 105, reducing the fees for licensed people. As Representative Ackert said earlier, hopefully we can include the apprentices. We at Earthlight have a lot of apprentices and a lot of electricians, and anytime we can make it a little easier on them is a good thing. So we support SB 105. Coming out against SB 233, there's a section in there that will once again hurt the apprentices and electricians, where There's a section in the bill that will not let, or that will demand that electricians and apprentices go up on the roof to handle solar panels and to mount them to the roof. Normally we run a crew of 5, 2 roofers / carpenters, a ground laborer, and then we have an apprentice and electrician. We're mostly downstairs working on the meters, working in the basement, doing the electrical work. We have the roofers up on the roof, measuring, mounting attachments, and mounting the panels, which include plugging together panels, just a male and female plug. And that's all they do. This bill, as it's written, will make my roofers, do the measuring and the attachments, and then climb off the roof, and we'll have to have electrician and apprentice go up on the roof to mount the panels. And there's a shortage of apprentice electricians, and none of them really want to be, mounting panels to racking up on a roof. So that's the struggle we have with this bill. And that's about all I have.
Great, thank you. Let me see if there are any questions, Representative Acker, and then I'll have a few after that.
Thank you, Mr. Schneider. Great to see you as always. How many, if you don't mind me asking, how many employees do you have in state now?
I think we have about 135.
Thank you. Thank you for the work that you do. So they did make a change on this, and it was up to the 25 megawatt. They kind of changed that. Did you notice that in the list? How many systems are typically 25 megawatts and greater that we're doing in the state?
Well, we believe that's a misprint. We believe it should say 25 kW. 25 megawatts is huge utility scale.
That's what I was, that's where I'm at. That's what I'm thinking. So when I think of 25, if they change that to kilowatts, we're talking a different different story.
We're assuming that's a misprint and it's 25 kW they're talking about.
Okay. So if it was grid scale, 25 megawatts, what are your thoughts on that? If that is not a misprint, that's utility scale, right? Only, right?
I don't think we'll see any 25 megawatt in Connecticut.
Okay.
At this point,
Yeah.
We don't have the huge, the utility scale you see out there is 5, maybe 10 megawatts,
Yeah.
So.
Okay, that's what I wanted your input on. As a professional, the numbers mean something. So again, thank you for your testimony, and thank you, Mr. Chairman.
Great, thank you. And yeah, it was a misprint. It wasn't intended to be 25 kilowatts. So at that size, are you primarily doing commercial or residential installations or both? And is there a size that would make sense or not?
No, so we're doing lots of residential and lots of commercial. Residential, like I just explained, you really don't want your apprentices up there just to attach panels and handle panels. Even on the commercial side, it's the same thing. You have attachments. You have a lot of times you have to carry cinder blocks up there to weight them down and doing all this stuff and handling panels, trucking panels across roofs. Sometimes it's a Walmart or warehouse or something, and it's just a lot of work. And if you have apprentices and electricians do it, it just doesn't make sense.
Yeah.
So
now, what about the other protections in the bill in terms of the sale of the solar systems? Are you?
Yeah, I am. I have people that are coming up after me. Sean Reel will be testifying on that. I'm not that familiar with that part of it. So
Okay, great. All right. Well, thank you very much for testifying.
You bet. Thank you.
Okay, next, Jeff Hinsky.
There I am. Yeah, thanks for this opportunity. Thank you, Chairs Maroney and Lamar, and all of the members of the committee. I am Jeff Hinsky. I'm Vice President of Policy at Green Skies Clean Energy. We are a commercial and industrial scale solar developer headquartered in North Haven. We have about 120 employees, probably most of them are Connecticut, probably just under 100 are Connecticut based. We operate over 150 solar projects in the state. That represents more than 100 megawatts of capacity. These were installed over the last 15 years and represent an investment of over $250 million in the state. Well, we generally support the consumer protection provisions in, I'm speaking in general opposition to SB 233. We generally support the consumer protection provisions of the bill. We don't directly get involved with residential or direct sales. We only do commercial systems, so those don't have a direct impact, so I won't be commenting too much on those. The language in section 1, specifically lines 76 through 81, that would require licensed electricians to perform the actual physical installation of solar panels, basically goes against current industry practices and what is currently and safely being done in the field. As you know, you probably can imagine, the installation of these projects, whether they're rooftops or ground mount systems, or more recently, we've been doing a fair number of parking canopies. Laborers and in some cases licensed general engineers or site engineers will actually do the physical installation of the racking, and that includes physically attaching the panels. Once the panels are mounted, the licensed electricians come through and perform all of the wiring and electrical connections, even connecting the panels, what they call stringing, connecting them all together in kind of a daisy chain. This is a safe and well-established process. In the 15 years that we've been installing systems, we've installed more than 250,000 solar panels in Connecticut, and we don't have any known significant safety issues or ongoing operational issues with these systems when they've been installed under this manner. Requiring the electricians to actually take over these non-electrical duties likely will create bottlenecks, increase costs, and delay projects, and will add to the shortage of electricians that already exist because they'll have to take on more responsibilities and just take them away from the more important electrical responsibilities. Well, we don't have an exact measure of the impact. We are estimating it would probably increase the cost of our projects from 2 to 5%, so not a huge single impact, but individually, it matters. We currently have over 50 megawatts of awarded projects in the SCEF and NRES programs, representing more than 100 million in investment. And some of that investment would be put at risk, even with that 2 to 5% cost increase. So I would also just add, this also eliminates an entry-level pathway for many people in the solar workforce. Many installers or electricians and electrician apprentices got their start as installers, and this would eliminate that role. So we respectfully urge you to strike lines 76 through 81 of section 1.
Great. Thank you for your testimony. Are there any questions? I guess my only another question is, are there other forces right now that are making it more difficult for installing solar in terms of expirations of
Yeah, well, there's big headwinds in in the bigger picture. Obviously, the federal outlook has changed significantly. The looming reduction or elimination of federal tax credits is a big impact in terms of overall cost. I did mention there are labor shortages in Connecticut and elsewhere in the country, particularly for things like electricians. Or people like electricians, excuse me. And then tariffs. We've had actual hardware costs, just simple things like aluminum structures or steel structures that the panels mount to. We've had cost increases of 25 to 35% on a lot of those kind of projects. And so, there's lots of headwinds. This would just be another one, the not gale force by itself, but adding to, what's already looming. So.
Okay, great. Thank you very much.
And I did submit written testimony as well.
Okay, fantastic. Thank you.
Thank you.
All right, next, Andrew Simonow.
Andrew has not been accepting the invite to be a panelist, so I think we have to move on to number 30, Kyle Wallace.
Okay. Oh, Andrew has raised his hand. Andrew, if you could accept the invitation to become a panelist, we'll move on to Kyle Wallace now and come back to you. Is Kyle?
Yep, I'm here.
Okay, thanks, Kyle.
Looking forward to doing this so I can get out and shovel like everyone else. Thank you, Chairman Lamar and Maroney, ranking members Rutigliano and Ciccarella, and all the members of the General Law Committee. I'm the Senior Director of Policy at Sunrun, a residential solar and energy storage provider, and I'm testifying in support of SB 233, specifically the consumer protection provisions. On the licensing side, I echo some of the concerns elsewhere, and I would just make the high-level point that at a time when energy affordability is top of mind for everyone across the state, making changes that would further increase costs that ultimately flow through into our utility rates is probably not maybe the wisest idea, unless it's absolutely necessary. We've filed some pretty comprehensive written testimony on our recommendations, so I'll just touch a few topics here that I wanted to highlight. The first is that we would ask that the definition of residential solar photovoltaic system cover systems up to 25 kilowatts to align with the state's residential solar program threshold. We understand that the reference goes to a solar permitting that was previously at 12 kilowatts. We would also ask that the definition explicitly include energy storage or batteries. We think this will help future-proof the definition as batteries become more common across the state. You will have companies that will go back to existing solar customers to sell batteries or batteries with new solar systems. So I think either way, it's good to ensure that those protections extend to those purchases as well. The second piece I wanted to touch on was in Section 3, the handbook that's developed by OCC with PURA and DCP participating as well. We support that requirement. We would recommend that it be a requirement to be provided to all consumers for all solar sales, not just in-person sales. That can be provided electronically if it's done, virtually or through some other means that's not in person. The bill last year had both a brochure and a handbook element, and we do think that there's some validity to that approach. We are a little bit concerned of just when it says a handbook, like, is that a 30-page guide? Is it a 5-page guide? I think that the size of that matters in terms of actually physically providing it to consumers and making sure that it's useful at the time of the sale. If it's too long, that may be challenging to actually deliver and for customers to actually process. Whereas with like a brochure, you can get the key information there and then have links to the more comprehensive guide that is available for the consumer to refer to. Also in Section 3, the restrictions on soliciting hours, we generally support having set hours, particularly where they don't or where there's also municipal ordinances in play. We would just ask that the 7 p.m. be changed to 8 p.m. We think that given this is kind of a backstop for where municipal restrictions aren't more restrictive, this shouldn't be like more restrictive because it does only apply to solar, not all door to door. So even if you say solar sales stop at 7, you could also have pest control, windows, everything else after 7. And if that's not palatable, maybe at least having it open to 8 during the summer when there's more daylight. I'll end real quick on the DCP annual report. Just wanted to highlight that we support that requirement, but we're a little concerned that the current language may require us to provide the individual names of each employee that works at a related company that we do business with, and we just want to ensure that we wouldn't have to do that. That obviously provides some practical challenges. So appreciate the time and happy to answer any questions.
Okay, great. Kyle, thank you very much. I will look over the written testimony and then I will be back in touch with you as we work on this legislation going forward. But thank you for coming to testify today.
Appreciate it. Thank you.
Okay. Madam Clerk, is Andrew available now?
Looks like he's here with us. There he is.
Okay.
Hey, how are you?
All right, Andrew, it's your turn.
Thank you for the directions. All right, so Chairman Maroney and Lamar, ranking members Ciccarella and Rutigliano, and the esteemed members of the General Law Committee. My name is Andrew Simino. I'm the president of Crisp Cannabis. We are a micro cultivator, and it has taken us about 2 years to establish and open our business here in Connecticut. I want to thank you for the opportunity to speak today in support of critical reforms that can strengthen Connecticut's legal cannabis market which will in fact aid us in extinguishing the illegal legacy market, which operates without controls, exposing us all here in CT to harmful, untested substances. As we navigate the complexities of this new industry, it's essential to acknowledge the challenges we're facing and the opportunities that lie ahead. Those of us licensed cannabis businesses here in Connecticut are a mix of startup companies. Most of us are family-oriented, hardworking people and are doing this for far greater reasons than to make a buck. We stand for the medicinal attributes of the plant, which are known to be more positive on your body than the alternatives. We stand for operating under good manufacturing practices and using science-based data to improve the quality and access of our products to all. I want to quickly touch base on the sad side of what has taken place in Connecticut. The high fees, the misconception of get-rich mentality has kept our prices at an all-time high in the country. This has caused licensed operators with a lot of time and a lot of money invested to close here in Connecticut. Adversely, this has caused the illegal legacy markets to thrive and puts us all in danger of losing a grip on the incredible legal and licensed market we worked so hard to build over the years. So I've two broad points. The current supply chain for medical and adult use cannabis products from legal licensed cultivators has caught up at this point. We do not have an undersupply issue as we had some of the original legislature was written and adopted. Second is the economics of cannabis in Connecticut can be equally important to all residents, whether our residents are for or against the substance. Each of us has the opportunity to grow the legal industry to better our state's economy and preserve the safety of our neighbors and families. On a financial aspect, whether you see the returns in improvements made in your town by the 3% tax collected from hosting a retail establishment, or possibly by the millions of revenue the state received from the sales taxes, which keep our mill rates reasonable, our roads plowed, and our kids receiving the best education possible. So regarding the bill specifics, first, I would like to discuss marketing and branding. I'm going to run out of time. That's all right. I'll submit the written.
Okay, yeah. If you submit the written, that would be fantastic. What is the most important point you have left that you want?
I'd say branding and marketing, just being able to clearly market a product so the consumers can understand what they're buying. That would be very helpful.
No, excuse me. Okay, and so I would just let you know that we do have a committee bill that will be coming. Likely the hearing hasn't been set, but it'll be next week. So you may have see some things in that bill that you would like, and we'd ask you to testify to that. Representative Ritigliano.
Thank you, Mr. Chairman. I just have a quick question. I just want to ask a question about the branding thing again. I'm confused by the topic. There was an offer last year of sort of a blockbuster model where you're allowed to brand and have whatever colorful packaging you want in the store, but when the product leaves the store, it's in the plain packaging that DCP wants, and it was rejected. I don't understand what having a colorful package for something you've already purchased helps the brand. You can enlighten me, that'd be great.
Yeah, so so I believe that the Connecticut's regulations force the cannabis brands to be generic and unrecognizably the package. And so this approach hampers brand identity and makes it difficult for consumers to identify safe and legal products.
Again, if they've already been in your store,
yeah,
and you can now have a big colorful brand in your store, then they know what they're buying, they've purchased it, and then when they bring it home, it's in the plain package. Do you think that's a reasonable compromise?
I'd have to wrap my head around that. Yeah, I'm not sure. Obviously, it definitely creates operational complexities, right, for us. I'm sure there's costs involved and all that. I mean, if someone's buying a product in the store, they know what they're buying, and I'm being, reasonable, not putting some Fruit Loops on it or something, what would be wrong with the person carrying that home if they bought it in my store?
Well, because if it looked like Fruit Loops, the theory is if it looks like Fruit Loops, it might be more attractive to somebody underage or a child or something like that. So in your store, like Blockbuster back in the day, you had a nice colorful cover sitting there and then a plain DVD behind it. So I thought it was a reasonable solution. I was just getting your perspective on it.
Yeah.
I appreciate your input and thank you.
It's a good point. I suppose we could do that today, essentially, because we can advertise within the store. So
right,
something we can operationally do today. I do, do things like that in the model. I think it's just a little bit, I guess, yeah. It's something to consider. I'll definitely think about that.
Well, I appreciate your consideration. Thank you.
Thank you, Representative Tigliano. Andrew, thank you very much for testifying. And as I said, keep an eye out for the bill for next week.
Okay, thank you.
You're welcome. Next, Savannah Kazavinsky.
Hi, hello, can you hear me?
Yes, we can. Please proceed.
Thank you. Thank you, distinguished members of the General Law Committee. My name is Dr. Savannah Kazavinsky. I currently live in West Hartford, and I'm an OBGYN who serves patients in both Farmington and Hartford. And thank you for the opportunity to testify in support of SB 227. This legislation would offer a critical layer of confidentiality and anonymity for providers of reproductive health care and gender-affirming healthcare services by allowing them to remove their individual names from prescription labels. So as I said, I'm currently residing in West Hartford, but before this, I was an OBGYN resident training in Rochester, New York. Right before I moved, my hospital in Rochester committed to allowing providers to prescribe mifepristone and misoprostol, the two medications used in medication abortions, without using a prescriber name, and prescriptions would be listed under our general practice name. In the shadow of the Dobbs decision, this change felt like a small victory in which passionate providers would feel empowered and safe to grant access to care for patients across state lines without fear of litigation. The amount of providers enthused about bolstering telehealth services for medication abortion jumped drastically, and more patients could access safe and effective care. As we know, Connecticut was the first state to pass a SHIELD law supporting SB 227 is a necessary step to strengthen the foundational groundwork that has already been laid. This will reaffirm Connecticut's commitment to protecting providers like me from out-of-state civil and criminal litigation for providing necessary and safe care. Telehealth abortions are safe and effective, and studies show 98% of patients had successful abortions without the need for additional intervention. Using the telehealth format is very common in many types of practice, including mental health services, and brings care to patients who may not be able to easily access it. And that includes patients in hostile states or have barriers to travel. Connecticut providers are committed to providing reproductive health care to all, regardless of where they live or the barriers they may face, and SB 227 helps us do this. Again, I strongly encourage and urge the General Law Committee and CT General Assembly to support SB 227 by building on the progress Connecticut has made to shield patients and reproductive health care providers as this care is increasingly restricted and criminalized across the country. This legislation would further protect provider privacy and security. And again, I thank you for your time and consideration of this important bill.
Thank you very much, Dr. Kazavinsky. Are there any questions? Okay, hearing none. Thank you. Thank you for your advocacy and for taking the time to come testify to us today.
Thank you so much.
You're welcome. Okay, next, Sean Reel.
Oh, thank you very much. Yes, my name's Sean Reel. I'm the Director of Sales Operations with Earthlight Technologies. You heard Tim Schneider speak earlier about some of the pitfalls having to do with Section 1 as it relates to weakening the licensure exemptions that are currently in place to facilitate deployment of residential and commercial solar. I'd like to speak today about consumer protections, broadly speaking. We are supportive of efforts to increase consumer protections as it's spelled out in Section 3. In particular, we support the notion of a handbook to be created by the Office of Consumer Counsel. I believe that this would actually be a much better step than what we saw in an iteration of this bill last year that would have left it up to individual installers. By having it be created by the Office of Consumer Counsel, in conjunction with other related parties. This will create some standardization, accuracy in information, and just provide a better, consistent experience for any and all homeowners looking at going solar. To that end, I believe that this handbook should be made available to and an acknowledgement signed by all residential customers who go solar. We'd even be able to utilize existing processes in place. Residential solar customers already have to sign a disclosure form when they are participating in residential net metering. So we could incorporate that handbook or a link to that handbook within the customer disclosure form. I echo Kyle Wallace's concerns, whose written testimony is fantastic, by the way, to include battery storage in the consideration for the development of the handbook. Want to make sure that homeowners are fully aware, not just of what solar can do, but also what related technologies like battery storage can do. The other part that I want to speak to is just including a definition for in-person solicitation in lines 196 to 221. Right now, without a definition, we would be left with a definition of home solicitation sale, which really just refers to any sale-related activity that takes place outside of a company's brick and mortar location. I'd like to propose that in-person solicitation that would fall under rules for when door knocking can occur be more specifically applied to in-person solicitation as door knocking. We would support efforts to restrict door knocking to set periods of time, but want to leave it open for customers to schedule a time to meet with people, to meet with contractors at times that make sense for them outside of the 9 to 7 p.m. hours. Thank you very much for your consideration. Oh, I believe you are muted.
I muted myself. So, Sean, thank you very much for your testimony. I will reach out. I do appreciate the suggestions. If we could tie it into an existing disclosure form and then updating that definition. So I will review your written testimony and then I'll likely reach out in the next week or so. So thank you very much for coming to testify.
Thank you very much, Senator.
Okay, next, number 33, Betsy Guerra.
Thank you, Senator. Yes, my name is Betsy Guerra. I'm the Executive Director of the Connecticut Council of Small Towns. We represent about 115 municipalities throughout Connecticut. I'm here today to oppose Section 1 of House Bill 5226, an act concerning mobile manufactured homes and mobile manufactured home parks. As I'm sure you're all aware, the legislature adopted a sweeping housing reform bill last November in special session, and that included a provision that requires municipalities with a population of 15,000 to either create a fair rent commission, participate in a joint commission with contiguous municipalities, or join one that is established by the Regional Council of Government. We're concerned that this bill, as drafted, does require the Regional Councils of Government to form a fair rent commission if their membership includes a municipality that has a mobile manufactured home park in its town. And we're concerned, first of all, that it's premature. The requirement under 8002 does not require the municipality to participate in a fair rent commission until January 1, 2028. We're also concerned that my understanding is that not all of the COGs are looking to provide this function for their municipalities. I know there may be some, and I appreciate that Representative Martinez has already reached out to me to discuss, what they're looking to do, what they're hoping to do with this bill. Again, we just want to make sure that it doesn't impose any additional requirements on either the COGS or the municipalities at this time, because they're ramping up to meet the requirements of 8002, which is a very, again, comprehensive bill that is going to require them to ramp up staff, ramp up their activities in terms of developing housing needs assessments, engaging the towns in planning discussions, preparing regional and individual housing growth plans, looking at water and wastewater capacity issues, zoning regulations, et cetera. So it's a big effort. It's a big lift on the part of the COGS and municipalities. We just want to make sure that this, if they're looking to change the scope of the Fair Rent Commission or require COGS to do Fair Rent Commissions, that it does better dovetails with what's under 8002. So we're happy to engage in discussions about this, but again, we do have concerns with the bill as drafted. Thank you.
Thank you very much for testifying. So I guess I'll just ask a few questions. So, I mean, excellent point raised, right? That about the Fair Rent Commissions and the date. So would it make sense then for us to also push out would that make it easier if we push the date out to January 1 of 2028, or
but it should
to
at least
align
be
with?
Sorry, it should be consistent. But
Okay.
I would also encourage, and I know Representative Martinez has already had these discussions, but encourage you to reach out to the COGS to determine whether or not they're even planning on establishing a regional Fair Rent Commission. It is a little beyond their scope. It does, and as we add to the requirements of a Fair Rent Commission, they are becoming more quasi-judicial. I know that some towns that have had some for years are indicating that people are coming in with legal counsel on both sides, and the lay people that serve on the Fair Rent Commissions are becoming increasingly concerned that maybe they don't have the expertise. So those are all things we need to consider. But again, we're happy to be involved in the conversation.
Thank you. And I think we will be in touch with you as we go forward. So thank you
All
for
right.
coming to us to
Great.
testify today.
Thank you.
All right. Next, Liz Gustafson.
Hi, good afternoon.
Hi. Please
Hi,
proceed.
honorable chairs, ranking members, and esteemed members of the General Law Committee. My name is Liz Gustafson, and I am the Connecticut State Director for Reproductive Equity Now. Thank you so much for the opportunity to testify in support of SB 227. Reproductive Equity Now works in Connecticut and across New England to make equitable access to the full spectrum of reproductive health care a reality for all people. And whether it be the makeup of the Supreme Court, who holds power in the Oval Office, or targeted out-of-state legal threats and persecution, it's important to remind everyone that abortion and gender-affirming care providers remain resolute and committed to ensuring people receive the highest and quality standard of care. Thankfully, in 2022, our state saw what was coming and took action to pass the first in the nation SHIELD law to protect providers, patients, and helpers pre-Dobbs. And similar provisions have been enacted in 18 states and Washington, D.C. Now, 4 years later, we know how critical it is for our state to continue bolstering our existing SHIELD law and offer additional layers of protection for the safety and privacy of providers. SB 227 would allow medications prescribed for reproductive health care services to be labeled with the name of the prescribing or dispensing practice in place of the prescribing or dispensing healthcare provider. Access to abortion care is increasingly threatened by hostile states across the country, as out-of-state actors are eager to target and criminalize providers by utilizing any and every opportunity to do so. This legislation aims to protect providers who prescribe medication abortion from unwarranted and hostile out-of-state intrusions into medical decision-making and address a method that has allegedly been used by hostile actors to identify and target individual providers via prescription labels. And so whether a patient travels to Connecticut to seek legally protected care within our borders, or our state does act this year to bolster our existing SHIELD law to protect providers who are willing to provide care via telehealth, regardless of patient location, allowing providers to opt to include their practice name in place of their individual name on prescription labels is a practical step Connecticut can make and take to offer an additional layer of protection to our state's providers. SB 227 models similar legislation in states who have comprehensive shield laws, and providers are ready to answer the call and meet patients wherever they are, and we must answer the call to further protect them. SB 227 would further allow Connecticut to do everything in its power as a state government to mitigate risks to licensed providers in our state and shield them from hostile out-of-state government overreach. And Reproductive Equity Now respectfully urges the committee to pass SB 227. Thank you so much.
Thank you very much for your testimony. I see Rep. Luxembourg has his hand raised.
Thank you, Mr. Chairman, and thank you, Liz, for your thoughtful testimony and advocacy. I'm very, very interested in this policy, support the intent and goals of it, but I had a pragmatic question that is born from my own ignorance, and I'm hoping you can enlighten me, related to medical malpractice and whether there's any I'm thinking about I love the goal of the legislation to protect the providers of the care, but I'm wondering if you can educate me about if there are any risks related to removing the specific medical professional's name and having it just be practice. If you ran into a situation where there was a problem with the medication or something went wrong in the process of prescribing it and you had an issue, is there any impact on the recipient of the medication in terms of protecting that consumer? And then also, is there any risk in terms of like the medical malpractice insurance arena related to this? Those are just two areas I don't know a lot about. I think it'd be interesting for the committee to learn from you.
Definitely, and fair question. I'll answer it in two parts to also kind of give some context. So at least in terms of medication abortion, so federal law does not require a healthcare provider's name to be included on the label of non-controlled substance prescriptions, including prescriptions for medication abortion drugs, including mifepristone and misoprostol or other drugs related to that care. And then secondly, every prescription would still be tied to a provider's national provider identifier, so NPI. So in the scenario an individual provider does need to be reached, DCP would still be able to identify the prescribing provider if the NPI is needed.
So as I'm understanding your testimony, there concerns about medical malpractice or sort of any protections being lost to the end user, the person who's seeking the medication, really not relevant here. You don't see any concerns, and in other states that are considering this or have done this, they haven't experienced any concerns in that area.
No. Mostly this is the concept and intent is the concern about addressing a method that has been used to target individual providers and offer an additional layer of protection. But I think a fair question.
Yeah, no, thank you for the testimony. I'm absolutely going to support this legislation, and I appreciate your leading the effort on it. I think it's needed, and I'm grateful for your expertise. Thank you, Mr. Chairman.
Thank you very much. Representative Turco.
Thank you, Mr. Chairman. Hello, Liz. My question is regarding, I have two questions for you, but the first one, just reading the language, I'm unclear, so I wanted to see if you had some clarification. Will this cover both protecting the providers from name being on the box or pill case, as well as other materials that may be given? For example, I pick up a prescription at CVS. They, put it sometimes in a brown paper bag, they staple it, and there's this big white giant pamphlet that might have the provider's information on it, as well as inside the bag. Will it cover both of those the way it's written?
Yeah, so this will allow providers to opt to have the practice name and rather than their individual name on written or electronic prescriptions and the related prescription labels.
Okay, so that's good. They'll be completely protected there. And just in case anyone thinks that like this is, we're and being proactive is always a good thing, but that, we're doing this, that we're taking up this potential legislation for some hypothetical scenario. Can you give some examples of where providers throughout the nation have really been subject to another state going after them for prescribing prescriptions that are legal in the state that they're in?
Yes. So the first civil and criminal cases against an abortion provider post-Dobbs have highlighted the need for these kind of additional protections. So last year, Dr. Margaret Carpenter, a New York-based provider, faced an extradition request from the state of Louisiana after being indicted for allegedly sending abortion medication to a patient in Louisiana, and the medications used for it. Additionally, this followed Texas Attorney General Ken Paxton's civil lawsuit against Dr. Carpenter as well for allegedly sending pills to Texas. And so in both instances, Dr. Carpenter was allegedly identified via her name on the prescription label, and the New York Governor Hochul refused to honor the extradition request and relying on New York shield law similar to Connecticut's. Additionally, more recently, Dr. Remy Coita, an abortion provider in California, was the first physician sued under a new Texas law, which permits private citizens to sue anyone for providing abortion pills, and was indicted for allegedly mailing abortion pills to a patient in that state. And similarly, California Governor Gavin Newsom also rejected Louisiana's extradition attempt and relied on their state's shield law. So these attacks underscore the urgent need for shield laws that defend against this new era of criminalization that we are navigating.
Yeah, thank you so much, Liz, for that. I figure there were some examples, or you wouldn't be advocating so hard for this. So thank you for giving those. And that's really scary to hear about that happening, because here are providers that are, taking care of their patients, helping their patients, and in what's legal in the state that they are working and prescribing in. And they need to be protected for what they're doing. So I think you're supporting some really good legislation here. So thanks for bringing it to us.
Thank you, Rep. Turco.
All right, I don't see any other questions. Thanks, Liz. Thanks, Representative Turco, and thank you for asking the question to show that this isn't just a solution in search of a problem. It is a problem that we need to address. So, as always, thank you for your continued advocacy.
Thank you so much. Take care.
Next, Jason Teal.
Good afternoon, Senator, Representative, distinguished members of the General Law Committee. My name is Jason Teal. I am the CEO of Nova Farms, Connecticut, and I'm here today in opposition of the provisions within HB 231 that will require pharmacists to be readily available for every hour a hybrid dispensary is open. Let's be clear, I believe in medical cannabis, I believe in patients, I believe in safe access, education, responsible dispensing. What's hard is a mandate that lacks valid policy explanation, imposes extraordinary financial burden, and places social equity operators at a structural disadvantage. The Department of Consumer Protection's recommendation requiring a pharmacist to be available every hour of operation has no parallel anywhere else in the country. No other state requires a pharmacist to be physically present or continually available for the entirety of a medical cannabis retail hours operation. There has been no demonstrated patient safety crisis to justify this expansion. There is no data showing that how having a pharmacist would be insufficient for medical patients. What this mandate does is create a financial burden. I operate a hybrid dispensary. We have 2.5 full-time pharmacist salaries are more than the entire staff combined. Essentially, pharmacist payroll is being subsidized by adult rec sales. This structure flies in the face of what social equity was meant to accomplish. Social equity operators were not intended to carry disproportionate regulatory burdens that make our business financially unsustainable. We were meant to have a pathway to participate and compete fairly in a regulated market. Pharmacists don't study the endocannabinoid system in school. which is the science behind how cannabis is medically effective. And in many cases, the ones I've dealt with are not major consumers or are knowledgeable about strains. I'll give you a real world example. I had a customer come in one time with a question about product selection and usage. Our pharmacist was not able to give this customer product suggestions because she is not a consumer, and she had to pull one of our bud tenders into the conversation for help. Afterwards, that bud tender pulled me aside and was visually frustrated, and they were upset because they were asked to perform what was essentially a pharmacist's role while only earning $18 an hour, and the pharmacist that didn't know was getting $60 an hour. This is, it's not about an individual employee, it's about a system design. If a pharmacist is required to be on site at a significant cost, but in practice, patient interaction still falls to trained retail staff, then I must ask, what exactly is this mandate accomplishing? We are being to maintain pharmacy level staffing without being able to operate as a pharmacy. If the state of Connecticut insists on mandating full-time pharmacist availability as though we are pharmacists, then I respectfully suggest the legislature should allow us to become full-fledged pharmacies, able to dispense traditional medication and compete with entities like CVS and Walgreens. It's fundamentally inequitable to impose pharmacy-level cost structures without granting pharmacy-level opportunity. This mandate is not rooted in patient outcomes. It is not aligned with national best practices, and it imposes a burden that small and social equity operators are uniquely ill-equipped to absorb. I urge the committee to remove or amend the pharmacy availability requirement in HB 231. We can support patients, we can ensure safety, but we must also ensure that regulation is rational, evidence-based, and economic sustainable. Thank you for your time. I'm available for any questions if you have them.
Great. Thank you very much. And I think you've heard us say this before. We do have another bill coming up next week, so we expect to see you back next week with your thoughts on that bill. And I always appreciate hearing your thoughts. So I don't see any questions. So thank you for testifying today, and we will be in touch.
Sounds good. Thank you.
Okay, next, Wesley Jenks.
Hi, everyone. I'm sorry my snowmobile wasn't working, so I couldn't meet you in person today. So, distinguished members, my name's Wesley Jenks, and I'm the president of Expo Canna. And for the past 5 years, I've operated the Connecticut Cannabis Expo, Connecticut's largest trade show platform. I'm here to propose 3 common sense shifts to move our state from a prohibition model to a professional one. These 3 points, I look forward to collaborating and working together to find a logical, safe regulatory framework for the legal cannabis space in Connecticut. The first one being post-prohibition roadmap. When alcohol prohibition ended, the state created framework for thousands of venues to operate responsibly. Today, Connecticut has over 1,000 liquor stores and thousands of active permits. We have already blurred the lines by allowing package stores to sell THC-infused beverages alongside liquor. Yet we bar any designated areas for the responsible use of cannabis at professional and private events. By denying permits, the state hasn't stopped consumption. It is mandating rogue use in parking lots and sidewalks. We should use the exact same framework as the DCP's temporary liquor permit. We propose a dual gate model, age-gated, zones with trained staff and buffer zones that follow the Clean Air Act. If we can trust wine festivals to manage their areas, we can trust professional B2B events to do the same. The legacy bridge, number 2, testing over taxes. The gray market exists because the legal barrier of entry is a multi-million-dollar wall. We don't ask farm breweries for millions. We ask them to follow safety codes, and it is a $300 permit. I propose craft micro bridge permits that prioritize safety over fees. By offering low entry costs for craft microgrowers in exchange for mandatory state-certified lab testing, we turn unlicensed products into safe products. If we want to eliminate the rogue use at events, we must provide a legal door for new registrants to walk through. Let's lead with transparency and testing, not exclusion. Third, fiscal reality. Ending the revenue leak. Connecticut is currently leaving millions in tax revenue on the table. To fix this, I have some different proposals, one which would offer local municipal incentives, encouraging towns to opt in by giving them a higher percentage of the 3% local tax for any registrants in their jurisdiction. This turns state level fear into local level economic engine, providing new revenue to address debt. In conclusion, the infrastructure to regulate adult consumption and artisan production already exists in our liquor and agricultural statutes. Let's stop treating cannabis like a warehouse secret and start treating it like a professional taxed industry it already is. I also have literature I will pass along before next week for everyone to review my points more detail. I thank you for your time.
Well timed. You made it right to the warning there. And so if you could send your materials in with your written testimony, and then we'll make sure they're both included.
Absolutely.
So great. I don't see any questions, but as I've said before, we have another bill, the committee bill coming up, and so we hope and expect to see you back in
Yeah, absolutely.
next
I'll
week.
be there and I'll have some more information for everybody to take a look at.
Great. Thank you.
Thank you. Have a great day.
You as well. All right. Next, Ben Zacks.
Hi, everyone. Chairman Maroney and Lamar, ranking members Ciccarella, and my very close friend, Representative Rutigliano, as well as all of the members of the General Law Committee. I want to thank you all for taking the time to discuss today's bill. There's actually been quite a bit discussed on cannabis today. I'm going to stay focused on this bill and this bill only. A lot of it has been in regards to just sort of the program as a whole. But so I run Fine Fettle. We have 9 stores across the state, as well as a cultivation facility. We've invested now about $30 million, created tens of millions of dollars of tax revenue. We've got 200 employees in Connecticut. Last year in the bill, there were 2 main shifts to the operating of retail and hybrid dispensaries. One was the ability to convert from recreational to hybrid facilities to expand medical. And the other one changed from the in-person pharmacy requirement to remote pharmacy requirement. While my written testimony speaks about some other pieces of the bill, I'm going to stay focused on those 2 areas. So we are the first company, and I think the only company at this time, we took all 5 of what were our recreational only facilities, and we converted all of them to hybrid. So now Fine Fettle stores give medical access to patients across our 9 locations. And I see DCP's intent in this bill, trying to codify some of the issues or lack of clarity with last year's bill in regards to remote verification as well as dispensary technicians. But I ultimately have a problem with the way that it's being done. And so in this bill, it specifically points to using the policies and procedures, which are sort of an ongoing adjustment of rules and regulations rather than, a full list of rules, to codify how we must operate versus following the intent of the legislation from last year. The intent of the legislation had 2 main pieces. 1, to lower the costs, and 2, to increase the operational burdens. And the way that this bill specifically, by going to the policies and procedures, happens, it actually increases both. It shifts the burden of scheduling from pharmacists in person to dispensary techs in person, when there's really a question of the way that that should be implemented. It also increases the number of pharmacists that we may ultimately need by using an outdated version of dispensary technicians and pharmacist operations that we had before recreational cannabis starting on January 10th, 2023, and just shifts the people and the licensing to the techs and pharmacists now. And I think the problem with that is that it doesn't follow the legislative goals and intent from a bipartisan bill last year that both Representative Chairman Lamar as well as Ranking Member Rutigliano agreed with in trying to put this in. And so while we do think we need to fix and codify some of the difficulties and discrepancies, we think that this bill is the wrong way of doing it. And rather than asking questions, it makes assumptions. And with that, I hope we can move forward in cannabis in a way that's effective for both operators, consumers, and patients to lower the costs and lower the burden.
Great. Thank you very much, Ben. And I think you already mentioned you have submitted your written testimony already, and you know that we will see you back hopefully next week. With that, Rep. Luxembourg has a question.
Yeah, thank you, Mr. Chairman, and thank you, Ben, for being a responsible operator in Manchester, where I represent.
Thank you.
I tried to get this a little bit from the commissioner's testimony, but want to give you the same opportunity. I've never gotten a complaint about somebody sort of walking in and getting the wrong information, getting bad information because a pharmacist wasn't there, or they could only talk to a tech or a pharmacist. I'm trying to get to the crux of the consumer protection that DCP is going at. And I tried to say, like, is DCP being flooded with complaints? I'm not getting any complaints. So I guess I'm trying to get your perspective on that balance between protecting consumers and raising the cost on providers, because maybe some providers aren't, presumably as a responsible provider as you are, but Ben, do you have thoughts on that? I mean, are you seeing complaints out there? I'm not hearing any. So
I think that's a great question. And so one thing that I'm proud of, both as running Fine Federal, but also in operating in the state, is that we actually have a good strict set of laws that I think the 72 open facilities, as well as the 10, some odd cultivators, follow. And I think we have very restrictive testing rules. We have very restrictive operational rules, but ultimately we think that's good for changing stigma, which is our first battle in the state. So I do want to note that we think these pieces and working with DCP is important. On the complaint side, the answer I would say is no. I haven't seen any complaints, and I'm a little confused about sort of where we're protecting at this point. And, prior to adult use, we only had technicians and pharmacists operating in our stores, and we still have a lot of those people who continue to operate. But as adult use changed, we brought on more employees. We brought on seed to sale tracking, which we actually never had prior to adult use in the state. It was all sort of self-reported through the pharmacists. We have weekly, daily inventory audits, and we have an in-the-moment seed to sale tracking system through BioTrack. And it's incredibly important that our patients receive the right product. And even today, whether it's remote or in person, a pharmacist is verifying that that product is correct and going to the patient. But not only does a pharmacist need to do that, all of our employees have to do that at every level, from you put in your order online, you walk in the door, it gets checked in the vault, it then gets checked again at the register. We show it to the patient or customer to know it's theirs. If it's a patient, we slap on their information on the label to confirm that all of that product is correct. The pharmacist is still checking that information to make sure that it works within their sort of drug interactions. And our staffs and employees are trained on HIPAA laws and honestly civil liberty laws as well, to make sure that their information isn't going anywhere outside of just the person who they're speaking to and otherwise. And that's part of our active and ongoing training, and it's part of the way that we need to operate to make sure that we stay in compliance. So if you walk into the first equity joint venture in the state, which was in Manchester, Connecticut, and you come into our store, if you're a patient, you would go into sort of one register. If you're just a customer, you would go into the other. But the same exact operations are done on, candidly, 99% the same products, because Connecticut only has a few products that only are for medical. And we would ensure that that product is the same no matter is what you ordered and was accurate. And you also could ask the questions to any one of our employees and get an answer on what the impact may be against your goals. And so that's consistent. And I think no matter who is walking in, at the end of the day, we're a customer service business with compliance accuracy necessary. And so I don't see sort of where the downside is in our current operations or in the operations in adding these extra restrictive layers, because we served over 200,000 people last year across our 9 stores, and now we're adding 10 to 20 to 30 medical patients in our new stores. And it's a consistent experience with consistent accuracy, because those are the rules and laws that we set our standard to, as well as the department setting us to. And, we think it's running and going well. We don't want to add the additional burden, especially where there's potential misunderstanding or disagreement in the rules.
Thank you. I'm all set, Mr. Chairman. Thanks for your testimony, Ben.
Thanks.
Great.
And
Thank you,
we're happy to
Representative.
represent Manchester and the fact that it was the first equity joint venture owned in the state. That's something we're super proud of. So thank you.
Great. All right. Thank you, Ben.
Cool.
All right. Next, Jad Abdul Noor.
Hi, how are you?
Hi. Good, thank you.
Dear honorable members of the Connecticut General Law Committee, thank you so much for having me today. My name is Jad Abdul-Noor, and I'm a sophomore at Yale University in New Haven, Connecticut, studying global affairs. Thank you so much for the opportunity to speak in strong support of Senate Bill 227. So, growing up in an increasingly digital world, I have personally witnessed how diet culture has impacted the youth mental health crisis, especially with the rise of social media. People often want quick fixes, but these solutions aren't always the best. And this can be especially the case for youth that are taking these weight loss and dietary supplements and over-the-counter diet pills with the misguided beliefs that they will change their physique. And sadly, these companies selling these products are frequently using deceptive claims to exploit these children's insecurities about their weight and their bodies. In a study from the CDC in 2015, researchers estimated that 23,000 people of all ages across the US are treated in emergency departments every year due to injuries that are associated with these dietary supplements. And specifically, one quarter of these injuries are due to weight loss supplements specifically. So banning the sale of these weight loss dietary supplements and over-the-counter diet pills to minors is crucial because we see the significant health risks that are associated with them as a result of both toxic ingredients and interactions with other medications. For example, there was a study that was published in the Journal of Adolescent Health, which found that dietary supplements for weight loss had almost 3 times the risk to young people of causing severe health problems compared with vitamins. And something that's even more troubling is that these predatory supplement companies are targeting youth with deceptive claims about safety and efficacy of these products, claiming that users can rapidly lose weight or attain a perfect body. So after observing my friends and peers struggle with body image and confidence, I've now become passionate about advocating to ban the sale of these weight loss dietary supplements and over-the-counter diet pills to minors. When I was in high school, one of my good friends had wanted to pursue a healthier lifestyle, and so she started going to the gym, eating more nutritious foods, and trying to make her and just feeling good. But unsatisfied with the results and also just influenced by social media, she unfortunately had turned to a diet pill in hopes of achieving a quote unquote perfect body, also being drawn in by the marketing of the product, which had promised her that she would be able to burn more calories quicker and lose more weight. And so after she told me about her use, I immediately informed her about the health risk and tried to urge her to stop using them. And she told me that she did not know of and didn't even think about any of the harmful side effects that could have potentially been there just because of how captivating the marketing was. And so she experienced many symptoms while using them, which was heartburn, dehydration, and nausea, as well as still post-use unhealthy weight control behaviors and body image issues. And sadly, this is a common story amongst numerous minors across the US. And so seeing these products readily available without restrictions is normalizing their youth and also downplaying their serious health risk, which further perpetuates deceptive claims and the sneaky marketing tactics that these manufacturers are making about these products. These products can adversely affect young bodies in a number of ways, including causing insomnia, contributing to depression, and straining the liver and kidneys, which could lead to further damage. And so by enacting this legislation, we take a proactive step towards fostering a healthier environment and positive self-image among youth. Being a college student, I'm exposed to the daily mental health toll these supplements cause, and so I ask you to please vote in favor of Senate Bill 227. Thank you for your time and listening to my concerns.
Great. Thank you very much for testifying before us today. I don't see any questions, so I guess I'm going to just start with the what caused you to take your time to register? I know you had a well-researched testimony. You did mention your friend, but what led you to want to advocate for this issue?
Yeah, so seeing number one is firsthand witnessing a friend from high school going through this due to these products, but then also seeing how big of an issue it is among youth, especially being further perpetuated by social media. I think it's very interesting to grow up having, even like since I think elementary school, having people have cell phones. And so people are able to have access to all of this technology and information just so easily accessible to them, which also is contributing to, I think, so many more social media is contributing to so many more mental health issues, especially in this specific field amongst these products. I think that body image and body confidence are very big topics among my generation now. And so I think it's very important to do something about it, and firsthand witnessing it in college and being able to have the opportunity to create a change is very important to me. And so that's how I became passionate about advocating for this.
Thank you very much. And hopefully we'll see you on other issues. But thank you for reaching out on this. And you've submitted your written testimony,
Yeah, I have submitted a written testimony as well.
Okay, fantastic. Thank you very much.
Thank you so much for your time and for your question. Have a great rest of your day.
You as well. And next, Raphael Rafi Podolsky.
Thank you very much, Mr. Chairman, for the opportunity to speak today. My name is Raphael Podolsky. I'm an attorney and policy advocate for the legal aid programs in Connecticut. Excuse me. I'm here in support of House Bill 5226, which deals with the rights of residents of mobile home parks. You know that most park residents own their home but rent the lot on which it sits. As a practical matter, the homes are not mobile, as you've heard, and Connecticut has long had special legislation to protect mobile home park residents. This bill has 6 sections, but I will use my limited time to focus on 2 of them, sections 4 and 1. Section 4 makes a critical change to the existing law that gives park residents the opportunity to organize and as a group to exercise the right of first refusal to buy the park by matching any sale of the park. All the New England states have similar laws, some for many years. Experience under the Connecticut statute, which was not adopted until 2023, has revealed that our statute does not adequately address what are called portfolio sales of mobile home parks. These are sales in which an entity owns multiple parks and sells them all in a single transaction. Again, you've talked about this already. As a practical matter, such a sale is impossible literally to match because the residents cannot buy multiple parks, nor would they want to. The purpose is to allow them to buy their own park. Maine, Massachusetts, and most recently New Jersey require the seller to identify a separate price for each park so that the residents of any individual park can match. Our statute, as written, does not mandate price separation, but it does require the seller to bargain this issue in good faith, and that was part of the compromise from 3 years ago. The initial use of the statute in Connecticut has raised serious doubts that a good faith duty is in fact workable. Section 4 addresses this issue. Section 1 of the bill makes sure that residents of all mobile home parks in Connecticut will have access to a fair rent commission. Connecticut law requires towns with population over 25,000 to have a commission, and 54 towns now have such commissions. House Bill 8002 extended that requirement to towns over 15,000. That, however, will still leave most small towns without a commission. Section 1 requires regional councils of government to create a fair rent commission for towns that do not have a fair rent commission. We support that requirement. However, we do ask the committee to consider some changes in the draft of the bill, particularly as it impacts towns that already have commissions. I've spelled those recommendations out in my written testimony. In general, we think that to the extent practical, the bill should retain the benefits of local fair rent decision-making regarding mobile home parks unless the park resident requests a different venue. We also think that the committee should consider including a provision requiring a mobile home park fair rent commission decision to apply to all residents in the park if a specific portion of the residents, perhaps 50%, jointly apply to the commission. Thank you very much for the opportunity to speak. I'd be pleased to answer any questions, and I hope the committee will reach out as it completes its work. Thank you.
Great. Thank you very much for your testimony. And so I guess, Rep. Luxembourg has his hand raised, so I'll let him ask a question.
Yeah, thank you, Mr. Chairman, and thank you, Rafi, for your testimony. You indicate that you have sort of concerns that the good faith provisions, which were heavily negotiated in the 2023 law, are not working. And so that leads me to believe that perhaps there are bad faith mobile park sales happening in large numbers. And yet the DCP data says there's only been 5 that have come up, 4 had the right to purchase, didn't exercise that right, and there was one portfolio sale. So can you give the committee a sense of why you think the existing good faith provisions aren't sufficient and where you see sort of a lot of bad faith actions occurring since we passed that law?
Yeah, let me try and give you an honest answer to that, because I owe you an apology. And it's very legitimate for you to bring this up, because we'd had a conversation where I thought there were more transactions than there were. And I don't have any reason to believe the DCP data is inadequate. My understanding is that of the 5 applications that have come in, 3 of them were really not, either the residents were not interested, or they weren't workable. I mean, residents cannot buy every park that comes up for lots of reasons. There may be all sorts of things wrong with the area. It may not be suitable at all. It would take somebody with much more funding than they could ever get to effectively buy the park. It's my understanding there have been 2 parks, not 1 park, 2 parks in which the residents made a very serious effort to buy the park. And in both, one was in Danbury and one was in Norwich. And in both of those cases, the seller found a way around the statute. One of those, one was not a portfolio sale, but the other was a portfolio sale. And the way around it was to take the good faith provision to mean all you have to do is say no, and you've been bargaining in good faith. So when the residents say, we need this separated, and you say, I'm sorry, but I'm not going to separate it, that takes care of the good faith issue. That is what made me think the statute that I thought was the compromise was not being seen as the compromise. Now, can you say, is this the only seller in the world who would have interpreted that way? And that's possible, because we have not had multiple experiences. But it struck me immediately that it's exactly what I would do if I were the park owner and I had a portfolio deal and I didn't want that deal to be risked in any way. Then I would just say no. What's the point of bargaining if I'm going to say no? Well, but the statute says the bargaining has to be in good faith, which means you have to open yourself to the possibility you might change your mind. And when I put all those things together, my conclusion was the defect was in the statute, that statute, using good faith as the test, was not going to generate good faith. Why did I think that? Because somebody actually used the statute for the first time, and immediately that was what happened. So I can't say, oh, there have been 10 applications in the state, and all 10 of them, somebody acted with good faith, because I don't know that. And I'm not going to tell you something I don't know. But I think it illustrated to me that a rational seller would, in fact, not honor a true meaning of good faith. And so maybe this isn't the only way you could change the statute, but that the statute has to be changed because 2 reasons. One is, in the long run, a lot of the sales are going to be portfolio sales. And 2, the portfolio sales are the very sales that the residents were most concerned about, because those are the sales most likely to be to investors, not quasi mom and pop owners of parks, but investors whose purpose is to buy something cheap.
No.
I'm sorry, is to buy something cheap and then sell it high and not really take care of the park. So there's my logic. That's where that came from.
Yeah, you sort of addressed my follow-up question a little bit, but I was going to ask if maybe, given that the portfolio sale exclusion was an integral part of the mosaic of the agreement in 2023, I was going to ask if you might be open to a solution which strengthened the good faith provision as opposed to taking away the portfolio exclusion, because that was integral to the mosaic of the 2023 law. But I think you sort of addressed that a little bit already, but maybe you want to opine further.
Well, I would just say I'm a big fan of people trying to work disagreements out. And I can't speak for mobile home park residents. I mean, they have their own alliance. You have a witness coming from the Mobile Homeowners Alliance. But I believe in conversation even on things where people are very far apart. And so something to me, yes. So to your question, my answer is yes. If something else solves the problem in a reasonable, workable way, then I think that might be the case. I don't know if such a way is possible. I mean, so that's an open question for me, because I don't know what it would take to get sellers who have a deal to realistically rethink the deal for the sake of their own residents rather than for the sake of themselves. But if a way can be found, I mean, maybe they're financial incentives. One of the things that was interesting, state of Maine recently passed, and within the last year has passed mobile home park legislation in this area. And one of the things they did was they included certain tax incentives to the seller to induce the seller to be more willing to sell. So one possibility might be to look at those, they're not in this bill, but to look at those as a way of combining with good faith, as a way of creating a situation where residents will not be routinely turned down in a portfolio sale. Because what happens is it's the nicest park, the ones where the residents are most interested, that is the very one that the seller wants to keep in the portfolio sale, because he sees it as making the whole deal work. But that is so to the disadvantage of the residents, who are going to end up with a new owner who's going to jack up their rents. And that's not fair.
Thank you, Mr. Chairman. Thank you, Rafi.
Thank you. Representative Martinez, see your hand is raised.
Yes, so there was some written testimony that was entered that did name you as part of being in the intensive negotiations and part of balanced compromise in 2023. Can you speak to a little bit more of that compromise?
Yeah, no, I think and it's sort of what I've said to Representative Luxembourg, that there was extensive negotiation. I mean, there was a significant difference in where the park owners were and where the park residents were. And this was an important issue in trying to work something out. And so I don't disagree with that. I think if there had been any reasonable feeling that good faith, that this was an anomaly, for example, that what happened is this one park was an anomaly, and that it was all going to work out fine in the end, that I think the reaction would have been different. But I mean, I think the reaction here was that it wasn't anticipated that was the way good faith was going to be handled. And there was no reason to believe anybody else was going to do it differently. Which is why I can say to Representative Luxembourg that if the problem could be solved in a different way, I, for one, would certainly think about that. So I don't think it's a false narrative that there was genuine negotiation. I think there was, and I think both sides gave a lot. For this, it was a huge concession on the part of the residents to not include portfolio sales, but it was a big concession on the part of the owners to agree to something in its place. And that was what was agreed to in its place. And I think maybe in hindsight, perhaps they had a better understanding than the residents had as to what the implications of that agreement were going to be.
And have you found in any of your research on this, have you found that other states requiring separate pricing have prevented park sales?
Well, that question was asked to a witness earlier who said, and she's has extensive experience with other states, and I think it seemed to be her opinion that was not proving to be adverse. I don't know of it being adverse. I mean, I suppose park owners may have their own experience about that. My sense is that when people want to sell, they can work something out, and pulling one park out, it is in the end, it's unlikely that it's going to make a difference. I can imagine a circumstance where it would. I mean, it's interesting to me that the prior witness testified to an instance where like there was a 3-park sale, and all 3 parks had residents who wanted to buy their parks, And so that was an easy solution. You just divide it up. But the much more typical case is going to be you have one, and that's what happened in Connecticut. You have multiple parks, only one has residents in it who really feel the desire that they want to own the property. And we know from the 3 parks that we have, and the history in other parks in other states, that owning the park often has a very real impact in the extent to which rents rise, because essentially you have a co-op or a quasi-co-op structure, and they're deciding that their board is making decisions. But because they're so vested in the park, and because they're owners, they're homeowners, they're not even just renters, they also carry a very substantial interest in maintaining the park. They don't want the park to decline because they live in it. And so that issue of saying how much can you hold the rent down and yet have enough cash flow coming in that we can maintain the park is something that in those parks that are resident owned, they tend to take pretty seriously, at least that's my sense.
Great, thank you very much. Representative Martinez, do you have any further questions?
All set, thanks.
All right, Rafi, thank you very much.
Hey,
Thanks
thank you
for
very
your
much.
advocacy on this and so many other issues. So
yeah, I mean, I do hope you'll include all of us as you work further on the bill. Thank you.
Yeah. And next, Esther Bateman.
Hi, good afternoon. Good afternoon, Chairman Maroney and Lamar and the distinguished members of the General Law Committee. So my name is Esther Bateman, and I appreciate the opportunity to testify today regarding House Bill 5222. I represent Service Corporation International, which operates funeral homes in 44 states, including 24 in Connecticut. We respectfully oppose the bill as currently drafted. While we understand and support the Department of Consumer Protection's goal of strengthening oversight of pre-need funeral contracts, we believe that the proposed changes will create significant operational challenges without meaningfully improving consumer protection and will make compliance impractical. So just to understand the process, when a consumer prearranges a funeral, they meet with the funeral director, they select merchandise and services. The contract can be completed on paper or electronically, and you can make payments either in a lump sum or in installments. The funeral homes are legally required to maintain detailed records, and they manage those records internally, or they work with a third-party administrator. Processing a pre-need contract involves multiple compliance steps. So you transmit the documents to the record keeper. In some cases, you mail it. You enter the contract into a system. You conduct quality review. You set up your payment plans, etc. Then the funeral homes have to send the funds that it has collected to an escrow agent, which is a financial institution that is going to hold those funds until the beneficiary's death. Under the current law, funeral homes have 15 days to process the contract and deposit the funds into escrow. This bill will reduce those timeframes dramatically. It will go from 15 to 3 days. It will also shorten the timeframe that the trustee has or the escrow agent has to send the notifications of deposits to the customers from 10 days to 5 days. Those deadlines are exceptionally restrictive and significantly shorter than any other states where 30 days is very common. We respectfully offer that compressing these timelines will not enhance consumer protection, and it will make compliance extremely difficult for both the funeral homes and the escrow agents. The funeral industry prides itself on high ethical and professional standards, and we share DCP's goals of protecting the consumer. We believe that alternative measures can be put in place that will be more effective in achieving the DCP's objectives, while still allowing the funeral homes to operate efficiently. These alternative measures could include consumer education, contractual representations, enhanced communications, and we welcome the opportunity to collaborate on proven solutions that we have seen in other states, such as reporting requirements, audits, inspections, or even the setting up of a consumer protection fund to provide for recourses in the case of fraud. So thank you, committee members, and thank you again for allowing me to testify. We look forward to working on a framework that will strengthen consumer protection while allowing the funeral industry to operate efficiently and under achievable timeframes.
Thank you very much for your testimony. And Did you mentioned what some of the other states have done that you'd be willing to share, such as the examples of reporting requirements and others. If you haven't included those in your written testimony, would you mind forwarding those along for
Absolutely.
us to consider?
Yes, we'll be happy to.
Great. Thank you very much. I don't see any other questions, so thank you for your testimony and for hanging in there. I'm waiting to testify.
Thank you.
Okay, next, Mike Trahan.
Senator, good afternoon, members of the committee. I'm Mike Trahan with the Connecticut Solar and Storage Association. Our members are residential solar contractors and commercial solar developers who have been operating the state for 10 years or more. Thank you for hearing comments earlier today from our members from Green Skies, Sunrun, and Earthlight, all of them in opposition to Section 1 in Senate Bill 233. I suspect that the language comes from proponents of language similar to this over the last 4 years and several times over the last 15 years. And the essence of it really is, does a individual, or is their task of installing a solar panel into metal racking on a rooftop or a ground mount system, and then connecting those panels together, is that work that should be done by a licensed worker? We're about to celebrate the 20-year anniversary of a license exemption that was approved by the legislature back in 2007. It created a special license exemption for individuals to do this kind of work. Since that license exemption was granted, 5 million solar panels have been installed in the state of Connecticut. The large majority of those have been installed by individuals who are license exempt under current state law. I'm happy to get into that more if you like. I know we've had this discussion multiple times in the past. There was also sections 2 and 3 in the bill. There are a number of consumer protection language changes that we've offered. They're in my written testimony and the comments from others who have spoken previously. I would just add that in the last couple of years, twice, there have been consumer protection task forces created in legislation. Our members have sought positions on that task force. They were vetted by the governor's office and legislative leaders who had appointments to those task forces. It didn't meet last year, and when reconstituted last year, it didn't meet last year either. We're very interested, Senator, meeting with you and other members of the committee. I appreciate the time that other members of the committee have spent with our contractors trying to come around to a language that we can all live with. So I'll leave it at that. If there's anything else in these two sections, I'm happy to get into that.
Okay, great. Thanks, Mike. I will review your suggestions for sections 2 and 3, and we will be in touch.
Very good. Thanks, Senator.
Okay, thank you. Have a good day.
See you.
Okay, next, Dave Delory.
Yes, thank you and good afternoon, co-chairs Maroney and Lamar, ranking members Ciccarello and Retigliano, and honorable members of the committee. My name is Dave Delory. I'm a resident of the 55 and over Cedar Springs Manufactured Home Park in Southington, an appointee of the DCP Mobile Manufactured Home Advisory Council, and as president of the Connecticut Manufactured Homeowners Alliance. I thank you for this opportunity to testify in support of HB 5226. While 5226 addresses multiple issues, I will focus on its two major provisions: expansion of fair rent commissions and elimination of the portfolio exemption from Public Act 23-125, the right of first refusal statute. To begin, I'd like to remind everyone that park residents have been petitioning the legislature for several years to enact measures to mitigate land rent increases as a means to keep manufactured housing affordable. Although these efforts have not borne fruit, residents continue to try by using the tools available. For example, as of today, there are over 200 active Fair Rent Commission complaints from Stonegate Manor in Wyndham, over 100 from Rivermead Point in East Hartford, 7 from the Little Shady Acres Park in Danbury, and over 100 from and I expect an additional 100 plus complaints to be filed in the near future from the Beechwood community in Killingworth. All these complaints have two common denominators. One, their municipality has a Fair Rent Commission. 2, the park is owned by a foreign corporation that is imposing spiraling rents that the frequently elderly, disabled, and veterans residents of the community struggle to afford. However, many mobile home parks in Connecticut are in municipalities that are below the population threshold where a Fair Rent Commission is required. Moreover, in towns like Beacon Falls and Plymouth, Local leaders have rejected residents' attempt to establish a fair rent commission, though state law allows them to do so. So I'm strongly in favor of the president to expand fair rent commissions to cover all manufactured home parks. Moving on to the portfolio exemption. In late 2024, residents of 6 parks in Eastern Connecticut received a purchase and sale agreement from the owner, acknowledging their right of first refusal and offering a separate price for each park. However, when the owner discovered that residents of one of the parks had organized to make an offer on that park, the local manager showed up uninvited to a resident's off-site meeting to inform them that the original contract had been voided and they had no legal right of first refusal because it was now a portfolio transaction. Residents then filed complaints to the Attorney General and tried unsuccessfully to obtain legal counsel that would take the case on contingency as a cut violation with the following results. And these are obtained from public records. Little Valley Mobile Home Park, Norwich, offered to residents at a price of $4,150,000, sold December 3rd, 25, $3,080,000. Lisbon Mobile Home Park, offered to residents for $4,092,000. Sold November 19th, 25, $1,855,000. Westview Terrace Manufactured Home Park, transferred 11/25/25 for no consideration. Price offered to residents, $1,764,000. Tunnel Hill Mobile Home Park, offered to residents, $1,872,000, sold 11/19/25 for $910,000. Ledgewood Heights Mobile Home Park, offered to residents, $1,690,000. This one makes a little sense. Sold 12/3/25 for $1,715,000. Tilting Rock Mobile Home Park, offered to residents at a price of $1,912,000. No sale of this park, which was part of the portfolio, has been recorded in municipal records as of today. Under this set of facts and circumstances, I urge you to vote House Bill 5226 out of committee for further consideration with all deliberate speed. I will be submitting written testimony, including background documentation of the figures I just quoted, and I'm happy to try to answer any questions you may have.
Okay, thank you very much. And thank you for submitting the written testimony and for all your advocacy. I've been seeing you coming up to the Capitol for several years now, I think. And Representative Martinez has a question for you.
You're muted.
Every time. When right now in section 2180, if a rent is going to be raised, something that makes manufactured mobile home law a little different is that lots that are similar would be raised. Do you believe that should be the standard moving forward when rent decisions are made? So if they're made at fair rent commissions, that there should be some uniformity in those decisions?
Yeah, yes. I mean, there's multiple fair rent commission complaints across the state, and I would like to think that the statute will make it so that if residents that have complaints of based on similar sets of facts, similar increases, that those decisions would be applied uniformly. Yes.
And then part of the bill addresses the amount of notice for a rent increase. Can you just explain why it's important to increase that amount of notice for manufactured mobile home communities?
You mean the notice for rent increases?
Yes.
Well, there was previous discussion today, and you heard some of our residents talk about how they struggle to handle what may seem like, on the face of it, are minor increases compared to some of the increases you see from apartment complex. I just want to remind everybody that we rent land. We rent a parcel of land that's generally around 5,000 square feet. That's it. Okay. On top of that, all of our residents are out either hiring somebody to shovel their snow today, shovel their walkways and driveways, shovel pathways to their propane tanks, because the propane companies will not deliver if there's 2 feet of snow on the ground. You either see, elderly people like myself out there doing it themselves, or they have to squeeze out some money from their budget to pay somebody to do it. And as another example, one of the service that was cut by the current owner, Sun Communities, that Jensen's family used to pay for, were heat tape inspections. Jensen's used to send somebody out for every house in the community. Just in my community, that's almost 200 homes. They used to come out and inspect your heat tape at the beginning of the heating season, so that your pipes wouldn't freeze. That service was immediately taken away when Sun took over, so that residents have either now had to rely on their own expertise to see if the heat tape was working, or had to pay somebody else to do it. And I can tell you that there were numerous freeze-ups that took place in the last 2 or 3 weeks when the cold weather happened. In part because the park owner sent out emails to everybody saying, "Don't let your pipes drip. Don't let your pipes drip," which is on the news. It's what that they were telling everybody to do. I'll let you figure out why they sent out that kind of email. Yes, I think that notice of rent increases, increasing the amount of notice, if nothing else, provides residents with more opportunity to figure out how they're going to pay the increase.
Do you think it's important, given that they're not as mobile as one may think? So in other words,
Well,
do you think
yes,
30
of course.
or
I mean,
45 days notice?
it's very difficult to find, a place to move a mobile home park if you can afford it. And everybody knows that the squeeze on rental properties out there. And so, yeah, of course.
I'll stop.
Okay, great. Thank you very much. Rep. Luxembourg has his hand raised.
Hi, Jeff.
Thank you, Mr. Chair, and good to see you, Dave. Wondering on the rent increase notification section of the bill, if you might be open to considering a compromise of a 60-day advance notification instead of 90. And the reason I want to ask you that is all of the housing authorities and affordable housing programs currently send out paperwork to folks that qualify for affordable housing, landlords and tenants, whether it be Section 8 or RAP or any of the various programs, where a 60-day notice of a rent increase is sort of required in that paperwork. And because there might be some overlap with those affordable housing programs and people that might be utilizing what you might call naturally occurring affordable housing in a mobile park, or they might actually have one of these programs, if there was some uniformity of a 60-day notice, it might be easier to implement for those programs to the degree there's some overlap there, while still giving residents of mobile parks 2 full months advance notice of a rent increase. So I wanted to kind of throw that at you and get your reaction to it.
Okay, so you and I and Rafi, the park owners, worked very hard 3 years ago to get the right of first refusal statute enacted. I hope you remember from that experience that although I am a zealous advocate for mobile home park residents, I am open to compromise. So it's not something that I want to. It's something I want to consider because other people think it's important. But I'm from the Rafi Podolsky school of thought. I'm open to listening to any kind of reasonable compromise that might be out there that would be satisfactory and help our residents.
Thank you, Mr. Chair, and thank you for your thoughtfulness, Dave.
Great. Thanks, Rep. Luxembourg. Thank you, Dave, for testifying, and I'm sure we'll be in touch with you as the bill works through the committee process.
Thank you. I will submit testimony with documentation of the information I provided earlier.
Great. Thank you. Okay. Next, Tanisha Senior. Did I get close?
Yeah, it's Tanisha
Okay.
Signer. Yeah.
Okay.
Thank you.
Yeah.
Good afternoon. I was double checking what time it was. Good afternoon, distinguished members of the General Law Committee. My name's Tanisha Signor. I'm the policy director at She Leads Justice. We're a statewide nonprofit that uses a justice and equity lens to advocate for under-resourced and marginalized women and girls in Connecticut. For over 50 years, we've been a leading advocate for policy solutions to enhance women's economic security and combat discrimination. Thank you for the opportunity to testify today on, in strong support of SB 227, an act concerning prescription drugs and over-the-counter diet pills and supplements. This legislation would offer a critical layer of confidentiality and anonymity for providers of reproductive healthcare and gender-affirming healthcare services by allowing them to remove their individual names from prescription labels. There is no denying that Connecticut considers itself a leader in reproductive and gender-affirming rights. In 2022, in anticipation of the falling of Roe v. Wade, we boldly passed the Reproductive Freedom Defense Act. This shield law was the first of its kind, and it worked to protect our state's providers from attacks from other hostile anti-abortion states. As we create protections for patients and providers, we must remember that today, systems of treatment evolve and grow quickly. We must create policies that keep up with the urgency of these moments. The need for these added protections is underlined by ongoing civil and criminal litigation by states like Texas and Louisiana, who are not only willing but eager to attack providers in Connecticut. We cannot allow these states to impose their outdated, scientifically baseless, dangerous policies outside of their own state's borders. Abortion care and healthcare for transgender people is necessary, life-saving, and deeply personal. We must protect access to this care in any and all ways possible. By adding the protections outlined in SB 227, Connecticut will bolster its first-of-the-kind shield law and reaffirm its promise of protection to medical providers and all our patients. We strongly urge the committee and the General Assembly to pass SB 227 by building on the progress Connecticut has made to shield patients in reproductive health care and gender-affirming providers. As this care is increasingly restricted and criminalized across the country, the legislation would further protect provider privacy and security. Thank you.
I was muted. Thank you very much for your testimony and for hanging in. I don't see any questions from the members of the committee, but have you submitted your written testimony?
I haven't submitted it yet, but I am going to tonight. Yeah.
Okay, great. Well, thank you very much.
Thank you.
Okay, next is Lou Rinaldi.
Good afternoon. Good afternoon, Senator Maroney, Representative Lamar, members of General Law. Thank you for this opportunity to speak on Raised Bill 231. My name is Lou Rinaldi, and I'd like to start with a comment for Representative Luxembourg. If you want to learn about what medical cannabis patients in Connecticut are thinking and feeling, we have the first in the nation Office of the Cannabis Ombudsman. I'm the originator of that Public Act 2379, Section 49, which created this office, working together with Leader Rojas. Our Ombudsman, Erin Gorman Kirk, just recently completed a survey of our registered patient population, and she has all the feedback that you're curious about. So you don't need to rely on DCP or industry operators who have their own inherent bias. Also, we heard from Andrew over at Crisp Cannabis earlier, and I thought it was kind of amusing to hear him whining about the illegal legacy market when his own company literally broke the law and was fined over $400,000 last month by our Attorney General. Curious there. But back to the bill. Sections 1 and 4, I have some concerns there. I think overall, like similar bills we've seen, the statutory language reveals some concerning loopholes that if this bill is passed in its current form, these provisions are going to risk degrading patient care, undermining market fairness, and prioritizing corporate convenience over consumer safety. Sections 1 and 4 about remediation and the 30-day time frame. We've seen in some of the written testimony already people complaining about the 30 days. I don't necessarily think that's the issue. I think the fact that we are allowing commissioners' discretion to grant extensions without any statutory limit on the length or the number of extensions, that's alarming to me. especially considering how we've seen commissioners' discretion abused up to this point, such as declaring cannabis treated with radiation to kill mold is not considered adulterated, which flies in the face of existing statute regarding consumer protection that's been on the books long before RRACA was conceived of and implemented. And, you know, last year around this time, we had testimony to this very committee from Dr. Tess Edom, who was talking about how remediation is essentially a cover-up for poor handling and growing practices, and that decontamination treatments like X-ray irradiation and ozone do not eliminate all contaminants or mold allergens or toxins or other potentially harmful microbial byproducts. And that even after these treatments, the contamination remains on the flower, even though these are known inhalation hazards. A couple other things I'll touch on super quick. Section 6, lottery bypass for retailers. It creates a mechanism where a standard adult use retailer can convert its license to a hybrid retailer license without applying through the state's lottery application system, which creates a regulatory backdoor. Retailers could secure a standard license and bypass the competitive capped lottery intended for medical hybrid facilities by simply filing a conversion application and passing a DCP inspection. Speaking of which, when is that second round of the licensing lottery? I think it was supposed to happen in 2022. And finally, Section 2, I think there's an issue with straw ownership in the vape shops. There's a cap on financial interest by an individual at 10%, but there's nothing in there that's going to stop bad actors from dividing their ownership stakes into smaller increments, like 3 associates owning 9% each to easily evade state scrutiny. So yeah, basically, I urge the committee to introduce amendments that place a hard statutory cap on contamination destruction extensions, eliminate that lottery bypass for hybrid conversions, and lower the ownership threshold for the background checks to prevent bad actors from hiding their financial interests. Thank you for your time and your continued commitment to protecting Connecticut's consumers and patients, and I'll take any questions that you may have at this time.
I keep forgetting that I mute myself while people are
It happens to
talking.
the best of us, Senator. It's all good. It's all good.
Thank you very much. Do you have an idea of what I think you raise an excellent point, right? That there should be a cap on the extensions. Do you have an idea on that? Should it be 2, no more than 1, or just a date, like extensions not to exceed 120 days?
I think the first and foremost, we should absolutely remove any language in statute about commissioner's discretion, because it's, you know, we've been burned enough times at this point that I don't think that can be trusted. As far as specific numbers there, I don't know, maybe we can take that up offline. I think there's a lot of nuance there, because when we talk about remediation, I think what most of the current operators in the state are thinking is they want to take a moldy batch that failed testing and then run it through the extraction process, which theoretically eliminates all the contaminants and allows them to make concentrates and whatnot. Problem is, concentrates are not even really viable or legal in Connecticut, except for the medical program, which is a customer base of 33,000 and shrinking rapidly. So if these cultivators are not producing for the medical market, but they're still seeking, you know, remediation extensions, that something's not adding up there. There's a little bit of nuance that I think might need to be teased out. And I don't know that we're necessarily going to do that within the scope of this conversation, but I'm happy to continue offline. As I said, if there's any questions about how to, you know, craft a subsequent draft of this and a revision, happy to help with that.
Great. Thank you very much.
All right. Thank you.
Okay. I don't see any further questions. So, and I think you've heard us say there's going to be a committee bill next week. And so just keep an eye out for that. And we expect to see you back.
Sounds good. Thank you, sir.
Great. Thank you. All right. Next is Jonathan Green.
Good afternoon, or rather, good evening, I think we can officially say. Chairs, ranking members, and distinguished members of the General Law Committee. My name is Jonathan Green. I'm a licensed funeral director and embalmer, and I serve as president and legislative chair of the Connecticut Funeral Directors Association. CFDA is one of the oldest and nationally recognized funeral service associations in the country, representing more than 220 member firms across Connecticut, from large cities to rural communities, and this includes both corporate and family-owned firms. Thank you for raising HB 5222. While CFDA strongly supports continued strengthening and enhancement of consumer protections, I respectfully offer testimony in opposition to sections 14, 15, and 16 as they relate to our pre-need funeral service contracts. The proposed reduction in the deposit notification timeframe from the existing 25 days to 10 days is not operationally practical and will not meaningfully prevent theft or misconduct. The deposit and notification process involves multiple steps beyond those you've already heard of today that are beyond the funeral director's control, including bank clearing procedures, escrow account establishment, and mail delivery. Bank clearing alone can take 2 to 7 business days, and in addition, recent postal processing changes may create additional compliance challenges despite good faith efforts. Shortening the time frame may also create unintended consequences for consumers. Funeral homes may be forced to require certified funds or cash to ensure compliance, which reduces accessibility, particularly for individuals who rely on personal checks or online banking, and may ultimately reduce transparency rather than improve it. The proposal also does not account for pre-need contracts that are funded through insurance. And these policies are issued according to timeline controlled by insurers and regulated by Connecticut's Department of Insurance. Funeral homes do not control the timing of policy issuance, and a 10-day requirement may be impossible to meet in those cases as well. Finally, allowing cancellation of irrevocable contracts, which are transferable from firm to firm, raises serious concerns, particularly in relation to Medicaid eligibility. These contracts are commonly used in Medicaid spend down and are relied upon by the Department of Social Services. Allowing cancellation without clear safeguards could create opportunities for fraud, abuse, and improper qualification for benefits. CFDA believes that the most effective consumer protections come through strong oversight, clear disclosure standards, and consumer education. When consumers understand the process and their rights, they're better equipped to recognize and report irregularities. We've included recommendations in our written testimony as supplement, and these will help support enhanced education and oversight. In closing, I respectfully urge that the committee reconsider these provisions. The current framework provides meaningful consumer protections while reflecting the operational realities of financial institutions, insurers, and the regulatory systems. CFDA remains committed to working collaboratively with the committee, Department of Consumer Protection, and state agencies to strengthen protections in practical and effective manners. Thank you, and I'm available for any questions you may have.
Great, thank you very much. And so in your written testimony, did you make, I mean, you mentioned on the allowing the cancellation of irrevocable contracts without safeguards. Again, you're opposed, not you're for that. I don't want it to seem I'm saying that. But do you, in your written testimony, include potential safeguards for that? Or, and I understand the issue, right, with the spend down and how they can be used for planning and other.
We don't have any specified safeguards. Really, our belief is that having both revocable and irrevocable contracts suit the needs of consumers. And truly, those irrevocable contracts are really needed for specific spend down to ensure that those funeral arrangements are covered for those who will not have the assets to do so. Otherwise, generally speaking, a revocable contract should be issued unless otherwise needed. Yes. And currently within statute, if someone wished to change the funeral home that they designate, they can certainly do so with those irrevocable contracts. They have that flexibility now.
Great. Okay. Thank you very much. I'll look to your written testimony, and then if we have further questions, we will reach out. But thank you for testifying today.
Thank you very much.
You're welcome. Okay, next, Robbie Bradshaw.
It looks like we don't have Robbie Bradshaw. We don't have Mark Minich. I'm butchering his name. I apologize. Mark Asnes is online, but needs to accept a panelist invite. So it looks like we're at Alvin Tran right now.
Okay. Alvin Tran, can you go? And then Mr. Asnes, can you accept the panelist invite? And then as soon as you we'll have you testify after Alvin Tran. Okay, Dr. Tran, please proceed.
Of course, great to see you, Senator Maroney. Good afternoon, everybody. Thank you to the members of the committee for having me today. My name is Alvin Tran, and I'm an associate professor of population health and leadership. And my research focuses on body image and the prevention of eating disorders. I'm here today in strong support of Senate Bill 227, and I want to start off by saying that our youth here in Connecticut should not be using diet pills or muscle building supplements to change their body shape or size, especially without their caregivers and parents knowing. The American Academy of Pediatrics has even issued strong cautions against teens using such products. And the question is why? Why? Because a number of research has documented health risks linked to the use of these products, and the health risks are significant. Young women who use diet pills are 6 times more likely to be diagnosed with an eating disorder within 1 to 3 years. And I don't want to forget talking about young men as well. Young men who use muscle building supplements are 8 times more likely to later initiate anabolic steroid use. These products have also been linked to serious organ damage, including liver failure and damages to reproductive organs. Importantly, many of these diet pills and muscle building supplements are not pre-screened by the U.S. Food and Drug Administration before sale. And that means our minors may be exposed to products containing banned drugs, steroids, toxic chemicals, or even heavy metals. Senate Bill 227 provides a simple prevention-oriented safeguard by restricting the sale of diet pills and muscle-building supplements to individuals under 18 years of age, whether in stores or on the online world. To be clear, it does not restrict informed adult choice. What it does is protects youth during a critical developmental period when lifelong health behaviors are formed. States have the clear authority to act, and that includes Connecticut, where I currently reside. New York has passed a similar law back in 2023. So therefore, I, as a Connecticut researcher and a resident, respectfully ask that each of you support Senate Bill 227 to prevent avoidable harm and protect the youth here in our state. Thank you for your time and consideration.
Great. Thank you very much for testifying. I do have a question. So you mentioned FDA does not require to be pre-screened before sale. Can you just elaborate on that,
Yes,
the process?
Thank you, Senator Maroney, for that question. It's something that I hope that everybody looks into who's on here today. It is a law passed in 1994, and the acronym is DHSEA or DSHEA, and it stands for Dietary Supplement Health Education Act. And when that was passed by Congress in 1994, it actually put the responsibility of ensuring that these products are safe and effective onto the manufacturers themselves. So that's why some states are considering taking action to making sure that youth don't have easy access to some of these diet pills and muscle building supplements.
Okay, great. Thank you
definitely
very much.
look into it. I think when it comes to body image, you saw some of the individuals who testified before me. It is something that we don't talk enough. I think we live in a day and age where body image is now an issue among young men, young women, girls, and boys, and it's a topic that we really need to take.
Young women are girls and boys.
Yes.
All right. If you're not speaking, if you could please mute yourself. Okay, and then I guess another question, is there, I guess one of the issues, we've heard, like for creatine, for instance, there are, discovering new uses, and is there an established list, science-based list of products that is regularly updated that we could reference for bans rather than putting things in the code? Again, or safe. I guess the contention would be there's no safe diet supplement for someone under the age of 18.
I think what the law would do is specifically target the products that are specifically being marketed as diet pills and muscle building supplements. And I think we can definitely refer to what the state of New York is doing for that particular list of products. There are some exceptions to the rule, but this would focus specifically on muscle building supplements and diet pills.
Okay,
And these are available widely in stores.
great. Okay,
Thank you.
thank you very much for testifying. All right. Madam Clerk, is Mr. Asnes available?
Looks like, yes, he's online there.
Okay, please proceed.
Awesome. Thank you, guys. Betsy, if you have to play me off with music, please do Sweet Caroline.
I wish
Yeah,
they had that choice.
We didn't do walk-on songs yet. I have requested it for
Yeah, if you
legislators
could-
when we come out, but
If there was request, that's my song. That's my
yeah,
thing.
okay.
I know it's been a long day. I've been with you guys for 5 hours as well. So I do thank everybody for the time it takes. I know what you guys do is a difficult task to hear everybody out. I thank you for the opportunity to submit testimony on House Bill 5226 on behalf of the Connecticut Manufactured Housing Association. If you're not aware, the CMHA represents the owners and operators of manufactured home communities here in the state of Connecticut, but we also only make up less than 1% of all housing in the state with approximately 10,000 homes. Generally, when I testify, I'm usually against the whole bill that was introduced. In this case, you may be surprised, but there are actually a few sections that I could support with reasonable modifications. So I'll start there. I do agree with a previous testimony by Betsy Guerra, who said, hey, we just passed housing legislation last year that reduced the population count for fair rent commissions and down to 15,000. Why don't we let that kind of take hold before we then introduce yet another? My compromise is if there is a need to have fair rent commissions where manufactured housing communities exist, as long as that the fair rent commission is balanced. So if they're asking for a resident to be on the commission or a resident advocate, that they mandate that either a park owner or a representative from CMHA is also on the commission to make sure that it's fair and balanced. But other than that, we don't have any issues with having more of them because, quite frankly, it would already fall into the 15,000 in almost 50 or 60% of the state anyway. Section 2 of the bill talks about fee disclosures. We have no issue with fee disclosures unless I'm not understanding the language. Quite frankly, the fees have to be in the lease for them to be enforceable. So if residents are being charged fees that they're not aware of, they should take whatever action that they need to because it's only enforced if it's in the lease. So it would be thrown out by any court. Section 3 talks about relocation expenses. We don't oppose the increase in relocation assistance in the rare case of a park closure. Just to be clear, in context, it's been decades, and there's only been, I believe, 2 closures in Connecticut. So if you want to increase that, no problem there. So we agree on those things as long as, like I said, we can come to some compromise on the language. Section 5 has to do with the DCP acknowledgement of complaints. Requiring them to acknowledge them is one thing, making them public is another. Complaints publicizing does not improve the resolution. Instead, it risks creating a public narrative that is later used to justify additional legislation. Complaints between a resident and a DCP representative must remain confidential. The vast majority are resolved directly between the resident and the community owner without any escalation. Section 6, 90 days of rent increases, 90 days before notice of rent increases. So this just isn't possible, and I'll tell you why. We don't even know most of our expenses before even the 30-day mark. So it just went from 30 to 45 days not that long ago, I think 2 years ago. Doubling it to 90 makes it almost impossible for a park owner to plan what his expenses are. Are you already playing me off? Holy shit. All right. Well,
please summarize here your remaining.
Yeah. So let me just summarize. Let me just get to the last part, which is the most important, which is the first right of refusal, which I see people had testified on previously today. 2.5 years ago, I was asked by Senator Moore and Representative Luxembourg if I would support the legislation of first right. Initially, we said no because, quite frankly, I don't think anyone should be told who to sell their park to. That being said, both Senator Moore and Representative Luxembourg said that they would be willing to mediate between myself, Rafi Podolsky, and Dave Delory and I believe Nora from the CDI was also involved somewhere. We went for weeks and weeks and negotiated it, and every single piece of that legislation was agreed to by all parties, and with my public support, it passed. Now, without any concern or issue with anything that's actually happened, they're looking to relitigate that particular section of the statute. And I just think that's quite unfair. It makes it look like that it was only passed with the hopes that they would get to change it later on. Anybody have any questions for me since I got the music?
No. Let me see it. Rep Martinez has her hand raised. Representative Martinez.
Sure. So looking at right of first refusal, if a separate price is not disclosed, how would residents know what amount they are required to match?
I'm sorry, if the fee is not disclosed on a sale,
Yes, correct.
it has to be disclosed on a sale because the notice of sale and the amount of the sale and the price terms and conditions are sent to the DCP when the park is put up for sale.
Sorry, I mean individually, right of first refusal in a portfolio. If the fee for one park is not disclosed, how would residents know what price to match?
But portfolios are excluded from the statute, so there is no notification of individual park prices. It's the only, it would only be disclosed. Well, I guess you could individually do it. I will tell you that the one portfolio sale that did happen, they did, for whatever reason, submit based upon the statute, each individual park price, even though they were not asked to or needed to per the statute.
So I guess what I'm asking is, the concern is that residents, especially portfolio sales, right, are obviously looking to buy their park, and currently they would only see the cost of the portfolio. So the question is, how would they, if that were in any way to move forward, how would they be able to do so? And I guess more the question is, have there been any examples that you can think of where residents were successful in buying a park in a portfolio sale without having the individual prices?
In Connecticut, no. So in Connecticut, since I sat on the advisory council per Governor Lamont's appointment, we had, I believe, six sales. Okay, 4 sales, the residents did not exercise their right. Okay, so 4 parks went up for sale individually with the price, and the residents never exercised their right. The 5th sale was the one in Danbury, which I believe that Rafi had spoken to. Now, they say there's something happened there, except the residents did exercise their right and then removed that once they found out that they needed to put $2 million in infrastructure repairs. So that's it. That's 5. And then the 6th one was a portfolio sale, which again, each of those park prices were given to the DCP, even though the park owner was not required to. There's a lot of logistic problems with portfolio sales, and that's what this is. That's why we have this language. So, for instance, I own multiple parks under the same LLC. Okay, so not every park is owned by a different company. So if you have multiple parks and you put them up for sale, and only one resident organization wants to buy Park A, and then they decline Park B, what happens to Park B? Do I close it? What does the bank do? Because the bank is cross-collateralizing the 2 parks together. That's how I got my loan. How do I pay off the loan? If it's broken up into parts, it doesn't work. And what if you have parks that are in multiple states? What if I'm selling my whole portfolio and somebody's going to buy them all, except they decide, oh, wait a minute, we don't want to buy the small parks. By the way, I own a park that only has 5 units in it. And they say, okay, well, what happens to that park? So all the residents, they exercise their right on all the large parks or all the attractive parks that the Rock USA wants. And then what's left is my park that has 5 sites, 13 sites, 22 sites. What am I supposed to do with those? Do I close them? No, but in a portfolio sale, you're mandating whoever's buying the portfolio that they buy them all and you keep them all running. And that's why the portfolio provision's in there. Does that make sense? I don't know if I was talking too much. I apologize.
No, it makes sense. It just, I think shows to a broader issue of resident rights. And I heard you speak right in the beginning about having it fair and balanced at the table, right, when decisions are being made. but owners operate with business, regularly work with towns on permits, budgets, inspections, and compliance. Well, a lot of the residents I'm speaking with, this could be their first interaction with manufactured mobile home law. Do you think by having them have an advocate that's well versed in the law at the table diminishes your point as an owners at the table for
No,
every
where would they
right?
sit? You mean sitting on the Fair Rent Commission?
Yes, correct.
Oh, no, not at no, not at all. I just want it to be balanced. I have no think about it. When the first right of refusal law came up, I didn't just say no. They said, "Can you please sit down at a table with Dave Delory and Rafi Podolsky?" Right? So the two people that were pushing for the law, I sat in a room at the legislative office building for weeks. We went back and forth, traded emails, Senator Moore, Representative Luxembourg, everybody was included, and we negotiated a fair deal that everybody signed off on. And nobody can say one thing that's happened that says that the law should change. Everybody keeps talking about the Danbury Park, but that wasn't a portfolio. That was an individual sale. And if something's wrong, go after them. We're not protecting people. So no, I don't care if at a Fair Rent Commission, Dave Delory wants to sit there or some. I don't care. I just wanted to have the Fair Rent Commission understand how mobile home parks work from my perspective, not just where the resident's perspective is. So no, I'm not afraid to have it as long as it's balanced, Representative Martinez, as long as it's balanced.
Could you see where it would be imbalanced now by having a resident versus a park owner that's dealing with mobile home law pretty regularly?
No, because they have the court system. They have fair rent commissions, the court system, legal aid. I mean, these things aren't new. They've had rights for years. And the reason that you don't see a lot of complaints is because there aren't a lot of complaints against mobile home park owners. What everyone's complaining about is that the world has changed and things are just more expensive everywhere. So rent increases, yeah, somebody may say, oh my God, 40%, I've been here 9 years. That's 4.4% a year. 4.4% a year. Do you know what that equates to in a mobile home park? $20, $25, right? So parks have been around in Connecticut since the 60s, yet the rents are still under $600. How does that work? That's like $11 a year for 50, 66 years. Nobody's taking advantage, but expenses are high. I don't control property taxes. I don't control insurance. I don't control refuse. I don't control water. Does everybody know that included in the rent is water and sewer? So my park in Killenly, where the rent's $540, it's $80 a month per home for water and sewer that I pay for. So theoretically, the rent's only $460, but all anybody talks about is the $540, right? So these are things I just want to get across to make sure that you understand, as well as any Fair Rent Commission understands, we're not gouging people. Our expenses are rising at a rate we've never seen in the history of our business.
Yeah, I do want to be clear though that rents everywhere are not under $600 and water's not always included.
No, no question. Yep, you're 100% right. I can't control bad actors. I will not defend bad actors. And quite frankly, a Fair Rent Commission in Wyndham, as you know, just rolled back a high mobile home park rent because it was so far above market. Then the Fair Rent Commission thing is working, right? The residents did have a place to go. They made their complaints and they were successful, right? And if I'm not mistaken, Ray Podolsky was the trainer of that Fair Rent Commission, right? But nobody asked me. I operate in the same town. They use my rent as the market rent, but not one person asked me anything about being a part of that commission to make sure that everything was understood. That's all I'm asking for, Representative.
Okay, just two more questions for you. Do you accept RAP or Section 8 subsidies?
We do. We don't have a lot of Section 8 in a mobile home park because, like I said, because the rents are so low comparatively. But yeah, absolutely. We don't have.
I was going to ask about the percentage.
We don't have a lot of Section 8 because I don't think you're allowed to own a home.
Right.
Yeah. So I don't. So we do have rentals. So the answer is we would accept Section 8 where we rent a home, not just a lot. But we just have very little of that. I would welcome it.
All right. So it would have to be a park that does rentals. Okay.
Right. Yeah. So I'm an oddity in Connecticut in the sense that I used to rent a lot of homes where we couldn't sell them. So like Norwich, Connecticut, which isn't always the best area for home sales, we at one time had 20 rentals in the community. And over time, we sold off some of them, but we had 20. A lot of guys never got into renting because it's like having an apartment where you're turning the home on a regular basis. which is a lot because it costs you about $5,000 every time you have to turn a home versus an apartment. What was your second question?
And then last question about right of first refusal. Did you find any language in the bill that would force a sale or prevent a park owner from completing a lawful transaction?
In the current statute or the proposed?
The proposed.
Yeah, well, yes, you want to exclude the portfolio part of it. So if you want to enhance the current law to tighten up fraud, which I don't like using that word because as far as I know, no fraud's been. But if you're looking to protect the individual sale to make sure that it's done properly, let me see the language and I'm happy to do it. I mean, we don't want fraud associated with our industry. It just doesn't work.
Right. So the question was, would it force a sale though? Would it force, by having individual pricing on individual parks, would that automatically mean that residents were able to buy the park and would?
No, not in a portfolio.
Correct.
No, you could, no, the answer is no, you couldn't force it. But if the guy buying the portfolio says, geez, I really, really don't want, one of your parks, you could surely at your wish offer it to the residents to see if they were interested. But you have to understand, if you have, let's say, 8 communities, you don't want to deal with 8 different resident organizations in 8 different timeframes. You have 8 different appraisals, 8 different purchase and sales. You're dealing with 8 different groups of people. Do you know how expensive that is and how cumbersome? The law already allows residents almost 6 months to close. If I had a portfolio and a balloon was due or my payoff was due in 2 months and I had to sell it to the residents and they had 6 months, what would I do if I didn't have the money to come up with for the portfolio, if I had to pay it off? It just doesn't work. It's too many parts, too much money involved to break it up.
Thank you. I'm all set.
Thank you, Representative Martinez.
Great. Thank you. Rep. Luxembourg.
Thank you, Mr. Chair, and thank you, Mark. I want to zero in again on the portfolio sale issue because it's complex. The reason that it was excluded in 2023 was related to a scenario which I fear could happen if we change the law now. And I want to kind of walk through a scenario like that. Let's imagine a seller in your industry owns 20 parks, and each of those parks is owned by LLCs with similar owners and different owners. So maybe across the 20 parks, you may have 500 people in Connecticut or 1,000 people in Connecticut owning different percentages of those 10 to 20 parks. And let's say somebody shows up and they want to buy all 20 cash for $50 million or $100 million. And those 1,000 Connecticut residents and those LLCs all invested in those, and they had contracts expecting a rate of return. They even had loans and maybe a pro forma with an exit strategy. And this was part of the exit strategy, a cash sale of the whole portfolio. And the buyer only wants it if they can get all of it.
Right, that's right.
But now the law has changed and the portfolio excluded, and one set of residents in one park comes forward to block the entire sale. If we remove this exclusion, could a small park out of 20 total parks block a multi-million-dollar sale like that, impacting all 20 parks and all the LLC members and all the owners and all the cross-collateralized lending for the entire portfolio?
Yeah, no, you said it, cross-collateralization. So I don't think people realize, for guys like me, and by the way, other than Sun Communities, which I know Representative Martinez has a lot of experience with, and honestly, I know from her perspective, they're not always doing what they should. I disagree with her on that I don't have any communities that have a pool or a clubhouse or a gym or any of the things that Sun offers. So let's just take me, because it's a real life example. So all of my communities are either under the same LLC, they're all cross-collateralized, meaning that I am on the hook for all of them You know, all of them, including, by the way, my personal house and any of my bank accounts. And that the bank could come after me for anything. So if one park is out of the loop, if one park fails or is sold outside of it, it reduces my covenants with the bank, which I am required to maintain at a certain level. If you start to break them up, I am in default of my covenants with the bank, and then I'm potentially in default with my partnership. Like you said, if you have people that are kind of outside investing in. But for us, I wouldn't be able to get the loans we get unless everything was cross-collateralized. So if you have 3 parks and they're all owned by the same LLC, and you feel, and one of them, the resident exercises their rights, I am in default with the bank because that third park is what's keeping the other 2 parks going. I can't separate one. I have to do something with it. What do you do when if you've broken it off? I don't know, but I'd have to get the bank I'd have to do another appraisal and make sure that it stands up by itself without the third park. And that just causes a lot of problems. That's why we put the portfolio provision in there, because I can't break up parks that are owned by the same LLC or, as you said, like ownership, right? So I own other parks where the partnership's the same people, but maybe at different levels, right? Different percentages, but it's the same ownership people. I can't break it off. We're all combined together as a guarantor on all of my loans. And there's nothing left in Connecticut, by the way, that's $100 million. Nothing. No, there's no group of parks, not mine, not anybody's. Sun's was the most expensive, but Sun's portfolio was over 5 states and 5,000 lots or something like that. There's nothing like that here. No, I don't have anything like that here.
One final question, Mr. Chair, which is related to how you would value or put a price on, and it's to follow up on Representative Martinez's question.
Yep.
I think I want to understand how you would value a park if you were required to value each one in a portfolio sale. And the reason I'm asking that question is I think there's a belief that real estate values are like apples, or like an item you buy in like a grocery store where the price is the price and the value is the value. But in a portfolio sale, isn't it possible that the value of each part of the portfolio could vary wildly, because it could be worth a lot more if it's part of a portfolio sale, or worth a lot less if it's just being sold individually, as opposed to this idea that each park is worth exactly what it's worth, regardless if it's in a package or sold individually. Can you educate us on that? It's kind of a complex thing to wrap our heads around. What is the value of a park?
Yeah. So the value of the park, obviously, this is no different than an apartment complex, right? So we're valued based upon our income and expenses. It's that simple. We're not on like a condo HOA fee, really. There's a lot of similarities between how we operate and how an HOA operates. So you're going to look at it individually, but I'm just going to tell you that actually, if you force a portfolio to break up, the individual parts become more expensive than they do as a whole. Okay, so and I think I explained this to Representative Martinez, if I have to deal with I have 8 communities here, and by the way, that sounds like a lot, but I have a park that's got 5 units, 13 units, 22, right? So they're not all these big communities. But if I'm selling it as a portfolio and I know that I have one purchase and sale, right? And on the back of the purchase and sale, there's an exhibit, and the exhibit lists all of the parks. And I'm only dealing with one company that does an appraisal, so I'm only supplying information to one appraiser. I'm only dealing with one bank, and I'm only dealing with one buyer. If there's economies of scale for me to do this. And actually, although the park price may or may not alter that much, the overall transaction, if I look at it, I'm going to be reduced. The whole portfolio will be reduced if it's sold as a whole, because of the amount of closing costs that it would not be associated with breaking it up. And so if you force me to break it up, those individual communities, without a doubt, become much more expensive. Because I could suffer from the fact that I got stuck with a 5-unit or a 12-unit park that I have no ability to carry anymore. So I'm going to have to build in that carry cost into the sale price of the ones that are selling. Does that make sense?
It does. Thank you, Mr. Chairman, for your indulgence, and thank you, Mark.
You're very welcome.
Great. All right. Thank you, Mark. I don't see any further questions. So thanks for your testimony.
Yeah, very welcome. Thanks, guys.
Okay. Next, Michael Myrovitz.
Right. Well, good evening, Chairman, members of the General Law Committee. Thank you for holding this hearing today. My name is Michael Myrovitz, and I work for the Council for Responsible Nutrition, or CRN. We're the leading trade association representing dietary supplement manufacturers and ingredient suppliers. While we do not have a position on other sections of Senate Bill 227, I am here to respectfully oppose the inclusion of Section 1, which, as others have discussed, would restrict the sale of certain dietary supplements to consumers under the age of 18. Currently based in Washington, D.C., however, I am a native New Englander. Was planning to come testify in person, but the weather had a different say on that one. That said, it's an honor to be here virtually on behalf of our member companies who manufacture and supply safe, federally regulated products used by millions of Americans. The dietary supplement industry is also an important part of Connecticut's economy, accounting for over $1.2 billion in total economic impact and nearly 2,500 direct jobs. As I mentioned, there's been quite a bit of discussion on this proposal, so I'll try to do my best to summarize. We also submitted written testimony, but first and foremost, it's important to know that we respect the intent of this proposal and recognize that eating disorders are a national crisis. They're serious, complex mental health conditions that require attention and resources. CRN strongly sympathize with anyone affected by these illnesses. Unfortunately, this provision incorrectly links muscle building and weight loss dietary supplements. I want to say again, dietary supplements, because I believe others have kind of used dietary supplements and diet pills interchangeably, but they are very, very different. As a organization that's really founded on science, we submitted a 2023 peer-reviewed study that examined the multiple risk factors for eating disorders, and which found no connection between supplement use and the onset of these conditions. Dietary supplements, again, as has been mentioned, are regulated by the U.S. Food and Drug Administration and are safe when used as directed. They're regulated as a category or a subcategory of food, which I think is important to note. Another study that we also submitted with our written comments, 2022 peer-reviewed study, looked at common ingredients in weight management and muscle building supplements, including some of those highlighted in this bill, and found that they are safe for consumers. FDA has the authority to remove illicit products off the market, and it's also important to note that if a product is marketed as a dietary supplement yet is adulterated or includes some kind of a drug, illicit material, or a steroid, by legal definition, it is not a dietary supplement, and FDA has the authority and the responsibility to remove it from the market. So instead of addressing legitimate health concerns, Section 1 would create unintended consequences for Connecticut consumers, the overall economy, and retailers. To comply, retailers would face multiple burdens, including determining which products are covered and training employees to age verify a very broad description of product, which again has been described by some other stakeholders who have testified today. It's very broad language, and this is all under the So I'm getting the music on. This is all under the threat of penalization, making it hard. And again, that's also impact consumers, making it harder for families and individuals to make informed health and wellness decisions. There's also a heavy enforcement burden on the state, requiring the inspections of hundreds, possibly thousands of retailers, a substantial cost to the taxpayer. I'll just summarize very quickly. We are committed to working with policymakers. I'm sure we'll have follow-up discussions to support public health. However, targeting safe, federally regulated dietary supplements is not an effective solution. We respectfully urge the committee to reconsider Section 1 of SB 227 and remove it from the bill. Thank you for the opportunity to testify, and apologize for going over a little bit.
Great. Thank you very much for testifying. I don't see any questions from the committee, but thank you for hanging in till almost the end. So,
absolutely.
All right.
And we'd really like to have some follow-up discussions with everybody. So again, really appreciate the opportunity.
And you've submitted written testimony, correct?
Yes, with those two studies.
Okay, thank you very much. Okay, next, Scott Modlin.
Hi, can you hear me?
Yeah, we can hear you. Please proceed.
All right. I was really actually looking to talk on Bill 5227, which was a bill I really didn't hear much talked about this afternoon. I guess Robbie from IICRC was not available. Um, I, there's a component of this bill that should be addressed, and that was part of. Well, first of all, let me thank you guys for having me, and I want to thank David Ritigliano for putting this all together. And originally, David and I came up with Bill 6657, which originally was a safety an act concerning emergency responders, and then it was rolled into 6965, and we were trying to get our actual bills together and not overlap. And I'm trying to figure out, maybe someone could give me a suggestion on how to get the language from 69, 65 into, or sort of make it part of 5227.
Yeah. So when you say that, the language I guess you're referring to is from last year, 69, 65?
Correct.
Okay. Yeah, and we will work and talk to Representative Ritigliano about that. I see Representative Lamar has his hand raised.
Yeah, thank you, Senator Maroney. Thank you for your testimony, Scott. We have had conversations with Representative Ritigliano. He's hoping to use a lot of the information and the expertise that you have and include that in this bill here. So we thought it was important for you to just present on sort of what your ideas were and like how we could incorporate it. Because I think he made a strong Representative Ritigliano made a strong point in our internal conversations about how this could be accomplished. He referenced the bills and the work that you two had done together. And we think there's an appropriate place here in this committee with this bill. So we wanted to just give you the opportunity to sort of like inform us a little bit more.
Sure, thank you very much. And what I would be looking for is to amend the original language. That was hold on, let me.
Maybe you might start with the issue, Scott.
Well, the issue originally was the original issue were individuals that were not licensed or actually having any type of credentials that were showing up on emergency or catastrophic situations that were particularly local or even in the city matters when it came to fire scenes and individuals that were property managers that had properties and you couldn't figure out who was who. You know, a lot of people show up on a fire scene, especially when you're in a small town. One of the problems that we had was, like we just stated, is we just don't know the people in the middle of the night who they are or who they work for. And in a day where identifications are a big deal, we were looking to add the language. And if you go back to 6965 and in the fire and catastrophic restoration business, the language is convoluted and it really doesn't belong with general law. It actually belongs with consumer affairs. And if
Hey,
they're the
Scott.
ones, yeah.
So I really appreciate it, and I know I didn't have the chair call on me, and I'm out of order, and I appreciate that respectfully. Sorry, Tim. Scott is so far down the road because he presented in front of public safety last year, and everybody knew the issue. I don't know if we on general law actually understand the issue. So I was just hoping that you could talk about the fire restoration services, the insurance claims, just why it's under DCP. You are in the Consumer Affairs Committee. So
Okay.
don't just have at it.
Okay. Well, I've also been, my apologies. I've been sitting here for 5 hours. So thank you, David, for dinner. Okay. Right now you have individuals like myself that are licensed by Department of Insurance of Connecticut. We are, as licensed public adjusters or any type of entity that is licensed by the Department of Insurance, we are allowed to solicit from 8 to 8 in the morning. But then you have the individuals that, You just don't know where they're coming from, and they're not licensed, and that show up on a fire scene. And those individuals are getting into it with the fire marshals. They're getting into it with other mitigation companies in the middle of the street. And ultimately, our neighborhoods, especially our smaller neighborhoods, we have volunteer firefighters and volunteer fire departments. They have their job is to knock down the fire and make and secure the property, and hopefully the homeowner gets off the safety, not to get into between who is going to sign the fire with the mitigation company on the street that's fighting with another mitigation company that's battling in the middle of the street, because ultimately we don't have sidewalks. And if you're in the middle of the street, or if you're on somebody's property, you're trespassing or you're blocking emergency services from really happening. There are a couple of solutions to this problem. One of them is it's not a 48-hour moratorium that's been floated around on responses to emergency service claims or anything like to do with fire restorations. But when it comes to insurance and insurance monies, it seems to be a hot topic these days. Everybody wants a piece of insurance money, and there really isn't too much sympathy out there for insurance companies. And right now, while the Northeast is going through another blizzard, it becomes obvious during fires. You have more fires when you have people trying to supplement energy, supplement heat. Bigger buildings end up on fires because they're not equipped to take on the electrical strain. That's a much bigger question on why is the strain so big? Why? Because the energy isn't new and we don't have anything replacing it, but that's a whole bigger issue. But we're here to talk about the safety of our fire and police officials that are out there responding to the scene. They don't know who I am unless I'm standing there wearing an identification. Everybody today wears an identification. If you go to the hospital, the nurse wears an ID. If you go onto if you get on an airplane, you have to show your ID. Let's talk about an airport. Just because someone's wearing a pilot's uniform, that does not mean that you let him on the plane. He still has to show you credentials. That doesn't mean you let him in the cockpit because he's dressed like a pilot and next thing you know, he's flying the plane. That's not the way it works. The people that are running at night don't have any identification. And that's why we've introduced, myself and IICRC, we came up with co-language together to strengthen this Consumer Protection Act. Basically what it is. It's not that it doesn't belong with the fire marshals. It belongs with you guys and not general law. And but there's language in there that almost allowed them. I see a hand up.
Yeah,
I see two
great.
hands up.
Let the chairman take the
Let's
committee.
go to Representative Ackert and then Representative Lamar. Representative Ackert.
I was
Yes, sir.
intrigued by Scott's information, so I will let him listen. So I understand the component, Scott. First and foremost, I use the public adjuster. I encourage it all the time. Sometimes we just don't know the way, and I do encourage people using public adjusters when they need them. So thank you for the work that you do.
Thank you.
But on the bill itself is what I'm looking at. And it looks like it creates another registration license certification to do the work, not about what you're speaking to the fire truck chasers, as I would call it, right? You say somebody's in the way doing that work, and I understand that piece. So I'm looking at two pieces here. I don't want if they are a certified company, one of our legislators sold his business recently. He was very, very active and involved in that type of work. Emergency services, right? You've got a fire, but if you can put a tarp over the roof that night before the rain comes, you can save a part of the house. So there's a balance here that we need to talk about in terms of how we get there. I do understand what you're saying, though. It's the people that show up and maybe cause a problem on the site, right? Essentially, or no?
Yes, that's what we're trying to do. We're trying to sort out who is avoiding coming out during the day. And if we're able to, we can't take the same incorporated language that's in the mold bill, because there is some overlapping and redundant language that needs to be tweaked. But when it comes to another license entity, I think that's why it falls under consumer affairs, because they're automatically there. And in that sense, it's just a matter of forming a specific registry, which is it's nothing further than purging some of your information onto a different spreadsheet that you already have on database and currently updating it to make it a stronger form. And then I think the registry should include an actual live, and I submitted something that I don't know if it was circulated or not. It was corrected language. Yeah, it was the corrected language on that bill. And because there are certain things that were in there, there's language in there that would have created a situation where mitigation or emergency services individuals became claims consultants. And that's against another law that's under Connecticut Insurance Department, which is the unlicensed practice of public adjusting. Ultimately, we're looking just to not police everybody, but if you take a badging system, not a badging system, an identification system, something enhancing what you guys already do at Consumer Affairs, and isolating, especially because it's a catastrophe. When you're going into someone's home and you're going into the middle of a fire, especially when people are in the middle of the street and they can't get their faculties and people want them to sign documents right then and there. Let's go. Trust me, trust me, trust me. You have no idea who I am.
Right.
Unless I possibly am wearing something that you could scan instantly. And in today's time, this is a no-brainer where you scan it and it comes up as it's a QR code. And if it's red, then I mean, I guess, that's up for the police in the neighborhood. But if it's green, then you can hang around the scene and go to the local bar, but or go to the local McDonald's or something, hang out over there in the parking lot. Don't hang out in front of people's houses. I think that the opportunity for the volunteer firefighters and the city firefighters need a separation. Like I said, not the word moratorium for people chasing fires or people contacting insureds. They tried this in Florida. Unfortunately, it was unconstitutional. So, I don't think it's a big thought process legislatively to try to challenge that. But it is okay to put a 2 hour, 2 hours, leave everybody alone for 2 hours. And let's get your bearings.
So I guess going back, I think we're a little different than language in the bill. I'd like to talk more with the committee about the language in the bill, because I did see supports, not supported on the bill in front of us. Your language seems like it would be a different component of that, and I'll let the chairs and ranking members have further discussion. I just think that what we're looking at here in the bill is a little different than you're speaking to, but I'd like to hear more about that. I'm sure that working with the ranking members and chairs on that, but yeah, we'll vet this out a little bit more. Thank you for your testimony, Mr. Chairman. Thank you for that.
Thanks, Rep. Ackert.
Thank you, sir.
And Representative Lamar.
Thank you again for the second time. I appreciate that. Scott, I think I've got it. Look, for the benefit of the committee, fire restoration, which is the business that you're speaking to and why we're here today, it does fall under our home improvement contractor language, which is in Chapter 400, which is under the Department of Consumer Protection, which is why we think it's more apt to be in this committee rather than public safety in the past. We wanted to make sure we had this robust conversation with you. It's going to continue moving forward. I think the underlying bill itself has merit that we'll want to discuss, and I'll continue to work with members of the committee. There's a lot of submitted written testimony on the underlying bill, but what you're speaking to also demands thought and attention. And I'll work with Senator Maroney, Representative Rutigliano, Senator Ciccarella, Representative Ackert, who's concerned about how this plays out, and we'll get to a good solution this year, Scott. So I just want to say thank you so much for your testimony today.
Thank you all. Thank you for having me.
All right, Representative Lamar, thank you. Thank you, Scott. And Representative Rutigliano will be in touch with you. So, all right, next, Bryn Austin.
Thank you. Good afternoon, honorable members of the committee. Thank you for the opportunity to speak in support of Senate Bill 227. I'm Dr. Bryn Austin, professor of pediatrics at Harvard Medical School. I'm here today to share research supporting this bill and to urge you to vote in favor of this important child protection legislation. The U.S. market for dietary supplements is enormous and steadily growing, with projections to exceed $66 billion in revenue. That's supplements in general. We've all seen these products in pharmacies, grocery stores, online, but what most people don't know is that supplements are not pre-screened for safety or effectiveness by the FDA before they enter market. Instead, manufacturers are expected to ensure their product's safety. However, some types of supplements, especially those sold for weight loss and muscle building, have been repeatedly shown to fall far short of these expectations. Rigorous scientific study after study has shown these types of supplements pose serious health risks to consumers. Many have been found to be laced with prescription drugs, banned substances, steroids, and other dangerous chemicals. Furthermore, studies have linked weight loss and muscle building supplements with stroke, testicular cancer, liver damage, and even death. The CDC estimates that 23,000 Americans are sent to emergency rooms every year due to supplements, and fully a quarter are due specifically to the weight loss category alone. In a study of the FDA's adverse events database, my research team found that youth using weight loss or muscle building supplements were 3 times more likely than those using ordinary vitamins to experience severe medical harm, including hospitalization, disability, and even death. Dietary supplements sold for weight loss and muscle building are not recommended by the American Academy of Pediatrics, which has issued 2 reports strongly cautioning against teens using these products for any reason. The fact that retailers across the state sell these types of dangerous supplements to youth, some as young as 12 years old, is unconscionable. How can we continue to let the manufacturers of these products and the retailers who profit from them, who you've been hearing from today, play Russian roulette with the children of Connecticut? This legislation offers a common sense solution to protect our children by prohibiting the sale of supplements specifically for weight loss and muscle building to minors, to people younger than 18, just as we've done with other risky products like tobacco. I urge you to vote in support of Senate Bill 227. Thank you for your leadership on this important child health issue, and I am very happy to answer any questions you may have.
Great. Thank you very much. I see that Representative Ackert has his hand raised.
Yeah, thank you. I'll be very quick, and thank you for your testimony. I've been listening to all the others talk about it. I know that when I was in high school, there was probably a product, weight gain or protein supplement or something I used to try to, I was super skinny then. I'm not anymore, unfortunately. But is that the type of product that we're looking to say that this can't be bought, like GNC, these companies that have these products that are out there for what they call health reasons?
Yes, that's exactly. If they're sold as dietary supplements, and not sold as food, but sold as dietary supplements, it's very easy to tell. You turn the box or the bottle around. If it says supplement facts on the label, it would be covered by this if it's being sold for weight loss or muscle building. I think you mentioned Hydroxycut earlier. I think it might have been you who mentioned that, or somebody mentioned Hydroxycut. Well, Hydroxycut was a killer, and it caused serious liver damage, requiring liver transplants. That particular product was pulled from the market and then put back on in different forms. What these companies will do, especially in the weight loss and muscle building category, is if they get caught, if they get fined millions of dollars, they take something off and just change the formulation, one little chemical element of it, or they'll put a slightly different name on it and go back on the market, if they even pull it at all. There are so many studies showing that mislabeling is an issue. I know that creatine has come up before. Sure, there's research on creatine in very tightly controlled scientific situations. That is not the kind of product that youth are buying. There have been many studies showing that what's on the label really tells you nothing about what's inside that bottle. There could be ingredients that are claimed to be in there that are not, including creatine, or there'll be ingredients that are not declared that aren't even approved for human use showing up, especially in the muscle building and the weight loss supplements.
Thank you for that. Just a quick follow-up. Is there, if somebody needs it for their health, can a doctor prescribe a legal supplement that would help them in whatever reason that we're talking about here, absent of them doing it from these? Is there a product that a doctor can prescribe if they went they needed more protein, something along that line, or dietary. Is there something that we can still help people that want to, whatever reason, is that available? It's simple, hopefully a simple question.
Absolutely. If a doctor knew someone needed more protein supplementation, they would give them a product that was known to be healthful, and it probably wouldn't be marketed as a dietary supplement. Or if someone was malnourished, they absolutely could get the treatment that they need.
That's what I wanted to make sure that we're not eliminating that. Thank you very much. Thank you, Mr. Chairman.
Great. Thank you very much, Representative Ackert. And Dr. Austin, you submitted testimony?
Yes, I have submitted
Okay.
written testimony.
Great. Fantastic. Thank you very much for hanging in there and for testifying to us today.
Thank you for the opportunity.
Next, Rebecca Connors.
You guys hear me?
Yes, we can hear you now.
Good afternoon, well, evening now, I guess. Thanks everyone for hanging in there, and especially during this crazy weather we're having today. My name is Rebecca Connors, and I'm a resident of a mobile home park in East Hartford, Connecticut, and I'm testifying today in support of House Bill 5226. This bill would allow residents to have access to rent commissions that would be knowledgeable in manufactured mobile home parks, further transparency on fees and payments due, and allow residents a real chance to buy their mobile home park if it is going up for sale. I moved into our mobile home community about 6 years ago, and many of my neighbors have been here for 20 or 30 years. Over my short time here, I've seen the cost of living go up through our yearly rent increases, while at the same time, the quality of the services we are provided has declined. When I first moved in, I saw this as an affordable housing option, but now living here is becoming less affordable each year. Some of the residents in the park are disabled, retired, or on Social Security. They are struggling to make ends meet and are facing the decision of possibly having to leave the place they have decided to call home. In addition, the services provided to us are not reflective of those price increases. Just recently, during the below freezing weather we had a few weeks ago, residents ran out of propane and they were unable to contact the office regarding this emergency, as it's a service that is provided by our park. After not receiving a response from our community manager, they ended up having to call the police. After calling the police, the East Hartford police officer was able to get the residents in contact with our community manager to get their propane filled. Our community management office is only open Monday through Friday, and there is no option provided to contact a person directly in the case of an emergency, just an answering service that will take your message. With the rising lot rents and additional monthly fees we are charged, instances like this should not be happening in our communities. While this is just one recent example, it is not the only instance of these type of issues occurring. Over my short time here, we have had issues with water line breaks, a propane explosion, and repeated communication issues. Many of my neighbors, me included, love living here for the people and sense of community. As I stated previously, many of my neighbors are older than me, and even with the age difference, I have been able to grow great relationships with them. However, with mounting issues, rising costs, and ineffective communication from our management company, the neighbors are becoming our only reason to stay. Additionally, mobile homes are not very mobile. They're very costly to move. The option of moving the home to a new community or a new lot is not realistic for many, which results in people selling their home when they do not renew their lot lease. Residents in these parks, neighbors like mine, and other neighbors in mobile home parks across the state deserve a better chance to stay in the homes they have created in the neighborhoods that they also love. Thank you to the committee for your time, and I'm happy to answer any questions you may have.
Great. Thank you very much for testifying to us today. Let me see. I don't see any hands raised. We appreciate you hanging in, and
of course,
I think as you've heard, a lot of questions have been asked before.
Yes.
So, but
Save
have
the
you
best for
submitted?
last.
Yeah. Yes, you're the closer. Well, almost the closer. So, on this bill, I believe you're the closer.
Yes.
So, have you submitted your written testimony?
I did. I submitted it just this afternoon. So I don't know if you guys had gotten a chance to see it, but I did submit it. And then if you guys have any other questions or want to reach out, I'm more than happy to speak with anybody.
Great. Fantastic. Thank you so much.
Yeah, thank you. Have a great night.
Thanks, you as well.
Thank you.
Okay. And next, Dr. Lisa Pereira.
Yes, hi, thanks. You said
Hi.
it correctly. I'm happy to bring it all home.
Thank you.
Good evening, Senator Maroney, Representative Lamar, and members of the General Law Committee. My name is Dr. Lisa Pereira, and I serve as the Medical Director for the Women's Centers, a group of independent clinics with locations in New Jersey, Pennsylvania, and here in Connecticut at our Hartford GYN Center. I'm here today in strong support of SB 227. Hartford GYN Center has provided full spectrum sexual and reproductive health care, including abortion, since 1978. At the Women's Centers, we primarily provide care in person at our clinics, and having those physical locations is essential. Telemedicine abortion is expanding, and we know it is safe and effective, but it is not a replacement for physical sites of care. It is a critical complement. There are moments when telehealth becomes essential, when patients cannot travel due to work, childcare, cost, or distance. And even today, as we are all participating in this hearing virtually during a historic blizzard. In these situations, telemedicine ensures continuity of care and access when patients would otherwise go without. But as access expands, so do the threats against providers. Since the Dobbs decision, we have seen hostile states attempt to investigate and prosecute doctors like me who are simply providing lawful care. The legal attacks against Dr. Margaret Carpenter in New York demonstrate that these threats are no longer theoretical, they are real, and they are designed to intimidate me and create a chilling effect across the medical community. SB 227 offers a practical and necessary layer of protection. By allowing prescription labels for reproductive and gender affirming care to list the names of the practice instead of my name, this bill adds an important measure of confidentiality. I am a doctor, not a lawyer. All I want to do is help my patients. Imagine that I am your daughter's doctor and she's in college at Tulane University. She has a mistimed pregnancy, and after conferring with her support system, decides to access medication abortion care from me. I know how to provide her with that care, and there are no medical reasons I shouldn't be able to. I know medication abortion is safe, effective, and legal in the state in which I practice. However, I do fear that her medication bottles could be found in her dorm room and turned over to the authorities. I do fear being criminalized and charged with a felony offense. I do fear that I could be arrested, jailed, and separated from my 2 children and be unable to provide for my family if that happens. Connecticut has been a national leader in protecting reproductive freedom and gender affirming care, and SB 227 builds on that leadership by strengthening my privacy to practice medicine and shielding me and all clinicians from criminalization at a time when it is urgently needed. On behalf of myself and Hartford GYN Center, I urge you to support SB 227. This bill sends a clear message that Connecticut will stand by me and all healthcare providers and ensure that patients can continue to access compassionate, lawful care without intimidation or interference. Thank you for your time and consideration. I have submitted my written testimony. Thank you for allowing me to go over by a little bit. And I'm happy to answer questions if there is brain space for them at this point.
Great. Actually, you perfectly timed it. You didn't go over at all. You just hit your time. We appreciate your testimony. We appreciate you staying in all day to deliver that testimony. I don't see any questions, but thank you for submitting the written testimony as well, which will allow us to reach out to you if we do have questions as we move through the process.
Please do. We're very happy to be a part of this process at the Hartford GYN Center.
Great. Thank you.
Thanks.
Okay, I believe that was our last person who had signed up to testify. And so Representative Ritigliano.
Mr. Chairman, before we adjourn, I wanted to tell you that I really enjoyed the questioning of from Representative Luxembourg and Martinez and the gentleman who owned the trailer park. I really did. I thought it was super informative. I thought it was great questions. I feel I am more informed now than I was even after last year's hearing. So I wanted to let you know that I appreciate it.
Great. Thank you, Representative Ritigliano. Senator Ciccarella, do you have any comments? Representative Lamar?
I think, look, we served our purpose here today. This is always difficult going fully remote, but it's an important tool that we've got to make sure that the business of the committee continues. And it's much better than making folks drive up to the Capitol and risk the roads and go. It serves the committee well. I'm glad we're able to do it in a thoughtful way, and I appreciate everyone sticking in all afternoon while watching the snow pile up outside. For anyone who hasn't gone out and shovel yet, I'm sorry. It's going to be brutal. Good luck.
As someone who hasn't gone out to shovel yet, thank you for that encouragement, Representative Lamar. I am hopeful that some good Samaritan removed the snow, but we will see what happens. But thank you, as you said, to all the committee members for sticking in, for all the people who testified. We do have a lot of work before the committee this year, and we would not really have been able to fit in all of these people if we had to reschedule. So thank you to Betsy and to the assistant clerks. With that, I believe the time and date of our next meeting, Madam Clerk?
We were still deciding. We're still waiting to see when some of our last bills are going to be filed.
Okay, so I believe though, for committee members, we're likely to have another public hearing next week. And then we will officially announce the time and date. I think as of this time, it appears likely that it'll be on next Wednesday, the 4th, and that we won't be having a hearing next Monday, the 2nd. And then we will let you know if there will be a committee meeting. So with that, I think we are adjourned, and thank you, everyone.
Thank you. Good luck, everyone.
Thank you. Good job, Betsy.